Welcome, sir. How are you?
Welcome. Good morning, everyone. I'm good. कैसे हो अशोक जी?
ठीक हूँ सर, बढ़िया हूँ.
That's good. अभी तो शायद टाइम लगता है ना?
I think it should have started by now. I just came back from the morning walk and then straight to the meeting to attend it. President and secretary are not yet there.
मेरे ख्याल से कुछ टाइम का ही इशू है. चलो थोड़ी देर बाद अब.
बस 1 मिनट में सतीश सर ज्वाइन हो रहे हैं सर.
ओके ओके. लेकिन अपने को अनम्यूट करेगा तो सुनाई नहीं देगा. पत्रिका वहाँ लाइव तो दिख रहा है. Good morning, Dr. Satish.
Dr. Sirohi, good morning. Dr. Alok.
नमस्कार सर. नमस्कार.
नमस्ते नमस्ते.
नमस्कार शाह साहब. आप अनम्यूट हैं इसलिए आवाज नहीं आ रही. थैंक यू सर.
Dr. Jaipuria, good morning. Dr. अनुराग भी अनम्यूट है.
म्यूटेड है.
म्यूटेड है.
Dr. अनुराग, good morning.
नीचे रख दो. कुत्ता क्या नहीं मिले तो पतीला नीचे रख दो. कुत्ता क्या
क्या
इतने डिस्टर्ब माइंड पे हो गए सर.
डॉक्टर आलोक.
यस सर.
क्या हाल केस की, क्या कुछ अपडेट है क्या अर्चना शर्मा वाला?
अभी वो तो शायद एब्सकॉन्ड ही कर रहे हैं.
अच्छा.
तो
कौन जो पॉलिटिशियन है दे आर एब्सकॉन्डिंग.
उसने बोला है कि स्टार्ट करो.
पुलिस वालों की क्या पोजीशन है?
पुलिस वाले तो वो इंक्वायरी कोर्ट मतलब वो एफआईआर जो है वो हियरिंग में ही होगी सर. अब
नहीं, वो 302 जो अप्लाई किया था,
हाँ,
उस पे कोई एक्शन है क्या?
नहीं.
गवर्नमेंट की तरफ से
नहीं।
कुछ नहीं?
गुड मॉर्निंग डॉक्टर जयपुरिया, आप थोड़ा अंधेरे में बैठे हैं सर, थोड़ा सा लाइट
ओके
चेहरे पे नहीं आ रही है।
ओके सर, गुड मॉर्निंग सर, गुड
हाँ,
मॉर्निंग,
आप ठीक है, नाउ इट्स गुड।
गुड मॉर्निंग,
गुड मॉर्निंग डॉक्टर जयपुरिया।
गुड मॉर्निंग सर।
मॉर्निंग डॉक्टर जयपुरिया।
क्या हाल चाल है गोंदिया के?
सर बढ़िया, एकदम
अच्छा,
एकदम बढ़िया। एक 100
डॉक्टर
बेडेड
जयपुरिया सबसे पहले ज्वाइन हो गए थे, आई वाज द सेकंड वन।
बेटा अभी 100 बेडेड हॉस्पिटल शुरू कर रहा है,
ओके। हाँ,
सुपर स्पेशलिटी।
गोंदिया में ही कर रहा है कि और कहीं कर रहा है?
गोंदिया, गोंदिया, ऑल डीएम एंड एमसीएच पीपल,
अरे वाह, बढ़िया।
ऑल स्पेशलिटीज, कार्डियोलॉजी, न्यूरोलॉजी, नेफ्रोलॉजी, ऑर्थोपेडिक सर्जन, ऐसा
बेटे
सब
ने
मिला
काय
के।
में किया है?
जी सर, यो एमसीएच यूरोलॉजी किया है सर।
एमसीएच यूरोलॉजी।
हाँ सर।
नाइस।
और बेस्ट
तो
विशेस सर।
आप भी वही हॉस्पिटल ज्वाइन रखेंगे नया?
नहीं सर, नहीं सर, मेरा तो पुराना चालू रहेगा। ओल्ड
अच्छा।
इज गोल्ड, ओल्ड इज गोल्ड।
आलोक सर, आपके आपके फोटोग्राफ सुबह सुबह में देख के दिन बहुत अच्छा जाता है।
क्या? ओके।
किसको? आलोक जी को बोल रहे हैं कि अनुराग जी को बोल
नहीं,
रहे हैं?
आलोक आलोक सर को बोल रहा हूँ।
अच्छा।
सुबह उनके जो पंछियों के
जी।
फोटो होते हैं कुछ
हाँ।
बहुत ही बढ़िया होते हैं, बहुत हाई क्लास।
थैंक यू सर। इनका इधर उधर की पोस्ट डालने से तो अच्छा है कि कुछ डिफरेंट ही डालें।
गौरी मैडम, गुड मॉर्निंग।
सर आप लोग कभी ना
गुड
इधर
मॉर्निंग सर, गुड मॉर्निंग एवरीवन।
काशीपुर आइए, ये कॉर्बेट के पास का इलाका है, हम बढ़िया घूमने का इंतजाम करेंगे। तिवारी जी तो आ चुके हैं, और लोगों से भी रिक्वेस्ट चाहिए सर।
श्योर श्योर। मैं ज्वाइन रहता हूँ, साथ में मेरा ओपीडी भी आज वर्किंग है, तो वो भी मैं थोड़ा सा देख लेता हूँ।
संडे को जयपुर में सब लोग रखते हैं कि आपकी रहती है?
सर म्यूटेड है आप।
मेरी छुट्टियां काफी हो जाती हैं सर, तो इसलिए जब भी जिस दिन भी मैं रहता हूँ उस दिन काम कर लेता हूँ।
अच्छा।
हमारे यहाँ तो सर अगर संडे को किसी को कुछ हो गया तो उसको डॉक्टर मिलना मुश्किल हो जाता है।
नहीं, रहते गांव में ही है कि बाहर चले जाते हैं सब घूमने?
मतलब फिर भी चूंकि ऑफ रखते हैं तो आम पब्लिक के लिए तो दिक्कत हो ही जाती है अगर संडे को कुछ होता है।
हाँ।
पर अब ये है कि अब कुछ बड़े हॉस्पिटल्स खुल गए हैं, तो वहां पे इमरजेंसी वगैरह मैनेज हो जाती है।
ओके।
पर यूजुअली प्रैक्टिस का ट्रेंड ये है कि संडे, मैं पिछले 35 इयर्स से हूँ यहाँ पे, संडे ऑफ रखते हैं लोग।
अच्छा। डॉक्टर मुखर्जी, गुड मॉर्निंग।
गुड मॉर्निंग सर।
आप कहाँ से हो?
सर मैं नागपुर में हूँ सर।
अच्छा।
गवर्नमेंट मेडिकल कॉलेज नागपुर में प्रोफेसर एंड हेड हूँ फॉरेंसिक मेडिसिन में।
फॉरेंसिक मेडिसिन।
अरे वेरी गुड सर, गुड
Very
मॉर्निंग
good.
सर।
गुड मॉर्निंग सर।
गुड मॉर्निंग।
Good morning, everybody. Hemant Gangolia here.
गुड मॉर्निंग
गुड
हेमंत।
मॉर्निंग डॉक्टर हेमंत। डॉक्टर अनुराग has not joined yet.
डॉक्टर अनुराग थे ना?
नहीं है सर। डॉक्टर मुकुल भी नहीं आए।
डॉक्टर अनुराग, गुड मॉर्निंग।
Good morning to all of you, sir. Good morning, sir.
डॉक्टर अनुराग, गुड मॉर्निंग। Not interested in reciprocating.
पूरी तरह से ज्वाइन नहीं हुए अभी वो।
हाँ सर, सब किश्तों वाले लोग हैं।
Dr. Sirohi, sir. Good morning.
जी सर, गुड मॉर्निंग।
हाँ, वो एक्चुअली ना मेरा कंप्यूटर हैंग हो रहा था, मैंने आई हैव टू ओपन इट ऑन मोबाइल,
ओके ओके।
so that's why I was trying since 8:30.
अनुराग सर, आप
अरे
दो डिवाइसेस से लॉगिन हुए हो क्या?
हाँ, दो से हुआ सर, एक को बंद कर दो।
एक बंद कर दीजिए।
I should leave or I should. It's all right now.
फिर भी दिख तो रहा है, आपने पूरा छोड़ा नहीं है उसको।
हाँ सर, उसे देखने दीजिए, बिकॉज ना अगर इसमें कोई डिस्टर्बेंस होगा देन आई विल यूज अनदर वन, एंड आफ्टर माय वर्क इज ओवर, माय जॉब इज ओवर, देन आई विल लीव ऑन वन।
डॉक्टर अनुराग, एक बार मुकुल सर को फोन कर लो ना।
ओके सर।
डॉक्टर मुखर्जी, मेरे को आपसे क्वेश्चन पूछना था।
बोलिए सर।
आपके यहाँ जैसे आप हेड फॉरेंसिक हैं,
हाँ सर।
तो जो डिस्ट्रिक्ट की जितनी वो होती हैं, ऑटोप्सी होती हैं, तो उसमें फिर आप लोग ही करते होंगे और या डिस्ट्रिक्ट हेड हॉस्पिटल वाले भी करते हैं?
नहीं सर, ऐसा है कि जैसे नागपुर एक बड़ा सिटी है, तो
हाँ।
मतलब मैक्सिमम जो पोस्टमार्टम है वो अपने यहाँ ही होती है, इंक्लूडिंग पोस्टमार्टम्स ऑफ कस्टोडियल डेथ, होमिसाइड्स। पर पेरीफेरी में पब्लिक हेल्थ के कुछ सेंटर्स है जो जैसे 30 से 40 किलोमीटर की दूरी पे नागपुर से, तो वो जो सिंपल केसेस है वो कर लेते हैं।
अच्छा, ठीक।
जैसा सर लोकल प्लेस पे एक्सीडेंट हुआ,
एक्सीडेंटल वगैरह।
हाँ, जो ऑर्डिनरी जो केसेस है वो कर लेते हैं। और बाकी इवन पेशेंट ट्रीटमेंट के लिए भी गवर्नमेंट या प्राइवेट हॉस्पिटल में नागपुर में आते हैं। तो नागपुर में 2 ही मेडिकल कॉलेज है और दोनों ही पीएम सेंटर है।
ओके, ठीक सर। तो आपको फिर कोर्ट वगैरह में वो देने के लिए अक्सर जाना पड़ता होगा?
किसमें सर?
कोर्ट केसेस में?
हाँ सर, हाँ सर, कोर्ट एविडेंसेस। यस सर,
बिल्कुल।
Good morning to all.
Good morning.
बड़े जोर की सीटी बजी थी काफी देर तक। क्या प्रेसिडेंट साहब आ गए?
कई बार डबल डिवाइस लॉगिन के वक्त ऐसा होता है।
आया होगा सर वो।
2 डिवाइस से लॉगिन करने में ऐसा कई बार होता है।
तो सिरोही सर, आपकी बात पसंद आई मुझे।
नहीं, प्रेसिडेंट साहब के आने का कुछ तो होना ही चाहिए अलग।
ढोल नगाड़े बजने चाहिए, आपने सीटी बजा दी सर।
जी।
ढोल नगाड़े भी बजेंगे देर के बाद।
बिल्कुल बिल्कुल।
Good morning, sir.
Dr. Atul Gupta sir, good morning, welcome.
Good morning, sir. Thanks for invitation.
Dr. Satish Agrawal, sir. Good morning.
Anurag, good morning.
सर लॉगिन हुआ म्हणते बरं ठीक मॅडम ते ऑन झालं.
गुड मॉर्निंग सर.
हेलो.
गुड मॉर्निंग सर.
जयपुरिया सर को नमस्कार.
हाँ, कैसे हो आप? हाउ आर यू फीलिंग बिकमिंग ए फाउंडर प्रेसिडेंट?
Sir, we are all president. This is just a designation. Just to distribute the post. Otherwise, Tiwari sir keeps on saying everybody is president.
Congrats, Satish.
Oh, is Dr. R.G. Patil, Rajendra Patil. From 1980 batch, he is an adolescent expert.
ज्वाइन कर रहे हैं सर?
We welcome
होने वाला है
Dr.
सर, ये
Gupta, sir.
9:30 था, 9:31 हो गया। सब वेट कर रहे हैं सर आप।
मुकुल सर हुए क्या ज्वाइन?
हाँ मैंने सर अभी कहा है वो ज्वाइन कर रहे हैं।
बस वो ज्वाइन हो जाएंगे तो शुरू कर देते हैं। डॉक्टर पाटिल, गुड मॉर्निंग।
गुड मॉर्निंग सर, गुड मॉर्निंग, गुड मॉर्निंग।
आपको व्यूअर्स की भी लिंक भेजिए और किसी को फॉरवर्ड करना होगा तो कर सकते हो आप।
नहीं ठीक है ना सर।
हाँ
नहीं, व्यूअर्स लिंक तो हमने सर काफी पूरे हिंदुस्तान में फॉरवर्ड कर दी। कम से कम ऑर्थोपेडिक्स के ग्रुप्स पे तो सारे पे पहुंच गए।
18 पार्टिसिपेंट।
Welcome Dr. Rishikesh Nagalkar. His pleasure of the body as well as today's session in charge. They will be conducting the proceedings. So Dr. Tiwari sir said कि moment Dr. Mukul Tiwari sir, the national president joins, we will start with the proceedings.
Yes sir. मेरे और चलाइट लो।
We are fortunate to have guests like Dr. Alu Gupta sir.
Yeah, I am honored to be among the great people, medical leader Satish Tiwari sir.
So the others they all belong to the National Medical Legal Group, and most of them are today they are the post holders from Maharashtra State Branch of Indian Medical Legal and Ethics Association. We welcome Dr. Anindya Mukherjee also. He is an MMC observer.
Thank you, sir.
Dr. Mukherjee, sir.
Sir, thank you very much.
Sir, you are at IGMC now?
Yes, sir.
You are at IGMC?
No, sir, I am at GMC.
Acha, because we are all passed out from GMC.
Yes, sir. Sir, I am at GMC.
Anurag, sir. Dr. Anurag Verma, sir. Dr. Tiwari, sir.
हाँ बोलिए।
9:33. 9:33 हुए हैं।
डॉक्टर मुकुल से मेरी भी बात हुई, ज्वाइन कर रहे हैं, ज्वाइनिंग दिख रहे हैं, वो आते बराबर शुरू कर दे।
हो गए ज्वाइन, हो गए।
गुड मॉर्निंग एवरीबॉडी।
गुड मॉर्निंग सर।
मॉर्निंग मुकुल बॉस।
गुड मॉर्निंग।
गुड मॉर्निंग।
बहुत देर कर दी सनम आते आते। गुड मॉर्निंग।
मुकुल सर शुरू करवा दीजिए आज का प्रोसीडिंग।
आज कुछ तबीयत ठीक नहीं है, सो आई विल आस्क योर फॉरगिवनेस फॉर बीइंग लिटिल लेट।
Sir, please carry on. No, not now with the forgiveness or excuse. We were just waiting for you.
Sorry for being late.
And as Satish Tiwari sir said, if you permit, then we will start with the proceedings.
डॉक्टर मुकुल।
यस सर।
आप ऑफिशियली डिक्लेयर करो ना कि आज की प्रोसीडिंग शुरू की जाए।
यस प्लीज स्टार्ट द प्रोसीडिंग्स।
So we request Dr. Rishikesh Nagalkar.
Yes sir.
To start with this installation ceremony.
Thank you respected Dr. Satish Agrawal sir. respected Dr. Satish Tiwari sir, all the respected vice presidents, and all the dignitaries. We'll start with the installation ceremony by the introduction of respected our National Secretary, Dr. Anurag Verma sir. Next slide, please. Dr. Anurag Verma sir is the MD Medicine. He is also LLB, LLM and consultant physician. He is also a medical legal advisor, and he is a medical legal consultant at MIC Private Limited. He is a member of Medical Legal Action Group and is associate professor at SD College of Law, Kashipur. I request Dr. Anurag Verma sir for his address.
Very good morning to all of you. Thanks very much, Dr. Rishikesh Nagalkar sir, for inviting me to address this highly intellectual gathering this morning. It's my immense pleasure and privilege to be a part of this installation ceremony of first Maharashtra State Branch of Indian Medical Legal and Ethics Association. Serving the association IMLIA as secretary, I am very fortunate to have able guidance and valuable inputs from time to time from Dr. Satish Tiwari sir, founder president of the association, and President Dr. Mukul Tiwari sir, and cooperation from for various academic activities from very active and committed members like Dr. Satish Agrawal sir, Dr. Hemant Gangulia sir, Dr. Rajesh Boop sir, to name a few from Maharashtra, and many other people, many other members from various other states of the country, and also senior members from Executive Board of IMLIA. These academic activities being so vital for medico-legal awareness of the medical professionals. Formation of a state branch of this big state of Maharashtra and upcoming state branch of Uttarakhand reflect the progress of Indian Medical Legal and Ethics Association. And with uninterrupted continuation of the academic activities, these shall lead to further enlightenment of medical professionals about the medical legal aspects of the profession, and to be able to practice in a better way, safe, secure, and free from medical legal litigations up to a great extent. I extend my sincere and best wishes to Dr. Satish Agrawal sir, President of Maharashtra State IMLIA branch, Dr. Hemant Gangulia sir, Secretary, and all other office bearers to be able to put their efforts for the progress of IMLIA, and that way to contribute for medical legal awareness among the medical professionals. Last but not the least, I extend my sincere thanks to the esteemed faculties of this CME and all other members behind the scene for making the event highly successful during the hours to come today. Thank you very much. Yes, sir. Now I hand over to Dr. Rishikesh Nagalkar for further proceedings. Thanks.
Rushesh, please unmute yourself.
Thank you, Dr. Verma sir. Now I request our National President, Dr. Mukul Tiwari sir. He is a MD, DCH and Fellow of IAP. He is a pediatric consultant and director at Apex Hospital, Gwalior, and he is the National President of IMLIA. So I request Dr. Tiwari sir, I invite him for his presidential address.
Thank you so much, Dr. Nagalkar, and a good morning to all the attendees. My respects to the founder president, Dr. Satish Tiwari sir. And as for the IMLIA was incepted in about 2011. It has been almost 12 years since its inception, and I have seen it growing from strength to strength. And despite many obstacles, any organization, obstacles always come. But Dr. Satish Tiwari sir, the founder president, with his vision, has steered off the obstacles and has taken the organization forward. And today we boast of more than 1,100 members. We have regular annual conferences, regular updates, and publication of a quarterly journal, which has gone uninterrupted since last so many years. And I hope the growth of IMLIA will go on. I hope and I'm sure that the growth of IMLIA will go on as it has done in the past. Now, today, it's a very heartening matter that Maharashtra state branch is being inaugurated. This is the first state branch, and I hope it will set precedence for many other state branches to be opened in the future. And it's a great development for IMLIA also. The incoming president of the Maharashtra state branch, Dr. Satish Agrawal, is a very dynamic person. I've known him since so many years, very affable, soft-spoken, endearing person, and very dynamic also. And Dr. Hemant Gangolia, the incoming secretary, he also holds the same qualities as I said about Dr. Satish Agrawal. So I'm sure they'll set the new records for success for the state branch. And in near future, Uttarakhand state branch will also be started, as has been informed to me by the National Secretary, Dr. Anurag Vermaji. He is also a very dynamic person. And as for the founder of IMLIA, Dr. Satish Tiwari, I hope and I'm sure that he has many more programs in his mind for the development of IMLIA. With this, I would like to conclude, giving best wishes to all the office bearers of this newly inaugurated IMLIA Maharashtra branch. Thank you very much. Thanks. That's all.
Thank you, National President Dr. Mukul Tiwari sir, for his crisp address. Now I request our respected Dr. Satish Tiwari sir and our founder. He's very much well known to me since my undergraduate days. He was my UG teacher. He was my PG guide, and I know sir very well since so many years. He is a MD Pediatrics, LLB, and Fellow of IIP. He is the founder president of IMLIA. He is founder convener Human Milk Banking Association. He is the president of IYCF chapter IIP 22-23, and he is also professor of pediatrics at PD Medical College, Amravati. So I request respected Dr. Satish Tiwari sir for his keynote address.
Thank you, Dr. Rishikesh. As rightly said by our national president, Dr. Mukul, the aim of forming this association was to create awareness amongst our members regarding the medico-legal issues, the ethical issues. And I think the present scenario is the example why this association is important. The unfortunate incidents of the death of Dr. Archana Sharma in Rajasthan. Dr. Alok is there, he can put more information if somebody knows. But the first thing our association wants to is to create awareness about medico-legal issues, not only amongst the doctor, but all the specialties of doctor, including the Ayush specialties, the advocates, the hospital administrators, etc. Of course, as we know, the judiciary and police authorities or the government authorities, they are also taking decisions many times which is against the interest of doctors and ultimately against the interest of the society or community as a whole. So to create awareness, we are having regular publications, we are having regular CMEs and conferences to empower our members. We had recently taken one CME along with Dr. R.G. Patil from Nagpur IM and all, the Save the Girl Child organization. So I think our aim is to empower our medical personalities, our medical colleagues, not to take such type of unfortunate decision of committing suicide. We should have the unity amongst ourselves. We should work with the ethical principles and legal principles. It's already come in the curriculum. And I think all of us will take care of our colleagues as we take care of our patients. So before something wrong happens, we have to remain united. We have to make them aware of the various legal provisions. Yesterday, Dr. Dinesh Thakre has kept a very good CME on how to protect the doctors. What are the various laws or the sections of IPC which protect doctor, in which we can be held responsible. And of course, Dr. Naurange sir has told many important case laws. So today also I welcome all the faculty, all the delegate. I can see Dr. Ravi Shankar from Chennai, Dr. Kedar Malwatkar from Nashik, Dr. Mahesh Baldava sir, our mentor and guide, which we started with the medical legal group of IIP, and it was his vision that we formed the Indian Medical Legal and Ethics Association, because medical legal group of IIP was only for the pediatricians. So we discussed and we said that we should come out with an association which is for all the doctors. So that was the guiding force, Dr. Baldava sir. And I welcome all of you again today on this very important occasion, very vital occasion of forming of the first state branch of the IMLIA, that is in the Maharashtra. As Dr. Mukul sir, our national president, has already said that there are many other state branches in formation. The most important which we expect the next branch will be from the Uttarakhand. Dr. Siroi sir and Dr. Anurag Verma are working very hard for the formation of Uttarakhand branch. So we will wish all the best to our Uttarakhand members and all the best to our members all over India, which now, as Dr. Mukul sir has said, it is somewhere around 1100 to 1200. If we include the Ayush doctors and advocates, etc., it will go more over 1100. So again, all the best to all of us. And with this, we wish all the best to Dr. Satish Agrawal, Dr. Hemant Gangolia, and Dr. Rishikesh Nagalkar for their next venture as a Maharashtra IMLIA state branch. Thank you.
Thank you, respected Dr. Satish Tiwari sir, for your kind words and guidance. I request Dr. Tiwari sir for the announcement of installation of the new team.
With this situation in the background, with the background situation, I hope the IMLIA Maharashtra state branch will bring a lot of laurels to the IMLIA. What we have achieved in last 10 to 12 years, as said by Dr. Mukul, this branch will add more and more milestones in the history of IMLIA. And with this, I declare the installation of Maharashtra IMLIA branch under the leadership of Dr. Satish Agrawal as president and Dr. Hemant Gangolia as secretary and Rishikesh Nagalkar as treasurer of the Maharashtra IMLIA branch. The further names of the various executive board members, Dr. Satish Agrawal will announce his team in detail. So with this, I think the Maharashtra IMLIA branch gets installed.
Thank you, Dr. Tiwari sir. I request Dr. Satish Agrawal sir for his acceptance speech. First, I will introduce Dr. Satish Agrawal sir. He is MD from Mumbai, BCH DNB Pediatrics. He was the past president of IIP Amravati branch in 2012. He is the executive member of IIP Maharashtra in 2013 and 16. He was also organizing secretary of Mahapedicon in 2005 and organizing chairman of Mahapedicon in 2019. He is involved in various social services by conducting TV shows on various health issues since last 6 years. He is regularly writing health-related articles in the local Marathi newspaper since last 25 years. He has received Excellence Award for Social Awareness by Central IIP. He has also received Sanman Patra and got felicitated at Mahapedicon 2019 for his social activities. He was also recently his awarded fellow of IIP at Noida at National Pedicon. So I request Dr. Satish Agrawal sir for his acceptance speech.
Thank you, Dr. Ruchkesh Nagalkar. Respected Dr. Satish Tiwari sir, Dr. Mukul Tiwari sir, Dr. Anurag Verma sir, all the executives, the guests, the delegates, and the audience who are viewing the proceedings on YouTube. First of all, I accept the responsibility bestowed upon me by the seniors as founder president of Maharashtra State Branch of India with all humility and politeness. Although I am making the statement, I know the gravity and the heaviness of the responsibility, but I am confident the expectations by all the seniors they have expressed will surely be taken care of because we have got a very strong team members with us. Dear friends, the goals as explained by Dr. Satish Tiwari sir, Mukul Tiwari sir, Anurag Verma sir, to form the branches is to decentralize the administrative process as well as to make the knowledge and information about the subject to reach to every corner of the country. And the whole day CME following the instruction ceremony is an endorsement of this statement. We'll try to organize such informative CMEs and as Dr. Tiwari sir said, including all the stakeholders in our regular programs. We all know the medical profession is supposed to be the most noble profession all over the world, and the society regards us as God or next to God. Unfortunately, of late, the doctor-patient relationship has deteriorated. The corporations of medical profession, as well as the Consumer Protection Act and so many judgments pouring in, they further deteriorated the doctor-patient relationship. So many litigations they are filed against the doctor. And Dr. Satish Tiwari said, a single case of well-publicized malpractice, so-called malpractice or negligence by any of the medico further maligns the image of the medico. So is there no place for ethical practice? Surely answer is yes. With due honesty, sincerity, and your hard work, and clear transparency in your communication with well documentation, one can very well render the noble services one had opted for. They say it's a very thin line between the errors and the negligence. And as we all know, the legal proceedings, the lawyers and most of the judges, probably they may not be having enough knowledge of our final medical technicalities. So prevention is better than cure. So why to get engulfed in such litigations? Better we adapt the same medical practice, meaning thereby not to avoid the emergency patients, not to avoid the emergency procedures, but to do in a methodical and the prescribed manner. Friends, I'm confident the tenure is going to be vibrant, dynamic. I'm so thankful to Dr. Mukul sir for his sweet words and the very strong team members of our team will surely achieve the goal. Jai Hind, Jai Maharashtra.
Thank you, respected Dr. Satish Agarwal, sir, for his acceptance speech. Me and all of our team members assure you that we will try our best for and give justice to IMLIA this year. Next slide, please.
So now it's with due respect to Dr. Rushesh, sir.
Yes. Yes, sir.
Let me take the opportunity to introduce our team. As Dr. Mukul sir said, I'm very fortunate to have Dr. Hemant Gangulia sir with me as secretary. At present, he is busy at Bangalore attending TOT. He is a very strong shoulder to us because we have worked together for the last two MDCon, and he is an asset to the organization. Next. We have seen the very polite person, Dr. Rushesh Nagarkar. He is a consultant pediatrician neonatologist at Nagarkar Nursing Home, Amravati, Director of Life Care, Critical Care at Amravati. And the very good quality of his is, he always says yes, unless until he has got any genuine reason. Thank you, Dr. Rushesh. Friends, since this is the very new branch, so as per the advice of the seniors, we restricted the number of executives and divided the bigger state in 5 zones. And we have taken the representatives from each zone, so representing the zone as well as the faculty. Now, the vice presidents and the executive members in alphabetical order. First is Dr. Dinesh Thakur sir. He is the vice president from Rauti. Apart from a pathologist, he is LLB. He is very much engaged in IMA activities and medical legal activities. He is a director, Thakur Pathology Lab, Amravati, and specialty is he's running Thakur Maternity Home along with his wife. Today, unfortunately, we are missing him as he is out of station. Next is Dr. Jayesh sir from Nandurbar. Actively involved, apart from medical legal activities, in IYCF chapter of IFP and BPNI Maharashtra. Sir, we welcome you.
Thank you, sir.
Dr. Milisha sir is a consulting gynecologist at Solapur. We have seen all throughout him is a great academician as well as a great human being. Sir is busy at family function, so we are missing him. Next. Dr. Sudesh Joshi sir is a senior obstetrician at Pandharpur. Chairperson Medical Legal Committee of AMOX, member of NIMC Foxy, and past president of Pandharpur OBGYN Society. He's such a humble person. Whenever we contacted him, he always says yes. Example being, he's a faculty at today's CME. Sir, thank you. Dr. Sugatya Iyer, madam, she's qualified in medicine, law, and hospital management. She leads the NABH assessor and trainer and a deputy director, Hinduja Hospital, Mumbai. Always smiling, laughing, and starts with Jai Shri Krishna. Madam, Jai Shri Krishna. Next, executive members. As I said, we have 5 zones and we included 5 executive members. Alphabetically, Dr. Anurag Panglikar is MD Pediatrics Gold Medalist and LLB practicing at Bid, Maharashtra. He was the president of IMA Maharashtra last year. Organizing chairperson Marcon 2014 and President Rasif Foundation Bid. Although he is not returned, but last year he received the Best President IMA Award at Patna. Thank you, sir. Dr. Gauri Gore. She is a practicing gynecologist and laparoscopic surgeon, doing private practice in Mumbai. She writes regularly in public print media, especially Marathi newspapers, about issues related to medical practice and how tiresome, how tedious, and how hardworking the work is. I know it very well. Thank you, ma'am. Dr. Jaipuria, sir, is such a soft-spoken person, a polite person. His CV only shows this tendency. He just wrote that I am a MD anesthesiologist practicing in Gondia. Sir, we welcome you and we're thankful to you for getting included in our executive body. Dr. Manish Matre, sir, a practicing consultant and gynecologic endoscopic surgeon at Pune, Chairperson, Ethics and Medical Legal Committee, FOXI. Sir, we welcome you. Dr. Radhesham Lodha, sir, is an ophthalmologist practicing at Dhule. Sir, we welcome you. So friends, with this short executive body, but the strongest ever, I believe, the executive body, we assure all the possible work the association can do under the able guidance of the CDS and help cooperation support of all fellow colleagues. I once again thank you all. Thank you.
Thank you, respected Dr. Satish Agrawal, sir, for the introduction of the new team. Introductory slide for Dr. Tade, please. Introduction slide for Dr. Naresh Tade, please.
Rishish, you may continue with Dr. Tade, sir.
Okay. So I request President of IIP Amravati branch, Dr. Naresh Tade, for his welcome address.
Good morning, everyone. I welcome all the respected dignitaries on the dais in this installation ceremony of IMLA Maharashtra State Chapter. First of all, I congratulate our own respected Dr. Satish Agrawal sir and Dr. Hemant Gangulia sir, along with Dr. Rishikesh Nagalkar, for the first Maharashtra chapter of AMLA installed as a team. I also wish my best wishes for them to do a very good work in this field, and I know and believe that they will do the work which will try to fill the gap between the doctors and the patients and decrease the need of going to the medical legal matter to the courts. And I believe by doing the active work of Dr. Satish Agrawal sir in public awareness, this may happen in next few years. I also request all the delegates who are here to attend the CME program on various medical legal matters, which is shortly followed by this installation ceremony. And I thanks the organizer for giving me opportunity to attend this program. Thank you very much.
Thank you, President IIP Amravati, Dr. Naresh Tade. May I start with the CME now?
Sure. Dr. Mukul sir, Dr. Satish Tiwari sir, with your permission, we start with the academic session, the CME.
Yes, please go ahead.
Please. Yeah. Please go ahead, and congratulations for a very successful installation program.
Thank you, sir. Dr. Rishikesh sir, please continue.
Yes, thank you, sir. The chairman for our first session is Dr. T.N. Ravishankar sir. He is a FCGP and DMA from Colombo. He also holds a postgraduate diploma in medical law and ethics. He is the director of Sundar Hospitals at Chennai. He is the chairman of Standing Committee, Medical Legal Cell, IIM Headquarters. May I request respected Dr. T.N. Ravishankar sir for his address. Yes, sir. Please unmute yourself, sir. Dr. Ravishankar, sir. Sir is muted, I think. Yes, sir. Not audible, sir.
So we'll put the slide of Dr. P. Tiwari, sir. Moment, sir, Joyce, will continue, sir.
He is still not audible, sir.
Prakash, please put the slide of Dr. P. Tiwari, sir.
Okay, we'll proceed with with the first speaker, Dr. P.N. Tiwari, sir. He will speak on the topic Consumer Protection Act 2019 relevant to medical practitioners. Next slide, please. Dr. P.N. Tiwari, sir, is the member, Judge, CDRF, Delhi, retired. He is MBBS and LLB from Jhansi. He is also LLM and medical advocate, member of Gujarat Bar Council, Supreme Court Bar Association. His expertise in medical negligence and deficiency and medical issues. He is the former panel advocate at Medical Matters, Government of India, Delhi High Court, and NCDRC. He's ex-MO Government of Delhi and LM IMA. He is practicing since 25 years. He is also an advocate since 2005, and he is the member just since 2015 to 2020. So I request respected Dr. P. Tiwari, sir, to proceed with his presentation.
Hello, everyone. Am I audible to you all?
Yes, sir.
Yeah, very good morning to all of you. And it's a great achievement for the IMRIA to establish another milestone in Maharashtra. And definitely it is a unique association which is very much conscious about the medical legal issues pertaining to the medical fraternity. And various topics has been explained and raised in different occasions. And secondly, because why it is unique? Because this association is the only association a part of IMA which has 3 Tiwaris. And all the main is Dr. Satish Tiwari, and I am thankful to him for including me. The second is Mukul Tiwari and myself. And again, I am thankful to Dr. Satish Agarwal for giving me some time to discuss about this act, because this is the only act which is directly applicable to the medical fraternity. And it is very important to understand what it is. Now, coming to the point that we have to make some awareness among the medical practitioners why it is so important to understand the basic structure of this act, because as on date, maximum cases are filed in consumer commissions. Why? Because the medical profession comes under the service provider heading. So fraternity is a service provider, and any damage, if occurs, and it is not taken due care, the cases are bound to be filed before the consumer commissions. Now, what this act is, and second, I'll discuss about the medical practice and some leading cases in medical negligence which are directly affected to our profession. Now, in this, what is new in this act? Because we all are aware that we had a Consumer Protection Act, and in medical fraternity, we used to call as COPRA, something like that, you know. But now it has been replaced in August 2019 with a very new thing. And what is new in it? We'll discuss. What is CCPA? Another chapter has been added to this act. The next is mediation, and other is product liability and e-commerce. I mean, these are the few chapters which has been added in this new Consumer Protection Act. Now, first we'll discuss what is new in it. Now, first thing is that initially we used to call as forums, right? And every district had one forum. Now this word forum has been replaced to commission. Secondly, initially the damage limit, the pecuniary jurisdiction was 20 lakhs. Now it has been enhanced to 50 lakh. Now second is here how much a patient can claim from a medical practitioner. And who is a medical practitioner? We all know, and we have discussed, even we will be discussing it. Here basically it comes to majority of the cases which are filed against the specialist, right from having a diploma to specialty or super specialty. MBBS simple, have a least liability. Now, how much expenditure one can claim against the fraternity? Now here, the claim has to be justified by the amount paid to the doctors in form of a consideration starting from the first consultation to all different stages where he pays, and that forms a hospital bill, you can say. So that is a justified way to claim the amount. And secondly, about the damages, because once he has suffered the damage, so the quantum of consideration has to be awarded is directly according to the damage suffered. So here the expenditure. Okay. Sir, anything you want to say? Sir, should I continue?
Sure, sir. If you can make a full screen.
Hello.
Dr. Tiwari sir, with due respect, if you can make a full screen.
स्लाइड शो नहीं किया है आपने, स्लाइड पूरी स्क्रीन पे नहीं दिख रही है।
स्लाइड नहीं आ रही, शेयर किया।
स्लाइड दिख रही है, फुल स्क्रीन नहीं है।
आप नीचे जाके स्लाइड शो में जाइए।
एक मिनट।
डॉक्टर तिवारी सर, जहाँ पे आपका कर्सर है, द येलो ब्लॉक राइट ऑन द 5 o'clock right corner, lower right corner. Yes, you can take your arrow on the right side, sir. Yes, sir. More down. Just near to the yellow box, sir. The yellow highlighted box.
Yes, sir.
Sir, 69% जहाँ लिखा है उसमें 69% जहाँ लिखा है उसके पड़ोस में जो आइकन है उसको क्लिक कीजिए।
सर फंक्शनल की F5 दबा दीजिए। फंक्शनल की F5।
आपको शेयर
करना हो नहीं रही, जस्ट देखना।
सर स्लाइड्स दिख रही है पर फुल स्क्रीन नहीं है, स्लाइड शो में नहीं है।
स्लाइड शो में नहीं आ रही।
हाँ तो नॉर्मली का काम कर लो।
Dr. Satish Agrawal, if there is a problem, continue like this only, no problem.
Sure, sir. Tiwari sir will continue. Dr.
Sir, it is visible now? Now it's sharing?
Don't bother Dr. PM Tiwari, please continue.
Okay. चलो यहीं पे था।
ये स्लाइड पे था। कोई पापा वो कई बार ना सपोर्ट नहीं करता है। आप ऐसे ही शेयर करो, वो दिखेगा।
It's all right, Dr. PM Tiwari. Please go ahead.
Sir, we are able to see your slides.
You are able to see the slides?
Yes, sir.
Yes, sir.
Okay. So now we were discussing about the justified claim which the patient or the complainant claims from the fraternity, and how it is calculated. It is all on the complaint. That is a justified or actual bills which he has, and secondly the amount which he claims for the damages. And how damages is to prove? It has to be proved beyond the reasonable doubt that this is the actual damage which he suffered from the line of treatment, because the damages has to be proved by the complainant or a consumer or a patient. Now the second is that in this way the process is taken, and here the new thing is that e-filing and e-proceedings were also introduced in this pandemic, the corona pandemic, and virtual conferences or proceedings were also done. Now here whatever the order is there from the commission or the district commission, it has to be appealed to the state commission within 30 days. And now initially every case used to go state commission, but now it is specific the only legal point where the forum has or the commission has done some irregularity. Otherwise, no appeal will be filed. And what are the penalties? That is all we have to see in the proceedings. Now, the second chapter has been added as a CCPA. That is it is a Central Consumer Protection Authority. This is a separate authority where this authority can intervene to the system or a fraternity or any, you can say in a medical fraternity, we can say the lab, the investigation, the process, whatever it is. This is a direct intervention of the Central Act. And here it is done by the chief commissioners or medical or the district magistrates. Now they have a different executive powers, and whether they can stop the functions, they can stay the functions or put the penalty or both. And about the appeal of against the CCPA, it is the only National Consumer Dispute Judicial Commission within 30 days from the date of order. Now the second chapter has been added is mediation. Mediation, we all know that it is a sort of mutual voluntary settlement between the two parties in presence of a neutral person. Now it is already there in Civil Procedure Code, that is section 89, and this has been initially applicable to entire medical fraternity. But after the enactment of this act, the medical services were omitted from this mediation process, not from the Consumer Protection Act. Here, even in mediation, if because two parties are, one is a patient, one is a doctor, treating doctor. If we all know that at what stage I have committed a mistake and I have not taken due care of it, so definitely we all know. And unnecessarily or some other issues, we keep on lingering the matters and proving our wrongs with all the issues. But here it is in this, if a opposite party or the responding party feels that he should go for mediation, then the damages will not be awarded in such a huge manner. It is only the mutual settlement among the parties. Whatever is indirectly, you can say neither it is an outside court settlement or it is a adjusting nature, but it is a legal process. And here, once an agreement is done between both the parties, so it is not no appeal, only appeal lies in High Court. So it is definitely a very difficult process. But here I'll say, though this new chapter is not included or applicable to the medical fraternity, but if a medical person or the respondent or opposite party feels that there is some negligence or deficiency either himself or in a vicarious liability form by the staff or hospital, whatever they can move an application and matter can be referred to mediation, and within no time it can be settled. Now this is two, and third is the product liability. Initially, the commercial goods were not included in the Consumer Protection Act. And even if some damage occurs, say for example, you have purchased X-ray machine, MRI, sonography machine, or whatever or lab testing units, and some damage has occurred. So those damages could not be recovered under this act because that was the commercial use and only personal use can be covered. So in such condition, that was a great damage to the fraternity. Now, under this product liability, if any damage has occurred against the product or its manufacturer or service provided or a product seller, whatever is there, and under these heads, fraternity or a doctor particularly has suffered damages or loss, he can file a case making the insurance as a party and can claim against any of these, whether it is a manufacturing defect or it is a service provider defect or any product which is sold not proper. So here the product liability is there, and main here is the use of services by the who can file. Here only the authorized person who is using the product can only file. Otherwise, it has no action against the damages if somebody else has filed the case or the product has beyond the warranty. So these are the three. And second is e-commerce. Now we all know, as on date, everyone, we are dealing in online platform transaction of money, all purchase and orders being put on software or the online platforms. So here again, if any damage is there or any defective goods has been supplied through e-commerce, you can claim, because every company which is registered with the government has a proper its address, its email and everything, and they have a policy to refund it, to repair it, or to replace it. So all these things now applicable in e-commerce. Initially, no, this facility was not there, because they say no, it has been manufactured, so the manufacturer is liable. Service provider say no, sir, I can't do because this is a manufacturing defect. Ultimately, consumer used to suffer. And now here, under this process, even a commercial person can also avail this facility. And now here, about the relevancy to the medical practitioner here, that all the records we are going to discuss here will be properly preserved, and everywhere your documents are required to be counted. So be careful and be attentive how to preserve the your documents, because every document has a legal identity. And with this, in short, I'll come to the end of my short awareness about this new act. And the now we are open for our question answer sessions, whatever is there. And with this, I hand over the position to the organizer of the session. With this, hello.
Dr. Tiwari sir, a simple question. The new provisions, whether they are doctor friendly or not?
See, directly or indirectly, no act is friendly to medical fraternity, right? Hello.
Yes, sir, continue.
But we have to see how we can take strong medical defense. And this medical defense is not an afterthought. It should be on the spot. Any document which has been put before the court, it should be seen or judged immediately what the situation was at that time. But not after 2 years or 3 years, and after supported by many issues or researchers that this process is right. So best is whatever we are doing, whatever we have done, it should be recorded, and under those issues, we can put our defense in a stronger way so that we can save our fraternity, ourselves. Otherwise, if you leave such issues, you will be held responsible.
Am I audible, sir?
Yes, sir. Yes, sir. Welcome,
Dr. Ravi Shankar here. Am I audible?
Welcome, sir.
I'm sorry because of some interruption in my net.
Tiwari sir, could you explain a little bit on the 1 crore, which we keep saying that the limitation of jurisdiction of the district forum is 1 crore, but what is actually given in the law is when you have spent money to the extent of 1 crore, you can go to the district forum. Correct, sir?
Yes, sir. Yes, sir. The upper limit is 50 lakh.
The compensation that we can claim to the district forum when you are filing your case. What is the upper limit for the claim from you, from the individual?
See,
you said it is raised from 20 lakhs to 50 lakhs. Correct, sir?
See, the upper limit of compensation is a pecuniary jurisdiction, which is 50 lakh in district consumer commission. And beyond that is for state commission and national commission. So we are discussing for the commission, district commission, it is 50 lakh now.
What do you feel if there is a capping of compensation on the money spent and the money that you can claim? Will be a repercussion on the medical fraternities? People keep demanding that there should be a capping of the compensation. If that comes into force, whether it will be a benefit or it will be a problem to the medical community.
See, compensation is for an individual person or a hospital. It is neither bound to or applicable to the entire fraternity, because every case has a different issue and different merits. So whatever damages has been awarded is only to the individual person. He may be an individual doctor or a hospital. So in that way, the fraternity can only learn about what mistakes has been done, what law has been laid down under this situation. So it is not an umbrella compensation or a capping compensation system. It is an individual based compensation, which is directly applicable to the opponent party, whether it is through insurance company or through yourself.
Respected Dr. Tiwari sir, last 2 minutes.
Yes, sir.
Last 2 minutes, sir.
The mine is over, sir. It's up to you,
okay,
sir.
Okay, sir.
I've already finished.
Sir, to sum up the session.
That was a clear giving instruction of how the present act is then applicable. Probably Tiwari sir is very clear that medical community is aware that the CPA 19 covers them. But then there are still a lot of people in our medical community who keep thinking that CPA 19 is not covering the medical community. But you have gone through clearly saying that in the mediation council itself, it is a negative positive thing. They have said that death or a medical negligence death cannot be covered in the mediation council. It means it is covered in another place. That is what it means. Clearly, or not in the terms that has been expressed, but there is a clear line which says communities are covered under CPA 2019. Thank you for giving an elaborate and insight on the Digital India into the Consumer Protection Act also. Thank you very much, sir.
Thank you, sir. Thank you.
Can we get on to the next topic, sir? When saints become sinner, I think the saint of the medical community is there, Dr. Mahesh Balwada. And I think he needs to be recognized a lot for an excellent author being, repeatedly doing something for the medical community on medical legal issues. A medical graduate, a pediatrician with a law degree, with a PhD in the consumer law, masters in business administration. I think what he had spent his time just reading, gathering knowledge onto his gray matter. And it is very much pride for the medical community that a medical man is teaching at the law college, in addition to being a professor in pediatrics at three other medical colleges. And I really thank you, sir. Your book has given me lots and lots of input, and I think your book should go into the records of doing lot of case laws for the medical community, for the advocates who support the medical community. Your book is going to be a Bible in the future. Thank you. Let's hear from you. The saint who's going to talk about how the saints can become sinner.
Thank you very much, Dr. Satish, all, Dr. Mukul Tiwari, Dr. Anurag, every one of you. Hi, and good afternoon from Melbourne. I'm joining so for inviting Dr. Satish Tiwari. I will. You will be there. One word which deliberately missed, or I don't know, which is not there in this particular. Saints become sinner legally. I am here to how they become. We are all saints. All doctors are saints till they are doing good for the patient. But moment something which is unpalatable to our legal fraternity, then we become sinners. This has been told. There are several books written by me, and this is the largest selling book. Now, this message, saints become sinner, was first made clear by 3-judge bench in Nizam Institute case versus Prasad Dhanankar. Now, they have clearly said here, this particular bench, that they emphasize the cases involving disability are in many respects even more tragic than cases of death, particularly where the disability is of the nature of involving lifelong condition. Now, this is the comment that disability is much problematic than the death itself. Now, later on it was diagnosed. In a NIMS, instead of removing entire pathology, instead of doing biopsy, the entire removed. The paraparesis, which other but lived with paralysis. Otherwise, also he would have had both limbs paralyzed. Duty of medical care fulfilled as required by IMA versus VP Shanta and earlier all Supreme Court judgments. Faulted for consent for biopsy but removed the entire tumor. Neurosurgeon was not associated to do with thoracic, along with the thoracic surgeon who was operating. And 1 crore, that at that time, in those days, it was the highest. Afterwards, of course, 11.5 crore plus amount has come. Patient died a natural death late after winning the case. So here, 2 counts, the saints have become sinner. One, they took a consent for the biopsy and they removed the entire, which was for the good, according to me, for the patient. And second thing, what unfortunate things would have happened otherwise also in a natural course. In this particular case, it happened, got crystallized just post-operatively. Now, I am not here to comment upon what, but then certainly in this case, good thinking person, thoracic surgeon, Dr. Satyanarayan, has been made to look. So messages do heroic the entire don't secrete, address the patient, use any aptly observed, save the without underlying message. Resuscitated newborn beyond 7 minutes. It was cerebral palsy. What died was an infant. And this is the then celebrated case of Spring Meadows Hospital versus Harjot Ahluwalia. At that time in 1998, it was the highest award, 19.5 lakhs. Now here what happened? The intravenous IV Lariogo bolus was given and patient developed cardiorespiratory arrest, treated full throttle with full efforts or resuscitation, survived with mental retardation, cerebral palsy. There was a vicarious liability of the nurse who gave this particular injection to the baby. And the child has become adult now, is living, continues to live with disability. Now here, again, saints have become sinners. There is no role of prescribing Lariogo or injecting Lariogo by doctor here. It is the miscommunication which has gone and the nurse itself has given, who was ultimately found to be unqualified. So in the legal parlance, even though the doctors or the Spring Meadows Hospital, they have not done anything actively, something else which is being done by the nurse because of our ignorance or whatever, overzealousness, the doctors and the hospital were held liable. So again, the child was already having respiratory and cardiac arrest. I don't know how far giving a care have gone in the way the legal fraternity looks at it. I am not here to comment, but this was the judgment. 2008 3-bench judgment. This you are very well aware. This is a consent judgment in Samira Kohli versus Dr. Prabha Manchanta. Unmarried 44-year-old woman. She had serious mental problem and she was found to be having extensive endometriosis covering entire uterus, entire ovaries, and some of the intestinal parts, etc. The real consent for diagnostic laparoscopy was taken, not for diagnostic laparotomy or operative. When the patient was under general anesthesia, doctor took the consent of the aged mother of the patient and removed and did total hysterectomy with bilateral salpingo-oophorectomy. That was for the good of the patient. I don't see as a doctor any problem. Now, what was found? The consent is what they observed. We don't require. We are not going to Roger versus Whittaker of the Australia. We are not going into the Canterbury judgment of the USA. We are not bothered about whatever the law may be in these Western countries. What the law, we are following Bolams. So as per the Bolams, the consent should be real. Real means whatever is written on the consent form, and it should be valid. Valid means it should be given by the patient herself, or who should be 18 years and conscious without any undue influence and all those things. So in this patient also, if you see medically, everything is done saintly, but legal paradigm, they were found negligent. Of course, though patient demanded 15 lakhs, only 25,000 was compensated. Supreme Court. But I have to wait. Same Supreme Court observation because with the IV fluids, but in one of the limbs where the IV fluid was given in his hospital, the Supreme Court observed they feel it is the subsequent development of gangrene and amputation. There is a prima facie doctor is liable, but then the matter had come for a quick decision. So it was remanded back to the National Commission, but doctor settled this out of court, and it was just short of becoming sinner. Just short of. He remains saint by paying 5 lakhs rupees, doing out of court settlement. So ultimately, this is another matter. Wherever the gangrene occurs, really the negligence of medical professional. But without seeing into the intricacies of what had happened before and how critically the patient was, from critical condition, patient has been brought to life. And now, of course, the fact is that a gangrene occurs and the amputation also is done to save the life. But in the legal fraternity, it is seen as if the saints have become the sinner. Now, if you do not provide a court whatever required documents which is needed as per Dr. P.N. Tiwari also, that whatever, but he said that it should be supplied as, according to me, whenever you lay hand over whatever case records you have related to the patient, of course not manipulated or crisscrossed, the genuine ones, even in your electronic format, which is allowed under 65B with a certificate, it should be submitted to the court of law, because otherwise what will happen? The court, if you keep the silence, then the court will speak. And they say the negligence speaks for itself. What a wonderful concept, though of course unreasonable. Now in this case, digest stent was removed. Now in this, the kidney stones were removed, but not mentioned on discharge card that digest stent. The orally patient was told that you have to come for the digest stent removal. He came after 1.5 years of insertion, and by that time it got calcified and it was very difficult to remove. So it went from one hospital to another hospital to another hospital. The fourth hospital removed the digest stent. Here again, the saints have become sinner just because I don't know what they just writing or not writing. The patient, does it work? But the stent will certainly patient, specialist or kidney surgeon or a general surgeon who will say the DJ is not, I have not told the, or do not show that it was mentioned. So again, the saints become sinner. Now, these are number of cases where the patient has survived. These are not the cases where patient is dead. And the mop was left or some tip of the cannula was left on. In all the cases, the patient has survived. Now, leaving a mop is so bad as to not to attend to the prior emergency. When it happened during the intra-operative period, the patient was bleeding and a pressure packing is done. Sometimes it so happens that pressure pack looks itself as a meatball or some raw area, and you are afraid to, in spite of due counting properly, it may happen that once in a while a mop might remain. And if it remains, the glyciform P-bioma are not so bad that it cannot be retrieved again, or even a artery forceps for that matter, or a tip of the suction cannula. That is definitely a smaller surgery than the original surgery. Competent doctors and probably, and in this case, this is to Dr. Viren Shrikande, who operated on the gallstones in 1993, and some mop was left and which was retrieved in 2002 and 2004. The case was filed, and the patient telling that 9 years she suffered. Now, Supreme Court clearly, as it was pleaded, that this case is barred by limitation, and they agreed, and there is no action in this limitation operates, though it was pleaded later on, held complainant was barred from limitation. This is the only way we can. Now, with increased amount of compensations of like 11.5 crores, etc., or it is better to plead at some or other stage that the case is time barred, and that only can save the doctor. So you have to go to the technical defenses and find out if there is any way I can save my skin, otherwise they will be. So here, saints saved from being sinner by it has become a cause that make a premature sinner patient that is thankless for to save the baby now with surfacing several comorbidities in the baby. They start murdering doctor. Is prosecute study, cerebral palsy, hearing problem, maybe increase in bilirubin giving rise to CP, or one of the commonest thing which is being highly compensated by the various courts and the Supreme Court, the highest being 3.38 crores, that is 1 crore 38 lakhs, particularly for non-referral of retinopathy of prematurity. This has become a noose on the neck of pediatricians, gynecologists, and ophthalmologists. Now, ROP, no screening advice, negligence, not a single case has been won so far. The consecutive 9 cases are available. The highest being V. Krishna Kumar versus State of Tamil Nadu 1.38, Maharaj Agrasen Hospital versus Master Rishabh 76 lakhs, Bhavik Mahajan versus Dr. Pankaj Sharma 43 lakhs, and there are other cases which everywhere something or else. There is not a single case I can find which is not where the doctor is not found guilty or negligent and no compensation is given. Now, doctor cannot win this case on merits. Now, defense is available to doctors for alleged non-referral of screening of ROP. So, prove the patient was referred. If there is a genuinely patient was referred, and now since the OPD case papers remain with the patient in India, they are not with us, not with the doctors. So, prove that patient party did not go to ophthalmologist. You have to lay hand over whether he visited the ophthalmologist or not. Of course, so many times the complaints cases have been for the country, and it is some or other time if you raise objection and now with the current scenario to pay amount if you go to the higher pack or 1 crore. So it means you have to deposit 50 or 25 lakh before you go to the bank, but also not going to win. So it is better points you want to raise that for the case is time bar. Other act which has caused to the blindness, multiple healthcare professionals were involved. Whatever care the patient takes advice of the doctor and vicarious loss of liability of the hospital. So let saints be saints and not sinners. Follow the Dr. Srikande's case where he pleaded that there was a limitation to that particular. Similarly, there could be other scenario that you are referred that the patient was seen by ophthalmologist, of course, though the patient has become blind, was seen by multiple people, etc. Now, in this particular this thing, if you want to remain, then the only technical defenses remain. Now, all the cases which I have described, these come under the category of short negligence. So, please consider all these technical defenses and exhaust them before you say quits to the cases. And I'm very sure if you go on the merits, you will never win in the court of law. So remain saint by taking help of lawyers and the medical legal people, and of course IMA, people like IMLIA, and various organizations have their own medical legal groups, and you take help of the law here and remain saint. Thank you very much. If any questions are there, I'm ready to answer. I'm well within time. Dr.
you, sir.
Ravi
It
Shankar,
was,
sir.
yeah, it was trying to quote all the landmark judgments of this country and try to show how a doctor, though having done the good job, if there is something lacked, they are legally bound to answer, and that is how they become sinner. Nowhere in any of those cases a doctor has deliberately done a mistake. And if a mistake has happened, it has to be taken care in the right way legally. Though we may not accept the fact that having given our knowledge, effort, and everything, finally something small wrong happens, we are bound to answer legally. That is what Dr. Mangesh has beautifully given all the landmark judgments. I think he is a data bank for the country's medical legal cases. I think he could enumerate, enlist, give it offhand. So many cases that he had gone through, he is keeping it in his computer brain to give it to us.
Thank you.
Thank you, sir. Any questions?
Any questions, sir? There are so many, like, where the like in treatment. I've seen Bombay Hospital. The National Commission has held that there was a delay. Oh, this is such a thin, and the delay is such that National Commission said that we will apply res ipsa loquitur, and Supreme Court says there is no delay. How can you apply res ipsa loquitur? So res ipsa loquitur has become like punching doll. Someone says in his discretion, I am going to apply. Some other person says, no, I don't agree. The facts and circumstances are so clear. So there are several. This is a recent judgment which I am quoting, Bombay Hospital, where the operation theatre was not available to a aortic aneurysm patient, and the patient died. I think all of you must be aware, and it was very well publicized in the newspapers as well. Any questions?
There aren't any questions. Sir, you are very clear. Whatever you told is quite obvious to everybody. There is no questions around.
What, some of the areas which are not covered, like, giving out, where they find, delay in treatment, or which is, I mean, those are where delay. Other one patient, physician felt the cardiologist of jam of Delhi, and patient died, and there is not a cardiologist. But in one of the judgment, you are aware from which went from Orissa, where Supreme Court observed, they gave a lot of advice about your Section 89 and alternative remedies and this mediation, etc. But they said that hysterectomy should not be operated without an ICU setup. Now, if we have such a kind of judgment, then in the official places, in the small towns, in the small setups, people will close down and go. Thankfully, only 5 lakhs were awarded, but the days are not that they don't consider the background that the person is from official or from a very small town, or he's from a big place, or it's a corporate hospital. For them, once the negligence is there, it comes to restitutio in integrum. Or something happens, something bad. Now, for lifetime, it should be paid by the doctor. For lifetime. This is what has happened in your case of V. Krishna Kumar, government of Tamil Nadu. The girl has been paid for lifetime, including inflation.
There are no questions. Can we close the session for the organizers?
Patient listening.
Yes, sir. Next slide, please.
Tiwari or any.
Thank you, sir. Thank you, Dr. Mahesh Baldava, sir, for a very informative session. and a lot of lessons to be learned from this session. Thank you, sir.
Dr. Rushikesh.
Yes, sir.
Let me interrupt. Dr. Ravishankar sir wants to sum up. Dr.
Okay,
Rushikesh
sir. Go ahead, sir.
I have summed it up, sir. I have summed it up.
Okay, sir. Okay, sir.
Okay.
Dr. Rushikesh sir.
Yes, sir. So our chairperson for the next session is Dr. M.L. Agnihotri, sir. He is a consultant pediatrician at Nogong. He is the Central Zone Chairman of IMLIA. He was the organizing chairman for IMLIACon 2020, and he was also the organizing secretary for the IMLIACon 2021-22. So I request respected Dr. M.L. Agnihotri, sir, to continue with this session.
Dr. Rushikesh sir, because Dr. Agnihotri sir is having some connectivity issues, you may continue.
Okay, sir. The third topic for today's CME is recent concepts of patients transfer, medical implications. Our speaker is Dr. Rohini Deshpande ma'am. She is MD, FRCOG, FMS and Diploma in Endoscopy. She is consultant obstetrician and gynecologist at Ramakrishna Hospital. She is the IPP of AMOX 2018-20, and she is a zonal chairperson of IMLIA. She is also national mentor for Lakshya program. She is a core committee member, Mission Save the Uterus and SOPs on hysterectomy, Compendium of Lakshya Manyata for Private Hospitals, Government of Maharashtra. She is also PG teacher at Ashwini Rural Medical College, Kumbhari at Solapur, and she has many scientific publications on operative hysterectomy and color Doppler, PIH. She has presented various orations and academic lectures at state and national level. So I request our speaker, respected Dr. Deshpande ma'am, to proceed with her presentation.
Good morning. Am I audible to you?
Yes, ma'am. Yes.
Yes. Good morning, Dr. Rushikesh. Thank you very much for inviting me for this session. I would like to express my deep gratitude to the national, this founder president, Dr. Satish Tiwari sir, and Dr. Mukul Tiwari as a national president, and secretary, Dr. Anurag Verma. I would also like to congratulate our founder, Maharashtra State Chapter President, Dr. Satish Agrawal, and Dr. Gangolia as a secretary. Thank you very much for giving me this opportunity to share my experience. Today's topic, can I share my screen now?
Yes, ma'am.
Is it coming? Is it okay now?
Yes, ma'am. Okay.
So today's topic is recent concept in patient transfer. As we know that this is a very important topic because it forms a very important aspect of the patient care, and the main aim here is to give the continuity of care and to improve the prognosis of the patient. But it involves the decision process, and the protocolized approach has to be there for a best outcome. So this transferring the patient, it should be initiated very systematically, and it should be based on evidence-based guidelines. This involves physiological alterations, which actually alters the prognosis of the patient. And this is a very important key point for this. This patient transfer can be intra-facility or it could be inter-facility, and it could be a diagnostic procedure for which the patient is referred to, or it could be an advanced patient care and in emergency situations. I know of one of my patients who needed to be transferred for a facility for a imaging, that is, she was for a CT scan because she had a big mass in the pelvis. I'm an obstetrician and gynecologist. So we wanted to get that done, but she also had a COPD. And the day before the operation, she was actually in that CT room, which was very, very cold. And they did not realize that this could trigger a respiratory event in this patient. This patient was operated and she could not come out of the general anesthesia, and we had to actually ultimately transfer her. So this was a situation which we knew that she had a COPD, but probably we did not anticipate that even a small or even a diagnostic procedure can even sometimes, precipitate certain events which may predispose patients for certain risk situations. So we have to be very, very careful on these issues. There are different guidelines which are available. That is American College, Society of Critical Care Medicine, British Association of Anesthesiologists, and so on and so forth. But as far as Indian guidelines are available, they are very far and few. So maybe I would request Emilia that we should have our own guidelines from our association for this transfer of the patient. There are certain key elements which should be emphasized for the patient transfer. One is the decision to transfer. This should be solely by the consultant or the doctor who is in charge. And the communication which goes between the doctor and the patient's relative. That is very, very important. Then the stabilization of the patient prior to transfer and its preparation to the transfer is also important, which is based on the ABC, that is airway, breathing, and cardiac stability and neurological stability of the patient. Then, of course, the mode of transport. This could be either a road transport or a ground transport. And again, the ambulances can be of 2-3 types. One is the basic ambulance, and another is an advanced where the life support machines are available on the ambulance. And there could be a possibility of mobile IC unit for a patient who has to travel a long distance. This is about the ground. But we also have a air transport which is available if we want to take the patient of myocardial infarction, stroke, or severe trauma. And this could be in a, through the air. And there are 2 vehicles which are available. One is with the fixed wings and another is a rotor wing, which is a helicopter. So another important point is we have to consider that who is going to accompany this patient. Again, it has been divided into different levels depending on the critical situation. Then the drugs which are important, emergency drugs with pre-filled syringes, because there won't be any time for the patient if she needs some important medications on the way. Then all the equipments have to be checked. All the monitoring devices have to be checked. This is for those who need the advanced life support and want to travel more than maybe 50 kilometers, 250 kilometers. We have to be very careful on these issues. And while we are doing all this, it is very, very important that we document all the events which are happening and what are the different steps which are happening, and along with the transfer note to the facility to which we want to transfer this patient. Why we are so much worried about the transfer of the patient? Because the ultimate truth is, what happens if the patient worsens on the way? What happens if the patient dies on the way? And what happens if the patient has a bad outcome? And these are the physiological alterations which we have to take into consideration while the patient is being shifted. One is the noise of the vehicles, the vibrations which the patient will get, and when there is an acceleration and gravitational force around the patient, that can disturb the patient's physiology. Sometimes on a long distance, patient may be affected when there is a hot temperature or maybe very cold temperature, humidity. And if the patient is flying, the altitude can make a difference because it can expand the gases within the body spaces, and the equipments also can get sometimes dislodged. So there are various issues with it. Sometimes the patient even will get motion sickness, can have nausea, vomiting, and it will predispose the patient for increased risk during the transit procedure. So these are the various complications like pulmonary, airway complications. As I said, sometimes patient may become hypoxic, patient may breathe the oxygen which is less in concentration. There could be dislodgement of the endotracheal tube, cardiovascular complication like hypotension, infection patient is prone to, and endocrine complications may be sometimes diabetic patients especially can become hypoglycemic or hyperglycemic. So there are various risk factors which actually predispose to complications, and they could be correctable factors. They could be either patient related itself, because if the patient has got myocardial infarction, severe trauma, patient is on complex medications, or it could be staff related. Hello? Yes, sir. Then there could be staff related complications like
हाँ बस देख रहा हूँ ना, आ गया स्क्रीन पे.
Sorry.
Yes, sir. Session is already going on, sir. Session is already started, sir.
So inexperienced staff, it is a very important key element because we have to give staff training as to how to transfer the staff. Unfamiliarity with monitoring equipment, the person who is accompanying becomes important. The insufficient preparation of the patient, if you don't have proper drugs, monitoring equipments, it matters. Then the poor communication with the receiving facility. There has to be a good communication so that they know that this patient is coming and they are also ready to receive this patient so that the prognosis of the patient can be better and the patient will get the best possible outcome. Then the inadequate resuscitation also can happen if somebody who is accompanying is not well versed with this kind of a transfer. So we have to know who will accompany the patient and that person has to be very responsible. Then the lack of checklist for anything and everything that you want to protocolize, you should have a checklist. And interruption of the therapy also can occur during this procedure, during the transfer. So we know that this transfer is needed in any faculty of medicine, maybe surgical, maybe obstetrics, maybe medicine, but we have to understand that it involves not only patient's relatives and doctor in charge of the facility and the department, and also the doctor in charge in the department of the receiving at the receiving end. So this smoothness of the transfer is entirely on a good communication, and a written documentation becomes very, very essential. And another aspect to it to add is the expense which occurs while we are doing all this, and increase mental pressure on the doctor, patient, and the relatives, and maybe the trauma that they undergo with the transfer of the patient. So it's important that we understand these key elements, that once we identify the situation that we have decided and evaluated the patient and patient needs transfer because we feel that patient will get a better care, or maybe there might be a situation where we don't have the equipments or a manpower to deal with this patient, and this could be an unanticipated situation or it could be an expected one. So we have to have a very justifiable reason for transfer, and we have to give it in our transfer note. The stabilization of the patient is important so as to make the patient safe for the transfer. And once the decision is made, even a minor action is performed with a sense of urgency, which is very, very important. Informed consent and a written consent has to be taken, talking to the in-charge doctor at the other end, preparing the transfer note, and making sure that the bed is available, because it shouldn't happen that you transfer that patient there and from there patient needed to be transferred to another facility, and in the meantime patient becomes worse or even dies. So all these things are very important, and make sure that the facility is better equipped and has a better facility than what your facility is, and counsel the patient's relatives for the approximate expense according to the facility. And accompanying the patient during the transfer in the appropriate case is very, very important. And all these key elements should be followed in each transfer to prevent any adverse effect which might adversely affect the prognosis of the patient. Any poorly organized and hastily done patient transfer to shirk off the responsibility can significantly contribute to the morbidity and mortality of the patient. For example, if the patient is bleeding in labor room and you want to transfer her in an anticipation of something of DIC which you cannot probably handle, then make sure that the patient is stabilized before actually she's transferred, because that can make her a lot of good. So we know that we have discussed, but road transport, we have discussed the air transport. The another transport that I need to discuss here is the in utero transfer, which is very, very important. And while we are doing this, there are key elements in the protocol which should be followed for each and every patient. And along with this, our staff training becomes a very important aspect. So this facility can be inter-facility transport. The ambulances are available. We should have a list which is displayed, and the number should be available. Even the air transfer, ambulances number also has to be available. The important point here in air ambulance, if somebody wants to airlift the patient, is you have to choose whether it is a fixed wing or whether it is a rotating wing, because if it is a rotating wing like a helicopter, it can directly go to the facility, doesn't have to use the ground transport again. But if you have a fixed wing air ambulance, then in that case they will drop you at the airport, and from there you have to organize for the ground transport again. So you will be losing some time. So we have to consider. Then this is regarding the neonatal transfer. How it can be very complicated, neonatal transfer, but it is required if the baby becomes hypoxic. But we have to make sure that this neonatal transfer can be avoided if we can transfer the patient in utero for those patients who have gone into preterm labor or those who are bleeding antenatally. And that makes again a sense to do that. I'll come to that in a minute. So when you are doing all this, as I said and emphasized, check and verify the document. The transfer note is very, very important. It should be put in on the record, and it should give the valid reason for transfer, the medications and the IV fluids which are given, and the surgical treatment in detail and the wound details. So coming to this wound, this in utero transfer, this is real a good concept. Those patients where babies are preterm, especially less than 30 weeks or between 30 to 32 weeks, they are very small and tiny babies who will not sustain this trauma of vibrations, noise, or even respiratory problems. They are prone for everything, like even including the infection. So look at this, if you have a baby like this, hypoxic and needed to be transferred, so many things baby will have, like respiratory, maybe oxygen going on, endotracheal intubation, blood pressure cuff, and whatnot, IV lines. So it's difficult to transfer. So the in utero transfer has got a lot of impact on neonatal outcome, and it has got an impact on the parents and the family as well, because parents will be in one place, everybody, and it will be economical for the family as well. And here we have to consider that in situations where we need to transfer them in utero, we have to give the patient, if patient is in labor, we can give tocolytics, we can give antenatal steroids to stabilize, and we can even give injection Maxel prior to transfer, so that it will give a neurostability to the baby and prevents complications of cerebral palsy, but not during the transfer. And the informed and written consent has to be taken. There are certain situations like preterm labor, eclampsia, antepartum hemorrhage, and abortion, where we have to stabilize the mother first and then transfer. For example, if patient is having eclampsia, we can't immediately transfer her like that. We have to secure her airway, breathing, circulation, and make sure that you give her anti-epileptic treatment, and then only you transfer her. If she's bleeding, you have to correct her hypovolemia and then correct. So these are the things which are actually new in our practice, which we should follow, and that will give the best outcome for the baby. There has been a study. Why we are discussing all this? Because we don't want to be go into the clutches of medical legal issues. And there is one case which is reported, they were actually fined 20 lakhs. There was a forum which slaps rupees 20 lakh fine on private hospital for problems in transferring the patient. So this case has been actually one of the landmark cases. There are so many landmark cases in a yearbook of 2013. There are listed at around 10 to 15. So you can imagine this, how many, what is the dearth of the, what is the magnitude of this problem when the patients are being transferred, and how we are actually vulnerable for the medical legal litigations. So the points to take home are the timely decision to transfer the patient, good communication with the patient and the relative and the doctor at the receiving end, pre-transfer stabilization of the patient, and appropriate way of transfer we have to choose, prepare the protocol, follow the guidelines, do the documentation, train your staff for smooth transfer of the patient, and avoid medical legal issues by taking due care. Thank you very much and have a safe practice. Thank you so much.
Good morning. Am I audible?
Yes, sir. Good morning, sir.
Yeah.
Thank you for being there.
So thank you very much, Dr. Roni Deshpande. You have covered all aspects of the topic very nicely. And your presentation, it was excellent, par excellence than the others. So now we have a time for question and answers. Please, all the respected participants are requested, they can ask the question. Any question from the participants? Any question? No. No, I think you have covered all aspects very nicely. So there is no query, nobody has the query.
Thank you, sir.
Dr. Amravati, sir.
So
Dr.
now we
Amravati,
have,
sir.
yes, sir.
If you allow me.
Oh, Dr. Satish, sir. Welcome, sir.
Question to ma'am, is it necessary, like while transferring the baby in a critical condition, say 2 or 3 day old neonate,
right,
the person who is treating should accompany the baby, or is who can substitute the treating neonatologist?
It depends on the critical nature of the baby, and usually the babies, when they are transferred in a critical situation, it is better that the doctor who is responsible, or maybe you can delegate to a person who knows if there are any problem, how to tackle. So that person should be a well qualified person, and he should have a reasonable knowledge of dealing with any situation which can arise during the transit, because the transfer can be a very short transfer, or it could be to the nearest neonatal facility. But sometimes these babies are even transferred from one small village to another big city, and that can lead to, you know, longer time will be there. And for babies, you know, getting the tube out or IV line getting disturbed, you know, all such situations have to be handled by that person. That is most important.
Thank you, ma'am. Over to Amravati, sir.
Thank you.
Any more question?
May I ask you, sir?
Shall I? Yeah.
Dr. Mahesh Bandhu? Yeah. If the patient dies on the way, then what are the things one should do?
Yes, a very apt question you have asked, sir. When we feel that the patient has arrested during this during the transit, then in that case, all possible events have to be recorded properly, and we have to when we reach the next facility, probably they will also evaluate the patient, and then we will have to whatever is the events are there, we have to put them across to the patient and the patient's to the patient's relatives. But we have to face this situation, and maybe when these such patients are very critical, we have to actually inform to the relatives in anticipation that we are transferring the patient, but there could be a possibility of worse outcome during the transit as well, because that will actually take off some pressure from us, and we will be in a safe hand, and we have to take the consent, the high risk consent in such situation. So basically we should have a sense of anticipation. If it happens as an unexpected event, then of course it is a very unfortunate situation.
In that event, who is going to be responsible to give the death certificate, etc., and whether the patient should go back to the referring facility, or where he is in the midway and patient is dead, and your accompanying doctor realizes this, accompanying doctor or assistant, whosoever, he realizes that.
If the facility to which we are going to get this baby transfer, the patient transferred is very much away, and we realize on the way, then the patient's relatives may be actually following you in another vehicle or something like that. But doing a counseling are in the transit will become a very difficult thing. So best thing is to reach the nearest facility which is available and go there and then explain everything, and then maybe patient can be brought back, and we know everything about the patient and the situation. So we will be very much in a position to give a death certificate to this patient if required, or we have to do a post-mortem in that case, so that everything becomes because it's like having a death on an operation table. So any death which is during the transit or unexpected, we have to inform the police and maybe do the post-mortem or whatever. I think that would be an apt procedure to do, because it is very unfortunate situation, and we should have some protocols, as I said, because such situations may not be like immediately we will have a grasp over such situations. So we could go wrong here in managing these patients.
Second
I will
aspect which I,
appreciate your inputs on this.
no, I think it should be brought back to the
Same hospital.
referring. That is the best way, because what happens, you are dealt with everything so smooth that everything goes fine, but there are chances that person may get into the traffic jam, like if you are in Mumbai or
Absolutely,
Pune,
sir.
and the delay is not on the part of the treating doctors or the ambulance, and the patient dies. So this part, and then there is a lot of mudslinging that you have to enter. So possibly, if you need to transfer, you have to choose such a time when the least traffic base is night.
Yes. Yeah,
So
we
time
have
is the
to
best
take into consideration the possibility, like in a place like Hyderabad or maybe in Mumbai, we will have all these concerns. So everything we have to mention in the consent itself. I think that is the first thing that we should do. And in case of any event, we will also inform the patient that we will bring back the patient. Thank you, sir.
Can I come for something? I am audible. May I say something?
Yes,
Hello.
Dr. Hemant.
Just I want to say some 3 points. When patient is on midway dying, there are 3 points. One, once declare the death there itself or not, have to anticipate the things. If problem is seems their problem, better not to declare death. Take the patient to the transfer hospital and then declare the death. Second situation, if you're confident enough, you can counsel the patient and anticipate. Come back and at your hospital decide to give the DC or not. Third thing, when you go for transfer, if the patient is really serious, it's better to also inform police. See, Baba, we are transferring such a serious patient, probability this may happen. So it just keep an antenna open for the police also. So these are the 3 things I think so that one should anticipate. And regarding DC, if the referred hospital takes the patient and show on the indoor papers, if they declare death is there itself, then again the issue of the death certificate will come. So whether the referring hospital will give or where they have reached they will give, then there comes the situation. So it depends on the relation between the 2 hospitals, how one refers to the hospital. If the relations are good, then they can show and then they can give that DC also.
Yes, it is one of the very difficult situations. I think very nice inputs we had from Dr. Hemant and Dr. Baldava sir. Thank you, sir.
Any more question? Dr. Hemant? Dr. Hemant, you want to know something? No? You want to ask anything? More question?
No, I want to add to it if I'm permitted.
Yes, Dr. Anurag.
Yeah, one thing very important to keep in mind, that while transferring the case to another hospital, the referring hospital has to provide all the records and documents to the patient also, because it is the duty of the hospital which is referring the patient to the another facility. Number 2, when the patient reaches the hospital where the patient has been referred, then it is duty of that hospital also to ask about the documents and records which are to be sent by the referring hospital. If the referring hospital does not provide, that hospital is also liable. And if the hospital where the patient has been referred to does not ask for these documents, that hospital is also liable. There is a judgment of Supreme Court in this matter, and I thought it necessary to put it here. Thank you.
Thank you, sir. Thank you for your input.
So it's okay, I think so. So thank you very much, Dr. Rohini Deshpande, for very interesting and very fantastic talk. I think so.
Thank you, sir.
Thank you. Now, I invite, we have another international topic. I invite Dr. Mija sir. That is the medical legal issues in international perspective. Dr. Mija, please. Dr. Mija is a very well-known personality in the medical field. He is working at Ethiopia JVDM Memorial Hospital, and qualification he did the bachelor degree LLB, and he has so many master degrees in the public health. Now over to Dr. Mija, please.
Dr. Melkamo, before you start, let us accept the greetings from the IMLIA for your completion of 1 year of the Medical Legal and Ethics Society of Ethiopia. So all the best for your society on behalf of IMLIA.
Thank you very much. Tiwari, sir. Very
Dr.
affectionate words. Thank you, sir. Dr. Mija, please.
Yeah, thank you.
Sir. Dr. Amravati, sir. Let me interrupt. Basically, Dr. Melkamo is a surgeon. And apart from his surgical skills, he has done all these LLB public health, this diploma, and he has got so many public certificates. His CV is nearly about 3 pages. Over to Melkamo, sir.
Okay, thank you very much, Dr. Satish Tiwari, for the very nice greeting message. We are really very proud of you, and yeah, we know that you are a good father of IMLIA. So we have a very great respect for you, and it was a very nice message, and we are very much boosted by that message, and thank you very much. And thank you also for the promise of support. Dr. Satish Argawi is now IMLIA Maharashtra branch, his chairman, and I really want to thank him for his the good job done and for organizing this branch, and now I congratulate him and his team for a good job that they have done. And also I thank Dr. Samir Sadwarti and Dr. Ashish Jain for the good, very nice and excellent message, together with Dr. Ashish Argawi. Very nice message that they passed to our members for our 1 year celebration. So after, and also thank you very much for inviting me to this session. And I will start my presentation. Okay, is it full screen now?
Yes, yes.
Okay. Congratulations and namaste. So my topic is medical legal issues on international perspective. But since I found this a bit wide topic, I only concentrate on 2 issues just to save time. And one is on standard care and some dilemmas around this standard of care. I will make some examples. I take some examples from the Western cases, and that may be important to take, though it is some these examples are a bit old, but it could be important for us to mention this again, and because we are a bit, especially in those in Africa, we are a bit not that much strong in medical legal issues. So it's good to learn from these issues of standard care dilemmas. The second one is also informed consent. There is also some kind of dilemmas around informed consent, and we'll mention some of them, and we'll discuss how these issues are dealt with in the current practice. We physicians practice based on the standard of care that the same medical profession is expected to function or practice. But in the previous days or centuries, there is so-called professional custom rule. In the professional custom rule, usually the custom practice of the physicians of the same level and with the same skill and knowledge, which gives a reasonable care, which was judged in the court by the reasonableness rule. Once the physician acts in the professional custom rule, sometimes the court can interfere. Not always, but sometimes the court can interfere and could say that the practice is not reasonable, and so that the professional might be found guilty. And if you take one case, there was in 1974, there was one case in Washington. The 24 years old female patient was having some myopia and short-sightedness problem, and for that reason, she visited an ophthalmologist. The ophthalmologist, after he investigated, he did some investigation, and then he ordered a contact lens. And after that, she was repeatedly visiting that ophthalmologist. Within a 10 years period, she visited around 10 times the ophthalmologist, some for irritation of the contact lens and for the other problems. But after 10 years, she started to have some difficulty in vision. She started to have a loss of peripheral vision, and then later weakness in the central vision. Then the ophthalmologist did a pressure test to check for the glaucoma, and she was found to have glaucoma. And after that, the court case arose from this case, and in the court, the expert medical opinion was the custom practice in that hospital or in that community, in that medical community, was to test pressure, to check pressure test for those patients who are above the age of 40. But since she was 24 years old, they said that it was not the custom practice to screen all patients under the age of 40, because the risk of having glaucoma is 25,000. So since the screen is not a normal professional custom, the patient was not didn't have screen, but eventually she developed glaucoma. But the court could not accept its professional custom rule, but resorted to its own analysis of reasonableness. So finally, the court, in its final statement, said that even though the custom rule is not sticking to custom rule, only sticks to the screening of pressure test or screening of glaucoma with pressure test after the age of 40. The doctor could have been reasonable to check that patient and do the simple simple and cost-effective pressure test, since she was seen around 10 times over 10 years. the doctor could have been done that, so that sometimes a professional custom should be interpreted in terms of reasonableness. So, because of after this assumption, the court finally gave a verdict against the professional custom, that is, which now we call it a standard practice. And even now in our country or in some parts of the world, such kind of things happen. Some courts may use this reasonableness or other factors to act against the medical practice standard. So these things could happen, and sometimes you have to also take into consideration when you deal with patients. The second one is customary practice. We have a standard medical practice, it's national or it can be state and so on, but most of us are practicing following some customs. And sometimes these customs cannot justify a negligent act because it cannot be interpreted in terms of standard care. One of the common issues is even nowadays it happens in some parts of the world, which is leaving a sponge in patient's tissues, or could be abdomen or in other tissues. The first case is in Louisiana. A patient operated, and a doctor operated a patient. It was laparotomy, and finally at the end of the operation, the nurses declared that the sponge count was normal, and finally the patient closed the abdomen. The doctor closed the abdomen of the patient, and after the surgery, after the patient was discharged, he developed some abdominal problems and signs of chronic problems like weight loss and fever and so on. Finally, he was investigated, and it was found to have some mass in his abdomen. He was operated, and a sponge was found in his abdomen. And in the courts, still both the defendant or the doctor and the experts gave a testimony that it's a customary practice for the nurse to count the sponge at the end of surgery and declare normal. And even the instruments count as normal and declare the instruments count is normal. But the court the court finally gave a verdict saying that even if the customary practice is what the experts and the defendants stated, the defendant or the doctor could have been responsibly oversee the whole process, so that only the customary practice cannot make him free of guilt. So sometimes the customary practice, which we usually do it, even in the presence of standard practice, may bring a problem to our medical malpractice case. In the second case, it's the same scenario. It was in Texas, and the patient was discharged. The sponge count was declared normal by the nurse, but while at the end of the operation, the doctor asked specifically the nurses to count the sponge. So in this scenario, the nurses are professionals by themselves. They are instrument nurses, and they are accountable for what they are doing. And the doctor once declared that by nurse that the instrument in sponge count is normal, then cannot be responsible for any missing sponge. But it's only because that he has them with to count the sponge. The court found out that they are under his supervision, even though they are professional, they are under his supervision because he asked specifically them to count the points. So because of this scenario, they finally passed the guilty verdict against the doctor. So these issues are still happening, and we have to always take care of standard of following the standard of practice rather than doing the routine practice. The other issue which we have to raise is, while we are doing this standard of practice, sometimes we may deviate our judgment. And for one problem, there are many alternatives, and we may choose one alternative over the other. And sometimes we may, because of depending on our skill and our knowledge, we may sometimes deviate from the normal standard of practice and do something for the benefit of the patient. But these issues are controversial because in the courts, every action of the doctor is interpreted in terms of the standard of practice, which an average physician or doctor of the same level, the same skill, under the same circumstance, perform or reasonably care. So when there is a error judgment, we can have different treatment or diagnostic options. One doctor may choose one type of treatment or diagnosis, the other could choose another one. But all these alternatives should be the standard first, standard of practice. Second, the doctor should get all the information, all the necessary information from the patient, so that he don't miss any important information which misleads him to or her to make wrong diagnosis or wrong treatment. And third, there should be a reasonable uncertainty between diagnosis of course of it. That means one doctor could prefer one based on the same scenario, the same case, and the other doctor prefer another treatment. So this standard, this error of judgment rule is controversial in most states, but in some states it's accepted as the reason when there is a medical issue arises. But if the doctor doesn't get a proper information from the patient, then and if he makes a decision out of that incomplete information, then it will be liable for negligence error of judgment. The other, this is an example of negligence of judgment. Like surgeon was very expensive. He knows that certain certain drug is have some problem for that could create a problem for that specific patient. But since that, he's specifically using, he has that information, but he uses that drugs, despite he's using the same drugs, or using the same drugs, knowing that that drug could have an adverse effect on the patient, and finally, if you use that same drug and if the adverse effect happens, that means it could be negligent for any error judgment. The other is the best judgment rule. Sometimes we may, as I said, sometimes we may a bit deviate from the normal practice, the normal standard of practice. In this scenario, we have a problem, and one drug is stated in the standard protocol that it's the primary drug for treating that specific problem. it's a drug choice, but when the resistance for that specific drug, there is a second line drug, which is in this scenario, it's called as it's mentioned as beta drug. So when you have a problem, we may choose first the drug which is in the protocol, the first line drug, and then when there is a resistance to the first line drug, we may choose a second line drug as an option. But in this scenario, for this specific problem, the first line drug has to be used in combination with other drugs or alone. And when then it's not successful, or when there is a resistance, the second drug should be used, which is beta in this scenario. And the doctor first, based on his assessment in clinical assessment, he thought that the problem could be most likely can be treatable with the drug alpha without having any issue of resistance. But since this patient specifically was an IV drug user, he thought that from his experience that there could be some resistance, the chance of resistance for the drug alpha. But despite this uncertainty, he started this drug alpha and till he waits for a drug insensitive test. And now he has followed the normal procedure protocol. And then second situation, it's the same scenario, but because he has some uncertainty of there could be a chance of drug resistance because of his IV drug user, then the doctor weighs the risk and of the benefits and risks and starts directly the patient on drug beta. But drug beta is potent, but it has some side effects, more side effects than the drug alpha. So in the first case, laboratory results turn out to be resistant to drug alpha. So the doctor has to switch again to drug beta, but in the meantime, the patient has suffered a lot and he has got some more complications because of the first drug was ineffective. In second case, empirically, the doctor started the more potent drug, but eventually, and the laboratory results shows that the bacteria is sensitive to drug alpha. So, but in this case, he developed some complications out of the drug by itself. So in this scenario, both doctors, they use their skill and knowledge and so on to make the best judgment for this patient. But when these patients, for the damage, when these patients take this issue to the court, it's difficult now for the court, since the court only strictly follow the national standard rule. It could be difficult for some skilled and for some physicians who have good judgment to really make a good out of their knowledge and practice for the benefit of the patient. Because since the courts usually use only the standard practice, that will limit the capacity of the doctors to practice to the maximum that they have to give for the patient. The other issue is the locality rule, and this locality rule is usually practiced in most countries along with the standard of care, just to protect the doctors who are working in a rural area, and also to encourage doctors to go to rural areas and practice just by easing the standard of care that they are expected to follow. So in this locality rule, the standard of care is it's not like the national standard of care, but the standard of care is based on the communities they are serving. That means, for example, there is hospital in a very rural area. The standard of care for the hospital it's defined on that specific area. It's not compared to the urban area. So this locality rule is still being practiced. Followed by most countries and most states, but nowadays it's become obsolete. And the problem especially in developing countries, we use a national standard of care, but still we have this discrepancy. We have many hospitals in the rural area, and doctors are practicing in that areas. They have no. There is no communication. There is the technology is very bad, and they don't get updates and continuous professional trainings and so on. So, because of lack of this, it's difficult to implement these national guidelines throughout a country or throughout the state, and there is still conflict of interest. Since this locality rule is not either in the regulations or in the directives or in the law, but just what we have is just only national or state standards. So that conflicts with the practice which is on the ground. That may be important to mention when we are talking about the standard of care. Regarding the informed consent, there was a conflict between beneficence and principle of autonomy to accommodate these conflicts, and this standard doctrine of consent was developed, and in this doctrine, the doctors are expected to disclose adequate information, and the patient and the doctors also should get an informed consent from the patient. And the patient must be like any other contract. The patient must be competent and must understand the information conveyed, and also must be voluntary without any question. And in this doctrine informed consent, it is measured. The information is measured against the reasonable practitioner under similar circumstances would convey the information in the manner that allows the patient to make knowledgeable evaluation. So it is measured against the reasonable practitioner standard. But after the Montgomery, this disclosure of information is measured not against the reasonable practitioner standard, but against the reasonable patient standard. And that doctor has to disclose all the material risks so that the patient can reasonably know and perceive all the significant risks and decide on that specific issue. There is one case, I think in 1976, a doctor operated a patient, and intraoperatively he found out a mass which has involved vital structures like big arteries, big veins, and so on. And finally, he continued to do the operation, and there was bleeding and some injuries intraoperatively. And after the operation, there were some complications, and that case was brought to a court. And the court finally decided that if there is an increased risk from the operation, and for which the patient has not been informed, doctor could have stopped the operation if that could have been interrupted or stopped without endangering the patient health, so that he can get an informed consent again. But this patient, this doctor, he continues the operation, and he knows that he knows that by continuing the operation, he was doing some procedures that he didn't inform the patient, but the court said that he could have interrupted the operation, and then after the patient's awake, he could have obtained uninformed consent for the new condition for new procedure and proceed with the operation. So regarding the informed consents, now after Bolam, after Montgomery, it's more of the general patient's standard rule, but now there is a movement towards the shared medical decision making. That means the physician shares all the risks and relevant risk benefit of procedure or all the treatments, and everything will be disclosed, and the patient's side also will disclose all concerns and relative to specific conditions, and then they together they decide on the specific treatment which is better for the patient's outcome and which is more thorough for the patient. And maybe the future, there are many advocates for the shared medical decision making, and that could be the future type of informed consent. So in our underdeveloped countries, there are problems with laws and the regulatory bodies, and most of our laws are transplanted from Western countries, and we don't have reforms. For example, in our country, we don't have reforms yet, and we are still using the codes that we have transplanted from the Western countries. So we are still facing with much more problems regarding the medical legal issues, but still we'll wait for the change to come while learning from experienced countries like the West and also from Indians. And thank you very much for thank you very much for listening. And
Thank you so much, Dr. Meja. Excellent. It's a very excellent talk, and very not excellent talk. It's very, very informative for we all. Now, may I request participant to please ask the questions. Any question from the participant? Any question?
Yes, sir.
Yes,
Hello.
Dr. Verma.
I have a question.
Dr. Tiwari, sir. Aye.
Hello.
Dr. P.N. Tiwari, sir, is here. Yes.
Dr. Melkamo. Hello. Audible?
Am I audible to you? Hello.
Yeah. Yes, sir. You are audible.
May I ask question? Yeah. Good afternoon, Dr. Malkanu. Hello. Hello. Dr. Malkanu, good afternoon. Yeah, my small query is whether you have consumer courts in your country, number one. Number two, the judgments of consumer related matters, especially medical negligence matters from our Indian Supreme Court, are applicable in your country also? And if not, then how medical negligence cases are decided in your country? That's it.
Thank you very much. I didn't hear the first question, but let me answer the second question. In our country, there is no consumer act. There is consumer act, but not for medical for medical profession or for medical consumers. I mean, for patients. So medical negligence cases are seen. First, there are two ways. One, the administrative way, and the second, through the courts. The administrative way, then the patients, when they have medical legal issue, especially ethical issue, and when there is ethical issue, when the doctors, when there is an ethical issue, or the doctor perform below the level of care that they expect, they apply to the ethics committee, the National Ethics Committee, and the National Ethics Committee will revise the case. And when they found out that there is some ethical breach or breach in the service is given below the standard, then they will take some administrative action like revoking the license or terminating the license and so on. But on the other hand, the patient can go to court and claim for compensation by proving that whether the doctor is negligent or not. And we use this negligence codes from the civil codes, which we transplant from the French civil code. We don't have specific medical legal codes or consumer protection acts specifically for the medical consumers.
So that means the Bolam test is not applicable in your country?
The Bolam test, now the Bolam test is, usually the courts, from my reading, usually the courts apply the Bolam test. The expert medical bodies, the expert medical bodies' opinion will be taken, will be considered as a Bolam test by the courts. But in our country, first the case will be sent to this ethics committee. So the ethics committee decision is which is used as a Bolam test. So if the ethics committee decision says that okay, the doctor has performed below the level of the care that we expect that the same professionals do, then that will be considered as like a Bolam test, but it's not specifically doesn't serve what the Bolam service, what the Bolam test is serving. That's the problem. What the ethics committee is, they are only considering, they are concerning on the ethics part, on the ethics part, and also the level of care. But there is a bit confusion here, and they don't specifically consider what Bolam test in the either in this committee or in the court.
So I think
Sir,
now,
then what is the standard of awarding compensation in damages?
Dr. Tiwari sir.
Is it hello?
Dr. Tiwari sir. Dr.
Sir?
Tiwari sir.
Sir?
Yes, I'm hearing.
Yes, I think, sir, now it's time is over now. Let's give this opportunity to others now. So thank you very much, Dr. Mija, sir. It's a really very useful, very informative and excellent talk by Dr. Mija. And I thank you very much, Dr. Satish Agrawal, Dr. Satish Tiwari, and all participants for giving me this opportunity to be with you and chair the session. Thank you so much. Over to Dr. Satish Agrawal.
Dr. Rushi, sir.
Yes, thank you, Dr. Agnihotri, sir, for chairing this session. Next slide, please. I think Dr. Sirohi, sir, has not joined yet. Next slide, please. That is the panel discussion on the topic violence against girl child medical legal aspect. Next. The moderator for this session is Dr. Alka Mukherjee, ma'am. She is the director and consultant at Mukherjee's Multispecialty Hospital. She is the honorary secretary, International Council for Human Rights. She is a national executive member of IMLIA. She was the past president of NOGS in 2021-22. She was the past honorary secretary Narchi Nagpur chapter. She was also the past honorary secretary ISOPARB. She is a life member of IMA, NOGS, Narchi, and Menopause Society of India, ISOPARB, and IMLIA. She is also a founder member of South Rapid Action Group, Nagpur. She is the past vice president of IMA Nagpur, secretary AMWN, and she has organized various conferences as organizing secretary. So over to Dr. Alka Mukherjee, ma'am.
Thank you, Dr. Rishikesh. Can I share my screen, please? Hello.
Yes, ma'am.
Hello.
Yes, ma'am.
Dr. Sirohi hasn't joined yet. He's our chairperson.
There's a message from Dr. Sirohi, sir. He's unable to join at present. The moment he joins, we will have it.
Okay, sir.
Till
No
that time,
issue.
we will proceed.
So should we start? Yeah. My screen is visible?
Yes, ma'am.
Yes. Just a minute. So good afternoon, one and all. At the outset, let me thank the organizers for the opportunity for moderating this very important panel. At the same time, let me congratulate Dr. Satish Agrawal and Dr. Hemant Gangolia for getting installed as founder, president, and secretary of Maharashtra State Branch IMLIA. I pay my sincere regards to Patron Sir Dr. Satish Tiwari, National President Dr. Mukul Tiwari, National Secretary Dr. Anurag Verma, Amravati IIP President Dr. Naresh Taide, Dr. Sushil Rajput as a secretary, and Dr. Ritiraj Deshmukh as treasurer. My sincere regards to Dr. Agnihotri Senior Sir, Dr. Tiwari Sir, Dr. Baldeva Sir, and Dr. Rohini Madam. So respected seniors, IMLIA member, and IIP members, friends and colleagues, today's panel discussion is on a very common. हर घर की कहानी करते हैं पण वळत नहीं, जाने देन अपने को क्या करना है। आखे ब्रह्मांड में गूंजने वाले, पूरे दुनिया के कोने कोने में छा जाने वाले, ओपन सीक्रेट के बावजूद भी किसी को पता न चलने वाले टॉपिक पे है, जो कि है वायलेंस अगेंस्ट गर्ल चाइल्ड। Violence against girl child, against women is a major public health issue and is a violation of human rights. It negatively affects the woman's physical, mental, sexual and reproductive health. गर्भस्थ कन्या भ्रूण से लेकर जीवन के अंतिम पड़ाव तक परिवार तथा समाज द्वारा स्त्रियां आज भी प्रताड़ित हो रही है. India wants to achieve the SDG goal number 5, that is gender equality and empowerment of all women and girls by 2030. Is it possible? तो आइए पहले जानते हैं what is WOW. For this, I would like to invite the panelists Dr. Kanchan Sote, Dr. Manisha Rathi, and Dr. Vaishali Varad. Dr. Kanchan Sote, she is the alumni of Seth Medical College and KM Hospital, Mumbai. She is the past president of Nagpur OBGY Society. She had received 4 Best Paper awards. She is faculty at national and international conferences. She had many books and publications to her credit. Welcome, Kanchan Madam.
Thank you.
Second panelist is our Dr. Vaishali Varadkar. She is a senior consultant gynecologist and laparoscopic surgeon. She is in charge of ICTC Center at Matru Seva Sangh Sitapati. She is fellow guide for ICMH since 2011. She is the clinical mentor and master trainer for MPP training. She is faculty for Foxy Manyata. She has special interest in infertility. She is actively involved in teaching. Welcome, Vaishali. My third panelist is Dr. Manisha Rathi. She is director Rathi Hospital, Dharampet. She is the ex-assistant lecturer at many places. She is right now she is a trainer for Foxy Dhira program. She is the winner of Mr. and Mrs. Medico JC's Nagpur. She has received Presidential Appreciation Award IMM Maharashtra State 2013. Welcome, Manisha. First of all, let us see what are the constitutional rights for women in India. As per Article 14, we have fundamental right to equality before law. As per Article 15, we have prohibition of discrimination of grounds of race, religion, caste, sex, and place of birth. Article 16 gives us equality of opportunity in matters of public employment. Article 19, freedom of speech and expression and freedom to practice any profession. Article 21, protection to life and personal liberty. Article 21, right to privacy. And Article 300A, right to property. But what this girl is saying? So, women face violence all over the world. 34% of the women in the age group of 15 to 49, married or in union, experience physical, sexual, or emotional violence by their husbands or partners. Among the married women who have experienced the sexual violence, 92% of them, they report their husbands as perpetrators. And during lockdowns, everyone of us know this violence against women was a pandemic in a pandemic, and lockdown has brought many, during COVID pandemic, its social and economic impacts. They have exposed the real face of men when the men they were at home. Globally, as many as 38% of all the murders of the women are committed by their intimate partners. So coming to what are the root causes for gender equality? My first question to our panelists, let us go to the root causes. For this, I just wanted to quote the Hindi films, जिनको देख देख कर हम लोग बड़े हुए हैं, हमेशा उनका अनुकरण करते आए हैं. तो मेरा पहला सीन ये रहा और मेरा पहला सवाल है डॉक्टर कांचन सोटी जी से. उन्हें ये वीडियो सुनकर कुछ अटपटा सा लग रहा है क्या? Sorry. Kanchan?
Yes.
Yes.
In our society, you have rightly said, actually, we have fundamental right of equality. But what is expected from a girl child and what is expected from a boy, that those things are imbibed, that behavioral patterns are imbibed from the childhood, that the boy should be strong, he should be independent, he should be aggressive, whereas the girl should be sympathetic, submissive, tolerant, and she should be dependent on somebody. So this is the main thing which is imbibed. So that leads to the problem. And second thing, we have always still in our society, male child is preferred over the female child. There are more of female feticides we have seen, and female is considered as a burden. So these are the main things. What the video you have shown, Alka, that shows that main identity shown as a powerful man, and while the girl has to be beautiful and all her these things. So this is where the root. This is where the root causes.
Thank you, Kanchan. Ekdam to the point. The gender rules and stereotypes, they always and always are suggestive of subordination of women. Coming to the next video. ये देखिए अगला सीन. यहाँ पे भी हम ये सब हम महिलाओं के साथ अक्सर होता देखते हैं, पर मजाल है कोई कुछ कहे. Manisha, what is your view on this?
Ma'am, the audio of these videos is not heard. Huh?
Okay.
The audio part of the video was not heard at all, even the previous one.
Okay.
Here you Alka.
Just a minute. Just a minute. Prakash, are you there? Sir. हाँ प्रकाश, याचा ऑडिओ कसा ऑप्टिमाइज करायचा रे?
मला मिनिमाइज करा त्याला. करा मिनिमाइज.
म्हणजे कशाला प्रेझेंटेशनला?
हां मिनिमाइज करा ना.
आता काय करायचं बघ?
मॅडम मला स्क्रीन दिसत नाहीये तुमची.
तू मिनिमाइज करायला सांगितलं ना?
हो मिनिमाइज केलं पण आम्हाला दिसत नाही इथं मिनिमाइज झालं. मॅडम खाली कॉर्नरला बघा ना एक व्हॉल्यूमची बटन आहे. तिथे म्यूट असेल बहुतेक. बघा खाली कॉर्नरला.
एक मिनिट. मला कुठेतरी चुकतंय. जस्ट अ मिनिट. सॉरी फॉर दॅट. आता आलाय का माझा व्हिडिओ दिसतोय का? स्टॉप शेअर करू का पहिले?
हो एकदा स्टॉप शेअर करा मॅडम. आणि खाली बघा मॅडम व्हॉल्यूमची बटन असेल, आयकॉन असेल खाली कॉर्नरला.
म्यूट आहे, स्टॉप व्हिडिओ आहे.
म्यूट आहे ना? म्यूट नका, अनम्यूट करा मॅडम.
आय एम तो अनम्युटेड आहे ना रे.
नाही तुम्ही अनम्यूट नाही मॅडम, याचं लॅपीचं लॅपटॉपचं सिस्टम. हा लॅपटॉपचं हे असेल मॅडम, म्यूट असेल बहुतेक.
एम आय सीन नाव? मी दिसते?
हो तुम्ही दिसता.
व्हिडिओचा आवाज नाही येत आहे.
हो व्हिडिओचा आवाज नाही.
हा
तुमचा आवाज.
सॉरी जस्ट अ मिनिट. I'm not able to do that.
प्रकाश ते झूमच्या सेटिंग मध्ये असेल ऑडिओ, तिथे म्यूट असेल मॅडमचं.
ते स्लाइड मध्येच असेल.
एक मिनिट मला ना कुठेतरी एक लक्षात आलं होतं, मागे तुम्ही सांगितलं होतं मला करायला तसं.
Dr. Alka, when you go to the Zoom settings and there probably you have muted the audio, then you have to unmute it.
Okay. Sorry sir. So how to go about it? प्रकाश कसं जायचं? तुला प्रेझेंटेशन पाठवू का? काय करायचं?
स्क्रीन शेअर करा ना तुम्ही तुमची.
मी शेअर केली तरी पण होत नाही ना.
एकदा करा.
इथे ओके. शेअर साऊंड आहे इथे. करू ऑप्टिमाइज करू की ऑप्टिमाइज फॉर व्हिडिओ क्लिप करू की शेअर साऊंड करू?
शेअर साऊंड करा.
ओके केलंय.
Share the sound.
नाउ इज इट सी? आता बघ. आता करू.
प्ले करा मॅडम.
यस.
तुम जर्नलिस्ट का तो काम ही सब कुछ बढ़ा चढ़ा के लिखना है, बड़ा चढ़ा के. रियली सीरियसली, जैसे आजकल तुम लोग विमेन्स इश्यूज पे लिख रहे हो. आई मीन तुम्हारी माने तो ऐसा लगता है कि हमारे यहाँ हर औरत हर वक्त हर जगह अनसेफ है.
हर सर्वे तो यही कहता है, लेकिन बात सिर्फ सेफ्टी की नहीं है, मतलब इक्वल राइट्स की है, बराबरी की है.
प्रिसाइसली, तो बदलाव आ रहा है. स्लोली बट श्योरली थिंग्स आर चेंजिंग. मेरी फैमिली को ही ले लो. मेरे डैड की जनरेशन तक किसी औरत ने काम नहीं किया, नेवर. फिर मैंने आयशा को अलाउ किया बिजनेस चलाने.
तुमने आयशा को अलाउ किया?
यस.
और उसे तुम्हारे परमिशन की जरूरत क्यों है?
You know what I mean?
No, I don't know what you mean. जब तुम किसी को अलाउ करते हो, तुम अपने आप को एक अथॉरिटी, एक कंट्रोल की पोजीशन में डालते हो, और ये बराबरी नहीं हुई. बट थैंक यू. जो मैं कहने की कोशिश कर रहा था वो तुमने साबित कर लिया. Cheers.
Manisha, what is your opinion about this?
And this video basically depicts patriarchy, that is जो पुरुष प्रधान समाज है. As we know, patriarchy basically
तुम जर्नलिस्ट का तो
is a social system in which the man holds the primary power. और अगर characteristics पर comment करें तो it basically means male dominance. Say we always say the father is the head of the family. Male centeredness. लड़का हुआ तो अरे मेरे राजा, अरे मेरे सोना. That is the way people talk. Male oppression और restrictions on women. अच्छे घर की औरतें रात को लेट घर से बाहर नहीं जाती. That is the way we hear people speaking, you know. And then the male desire to control everyone around are basically what we observe in this patriarchal society. And we see it in different forms, we see it at different times, and we see it in different cultures. To put my viewpoint, I'll tell you an example. Say in the household, housework, raising the children are basically considered as a female domain. आप 10 डिलीवरी करके भी घर पर आएंगी और बच्चा खाना मांगेगा तो मैक्सिमम टाइम घर में, मैक्सिमम कल्चर्स में माँ ही उठेगी. That is basically there. Another example to put forth is paid work, या जिसे हम रोजी रोटी कहते हैं. रोजी की बात करें तो 6 घंटे अगर लेडी काम करती है तो 300 रुपया, और वही अगर आदमी काम करे तो 500 रुपया. Women are likely to be paid less, Alka, you know.
Yes.
Parliament या state representation और all these formal power distributions. करोड़ों में एक ही इंदिरा गांधी मिलेगी, करोड़ों में एक ही सुषमा स्वराज मिलेगी, या करोड़ों में एक ही जयललिता होगी, बट करोड़ों में ये इसमें भी मेल डोमिनेंस आएगा ही. वायलेंस, कितनी बार आपने आदमी को मार खाते देखा है? Maximum times it is only the females who are prone to be abused.
Yes.
Sexuality, femininity. आप अगर इस शब्द को देखेंगे तो when it comes to women, it is mostly treated in the negative way. Here we can consider that patriarchy is the main reason behind this violence against women, which can take any form. It can take a simple form of an abuse, it can be battering, it can be rape, it can be murder, or it can be anything against our women in this contemporary society. This is my view, Alka.
Yes,
Over to
very
you.
true, very true, very true. So, what next? Vaishali, are you there? तो ये क्या है?
जो मर्द होता है उसे दर्द नहीं हो.
What is this type of mentality?
Yeah. Okay. Thank you so much for making me a part of this discussion. A topic which is really, we as gynecologists, obstetricians have a responsibility towards the society. These are it is as the male-dominated society, and what Manisha said rightly, patriarchal society. So this is an extension of that. We call it toxic masculinity. It is a term which is used to define certain traditional characteristics which are attributed to manhood and associated with men. There are certain cultural and societal pressures which and men are expected to behave in that way. They need to be tough, strong, emotionless, then violent, aggressive. What we usually hear, boys don't cry, be a man, then boys will be boys. These are usually depicted in our ads. Dolls are only for girls. So men are expected to behave in a certain way, and then they usually this stereotype which creates an unhealthy and unrealistic understanding of what it means to be a man in today's society. Men are expected to be protective, breadwinners, or leaders, and terms like aggression, anger, selfishness are associated with men. Then these beliefs are based on unproven biases, and boys and men are taught right from childhood. Boys are taught to be falsely believing this, and in the process they are harming themselves and the society also. In the long run, ultimately this is going to contribute to gender-based violence as well as sexual harassment.
So, is it something like this?
बाइक क्यों चलाते? माचो दिखने के लिए. जीन क्यों पहनते? माचो दिखने के लिए. पर ये माचो है कौन?
In reality, the real men they are made and not born. Why they need constant validation? They should not need constant validation. We female, we don't need constant validation. We progress on our own, isn't it?
Yes. Very rightly said.
So coming to sexism, it's an ideology based on the belief that the male person is superior to the female. Anything you want to add, Kanchan madam?
Yes, this picture, what you're showing, the keh diya na bas, that is again an example of patriarchy. The male person is the only one decision maker in the family. Others' views cannot be considered, or they don't give importance to the others' decision. That is the example which has been very nicely shown here.
And yes, the zeros on the paycheck do matter because we all ladies work very hard for it, isn't it?
Yes.
So violence against women, it's an act of gender-based violence that results in or is likely to result in physical, sexual, psychological harm or suffering to the woman, including threats of such acts, coercion, or arbitrary deprivation of liberty, whether occurring in public or private life.
Globally, 1 in 3 women and girls worldwide have experienced physical or sexual violence during their lifetime. Less than 40% of them seek help of any sort, and of these, only 10% seek support from police. And of all women who were victims of homicide worldwide in 2012, 50% were killed by intimate partners or family members. This situation cannot be overlooked.
So when the problem is known, people know the cause, the culprits, why don't we complain? Women do not complain because of many reasons. First of all, they consider it as a family matter. They consider they think of their children. They think of they are financially dependent on the men. Today, scene hasn't changed. Even earning women today cannot spend without the permission of her husband, and there is a fear of repeat more and different type of violence from the men. और सबसे बड़ी बात तो जनाब ये है कि इन्हें समझ ही नहीं आता कि इन पर अत्याचार हो रहे हैं. Especially when the partner is loving, caring, and running the family, they have seen their mother and other ladies in the society tolerating all the violence, and they consider it as a normal.
Yes.
Yes.
They consider it as a normal part of marriage.
Yes,
Yeah.
yes. With this brief preamble, let me start with this topic. Kanchan madam, this clip is for you, please.
Yes.
Section 9 restitution of conjugal rights. ये लीगल नोटिस है आपको घर वापस ले जाने के लिए. मुझे नहीं जाना है. What's the real story? His family? No. He's having an affair? No. You're having an affair? No. So just one slap then. Just a slap? पर नहीं मार सकता.
So Kanchan madam, what is your what is
the
this
type
kind of violence? Yes.
Yeah, this is the domestic violence, what we can say, intimate partner violence.
Can you tell us the types of violence, various types of violence?
Yes, it could be physical.
Section 9.
There is a physical abuse, and it could be emotional and could be combined. Most of the time in domestic violence, the combined pattern is seen. Always there is a criticism for the criticism of females and all other things, so that she's emotionally abused most of the time. And then the physical violence also is very, very common, like kicking and slapping. This is very, very common, and it keeps on going. Women tolerate for a long, long time. As you rightly said, that they don't complain, and hardly 10% of them seek police help. So that again gives good encouragement for the male partner, that they can, and they consider it as a normal part of their marriage. So that is the main thing. It is a domestic abuse or the intimate partner violence, and it is
Very
a type
well
of behavior.
Yes, yes.
Yes.
So next scene is for Dr. Manisha. So basically, Domestic Violence Act is there. It covers physical, sexual, verbal, and economic abuse. It grants immediate protection, punishes the abuser with imprisonment up to 3 years. Yeah. This next scene is Manisha, aapke liye. What kind of violence is this?
मैं बैंक से आ रहा हूँ. पैसे कहाँ के किरण? जवाब दो, क्या किया पैसों का?
मैं खर्च किया.
वो पैसे मेरे थे, तेरे बाप के नहीं.
खर्च किया. Food for your sons.
चला दें तेरे इस खूबसूरत चेहरे को जिस पर इतना घमंड है. बकवास करती है. ये मेरा घर है.
Manisha, are you there?
Yeah, I'm there, ma'am.
Yes, yes.
As you rightly put on the screen, ma'am, it is intimate partner violence. It is basically when a person behaves in a way to control the other person, specifically in an intimate relationship. It means it can exist between not only husband, wife, it can even exist between girlfriends, it can exist between boyfriends, romantic partners, or lovers,
Yes.
And this can take any form. It can be, as it was shown, a physical abuse, where you know it as शारीरिक प्रताड़ना, जहाँ आप मार सकते हैं, you can punch, which can even result in broken bones. It can result in sprains, or which was shown in the picture, financial abuse. आप कमा तो रहे हो, but आपको spend करने की छूट नहीं है. All investment decisions in the family to be made by the husband. तुम ये पहनो, तुम ये मत करो, तुम यहाँ जाओ, तुम ऐसा करो, तुम वैसा करो. Things usually start in this simple form, and then take a very gross form in the form of emotional and psychological violence, which turn up later.
Is there any cycle of abuse? Yes, yes.
Yeah, basically the victim lives in constant fear, and often with this lives in chronic stress. She stays silent because she often feels she needs to protect herself or protect some near or dear ones from her. And sometimes this can result in such a bad violence form that people don't even share it with their best friends, because once the reason basically can be these numbers are not reported, or even if they are reported, there are hardly any reporting grossly. In other words, they are just underreported. They may happen in hundreds, but hardly people have the courage to report 2 or 3 of them. Here, whether they want to have sex or they don't want to have sex, they are compelled to satisfy the other partner. It can result in any other forms of abuse, resulting basically on the toll or ill health of the victim. So the take-home message for this slide basically will be, remember that the victim is not to be blamed. She did not cause the abuse. And if you care for the victim, then intimate partner violence, one should seek assistance in the form of either a counselor, or there are many sites which do offer you helplines. And the most important women helpline number to carry home will be 181.
Yes, we will show them later on. So basically, the low levels of education, history of exposure to child, the child, they usually see this kind of behavior from their fathers and their forefathers, and the family violence, the marital discord, all these factors, they are responsible for this immediate intimate partner violence. Coming to criminal intimidation, when someone is threatening to cause death, hurt you grievously, or destroy your property, the Section 503 IPC can cause imprisonment for up to 2 years, or fine, or both. Coming to this type of violence, Vaishali, what is your view?
पैसे कहाँ से आए? पैसे कहाँ से आते हैं, मर्द कहाँ से लाता है, ये पूछने का अधिकार औरत को नहीं है.
In brief, Vaishali, please.
पैसे कहाँ से आए?
Okay, this is a new term. Okay, economic. As being a society,
it's a mix,
male-dominated society, the financial rights and all are with the men. So when we say of femicide, it is a term.
No, femicide is later on. It is an economic type of violence.
Okay, sorry.
It's a psychological violence, emotional. It's a combination of all.
It's a male-dominated. Yeah, it's a combination of psychological violence and economic violence. That the
emotional.
The men are holding the rights to spend and all, and they always keep on questioning the females, the female partner. How much, who has given the right to spend, or how much she can spend. Even it is actually existing, even if the females are earning, still the men are holding the rights to spend. They don't have the economic liberty to have their
they
own.
make the women emotionally very labile.
Yes.
So what you were saying about femicide, something you were saying about femicide?
It is the most extreme form of
To save the honor of my family and my community, I killed her.
Yes.
Honor killing is a part of femicide. Is a term which is used for intentional killing of a woman or a girl because
she's a woman.
Female. Yeah. And this term was popularized by Dr. Diana Russell. She was a South African female activist, and she had popularized this term. And it is persistent globally, though surprisingly we find that in North India the prevalence is quite high of femicide, but in Latin American countries it is more than that. So, and the incidence of femicide has gone up during the lockdown in these last 2 years because more and more victims are trapped at home, and mostly the abusers are their partners. So and the root cause of femicide is mainly gender inequality and gender-based discrimination. The types of femicide can be, as you have shown in the clip, honor killing, then there can be dowry-related killings. Then non-intimate femicide is also quite common, especially in sex workers and bar girls.
Yes,
Then,
we will move further.
Yeah.
Vaishali, we will move further.
वही तो मैं कह रही थी
And what about this? The barbaric act. Kanchan madam, will you
Yes,
light on
yes,
this?
this is a clip of acid attack. This usually it is mainly seen in the romantic relationships and usually in the teenagers when the girl refuses or rejects the romantic advancement of a male partner. She is either threatened and or sometimes the act is actually done in a view to disfigure her. So that is the main intention of a male partner, to disfigure her face, and so that she lives the whole life in a shame. So that is acid attack. It is very common, reported very less.
Yes, I request the panelists to be precise. Yes. So what we can do, we can report to the trusted person and police if the attack is threatened or attempted, and it is punishable under this action under the section 326B IPC. And the next important thing is the new on the horizon, which is very much talked now, is a female genital mutilation. Vaishali, do you want to say something about this?
Just in short, I'll say female genital mutilation is a procedure performed on women or girl to alter or injure her genitalia for non-medical reasons. This is very specific. So mostly it involves partial or total removal of the external genitalia, and it is a violation of a fundamental human right.
It is also called as female khatna. Female khatna.
Khatna. Every year, almost 4 million girls worldwide are at risk of getting genital mutilation. So, and it is practiced as a social norm in many countries as part of gender inequality in order to suppress the women's sexuality, and some consider it as a part of their religious beliefs.
Yes,
so,
yes. Now we are very much techno-savvy and technologically advanced. So here comes the cybercrime. Manisha, do you want to say something on this?
Speaking directly on the by categorizing them, the first, as you put, it is cyberbullying. It can be simple by posting false online stories, photoshopped pictures, jokes, humiliating content or comments basically on the social media. The intention is just one, सामने वाले को नीचा दिखाओ या फिर ये कोई एक बदला लेने का तरीका भी हो सकता है. Second type, basically common, is cyber teasing. Here they just share vulgar, derogatory or harmful messages on social platforms. There can be cyber stalking, which is basically hate speech, hacking of your accounts, maybe your Facebook accounts, or you may be followed using
and
GPS.
They say it's permanent. They say you cannot erase it. It's permanent.
But you cannot erase it because there is no, once it is hacked, you either have to close down the account or report. Otherwise, there's no way going out. Then there is another thing called as catfishing. Here, someone is harassing someone by creating a fake media profile in the name of others. This may be basically for financial gains or can be a simple romance scam. Doxing, hacking your personal information as name, address, credit card or debit card details. Basically the intention being again a bad motive. Cyber trolling, आपने कोई सोशल मीडिया पे कमेंट डाला और तुरंत आपके कमेंट पे नया कमेंट आ गया. And this is going to be followed all the time. This is trolling. Swatting, this is, I would say, beware all online gamers. Here there can be a hoax call made to the police, and immediately next moment you have the quick response team.
How to manage it? Manisha, how to manage it?
Ma'am, the basic is please log out all accounts once you have used them. Always learn how these accounts, there is a privacy mode for all these accounts. You have to use all the privacy modes. Limit posting of your photos and pictures on the social media. You can help by contacting the cybercrime cell immediately, or you can log an online complaint on www.ic3.gov. This is the best way.
Yes, yes. Thank you, Manisha. Coming to sexual violence, which means someone forces or manipulates someone else into unwanted sexual activity without their consent. These are the different types of sexual violences: trafficking, starting from trafficking, cyber harassment, voyeurism, degrading the sexual imagery, indecent exposure, stalking, sexual abuse, and rape. And there is workplace sexual harassment as well. We all know these all things are punishable under section 354 IPC with 1 to 5 years and a fine. They are punishable under Nirbhaya Act 2013 and section 375 IPC. Section 354 IPC protects against sexual harassment and unwanted physical contact. There is POCSO Act 2012 and which protects the minors from sexual abuse. So coming to measures to eliminate the violence against women. तू मेरी बेटी नहीं बेटा है. सबसे पहले तो ये मेंटालिटी स्टॉप करना जरूरी है. Reinforcement of patriarchy, ironically used as a compliment for a girl who has made her parents proud by performing well. The wow mindset has to be changed, which is nurtured since childhood. The toxic mentality has to be changed. It is based on the way a child is brought up. So what to do if you know someone is abused? Manisha? One should not be afraid. Yeah, Manisha, please unmute yourself. You should listen to the victim story, reassure them to stay brave, believe their story, believe them. Yes, जो भी बता रहे वो सही है. You should not blame the victim. Keep an eye on the situation to make sure it is not going too dangerous. Ask them about their immediate plans. Report to a higher authority, the teacher, the parent, the guardian, the husband, or the police. Respect their decision, have resources to keep the conversation going, and be careful that any action taken do not harm you or the victim. And what to do if you are yourself being abused? Manisha?
Recognize the toxic behavior of the cycle of abuse. Protect yourself by leaving from the vicinity of the abuser. Avoid escalating situations. Report the incidents. Keep evidence of the abuse by recording and photographing. Plan a safety kit in case you have to leave your home in a hurry. And let someone you trust know of the abuse. It can be a friend, your doctor, or the concerned police officer of the station close by.
Yes. Ask the victim to speak out. Just ask them to speak out. That is very important. Take a stand because abuser is afraid of your voice. It's very important to speak up. Don't let another generation of victims to be there. Give the victim a platform to speak. Believe the victim. Don't blame the victim. Stand up for justice. Don't let the people forget that once someone commit abuse, they are prone to do it again and again. Manisha, you were talking about this safety using technology. Do you want to talk on this?
Safety using technology is basically to avoid cyber harassment. You can download and familiarize yourself with the safety apps. There are many spy care apps, Smart Sheher, Women's Safety Shield Protection, V2, Scream Alarm, Suspect Registry, Be Safe, Abhaya for legal advices. These are all apps which can be downloaded and used basically when you are traveling late at night or when you are doing some legal work on your device, that is your telephones. Share your live locations when you are traveling with those you trust. Take pictures of the taxi driver and the license plate before you board in. And in case of emergency, activate the location and app so that you are being traced every time wherever you go.
Yes, yes. Thank you. Whom to contact? Vaishali, do you want to read the slide?
The All India Women Helpline, women in distress can call at 1091. Then for domestic abuse, the helpline number is 181. Then the National Commission for Women.
They can take a snap because we won't be able to remember. Yeah, yeah.
Okay.
And local police
champions
stations and NGOs should be there. Yeah. This is the distress signal. Kanchan madam, will you describe this?
Yeah. Yes, distress signal, just put your palm like this. Just tuck your thumb and do like this. This is a distress signal. If you see this signal, you have to help the victim. Okay, that is very important. If you see this signal, anytime in the taxi or anything, you have to help that woman.
Your palm to the camera.
Palm to the camera.
The person you're seeking help from. Tuck your thumb. Trap the thumb with the remaining fingers.
Yes. So whenever you see the distress sign, you should help the victim.
Yes.
Yes. These are the gender-based violence command trying to report gender discrimination and abuses. These are the numbers, the domestic violence and the gender equality, and to report child abuse and crime stop. All these numbers will be covered in the recording, I believe. Yes. Coming to guidelines for medical legal care for the survivor of victims of sexual violence. This is very important. Nowadays, we start using the term survivor, that the person has agency and she's capable of taking decisions despite being victimized, humiliated, and traumatized due to the assault. Encourages them to believe the person and not pity her. Victim is considered as a person who doesn't possess agency and is not fully capable of comprehending the situation at hand because of the victimized faced. The points of certain important points. The different types of sexual violences are given over here: the rape, the forced sex, systematic rape during armed conflict, sexual slavery, unwanted sexual advances or sexual harassment, sexual abuse, and so many things are given over here. The health consequences and role of health professional is very important. The health consequences, the fatal health consequences can be homicide, fatal, like homicide, suicide, or maternal mortality, or infant mortality, or AIDS-related mortality. And the non-fatal outcomes, they are the acute physical health. There can be injury, there can be shock, there can be disease or infection. In chronic physical health, the patient can be disabled, the victim can be disabled. There are somatic complaints. Sometimes there is chronic infections because of the unprotected sex, chronic pain, gastrointestinal complaints, irritable bowel syndrome, eating disorders, alcohol and drug abuse, headache, fatigue, and fibromyalgia. And in reproductive health, if you talk of, there are unprotected sex. Because of unprotected sex, there are unwanted pregnancies and abortions and risk of STIs and HIV. And there are multiple menstrual disorders which can be related to this. In mental health, there is post-traumatic stress, depression, anxiety, fear, anger, aggression. All the time the victim, the survivor is under tension. And social well-being, the patient want to try to isolate themselves. They consider it as a stigma, and there is loss of role of functions in the society. Every hospital should have their own SOPs to provide comprehensive services for the smooth handling of the cases and clarity of roles of each staff, to have uniform practice across all the doctors in the hospital. The SOP must be printed and available to all the staffs of the hospital. Certain important facts. Any registered medical practitioner can conduct the examination, and it is not mandatory for a gynecologist to examine such a case. But it should be preferably done by a female doctor, but it should not be denied if female doctor is not there. A male doctor in presence of a female attendant can do the examination. Do not deny or delay the treatment or examination or collecting evidence. In case of a minor person with disability, his or her parent, guardian, or any other person with whom the survivor is comfortable may be present. Police should not be allowed in the examination room. On request of survivor, her relative can be there. Responsibility of the examining doctor is very important. Admission, evidence collection, or filing a police complaint is not mandatory for providing treatment. The important part is the history taking in the examination should be carried out in a complete privacy in a special room set up in the hospital for examination of sexual violence survivor. These are the things which are required for collecting and preserving the physical evidence following a sexual violence. The forms for documentation: large sheet of paper, paper bags, catchment paper, comb, nail cutter, wooden stick, small scissors, urine sample, cotton swabs, tubes and syringes and needle for drawing blood, distilled water, disposable gloves, glass slides, and so many things. The survivors of sexual violence should receive all the services completely free of cost. That is very important. The OPD, the inpatient registration, lab, radiology investigation, urine pregnancy test, medicine, everything should be free for her. The casualty medical officer must label the case paper for any sexual violence case as free, so that free treatment is ensured. And a copy of documentation, including that pertaining to the medical legal examination and treatment, must be provided to the survivor free of the cost. If any medication or investigations they are not available at that time in that hospital, the outsourcing can be done, but it should be compensated back. All the collected samples for evidence must be preserved in the hospital till such time that police are able to complete their paperwork for dispatch to forensic lab, including DNA. After the examination is complete, the survivor should be permitted to wash up using the toiletries and the clothing provided by the hospital if her own clothes are taken as evidence. Admission should not be insisted upon unless the survivor requires indoor stay for observation or treatment. I have 10 minutes to go, just quickly wind up. Medical examination and reporting for sexual violence. First of all, the initial resuscitation is important, that is first aid. Then there is informed consent for examination, evidence collection, police procedure, detailed history taking, medical examination, age estimation by physical, dental, or radiological means if requested by the investigating agency, evidence collection as per the protocol, documentation, packing, sealing, and handling of the collected evidence to the police, treatment of injuries, testing or prophylaxis for STIs, HIVs, hepatitis B and pregnancy, psychological support and counseling, referral for further help in the shelter home or the legal support. Some instructions for the doctors. Regarding the informed consent, doctor shall inform the person being examined about the nature and purpose of examination, and in case of child, to the child's parent, guardian or person in whom the child reposes trust. This information should include the medico-legal examination is to assist the investigations, arrest and prosecution of those who committed the sexual offense. And this may involve the examination of mouth, breast, vagina, anus and rectum. To assist investigation, forensic evidence may be collected with the consent of the survivor. The survivor or the child, or in case of child, the parent, guardian, or person in whom the child reposes trust has the right to refuse either a medico-legal examination or collection of evidence or both. But that refusal will not be used to deny treatment to survivor after sexual violence. As per the law, the hospital or the examining doctor is required to inform the police about the sexual offense. However, if the survivor doesn't wish to participate in the police investigation, it will not result in denial of treatment for sexual violence. Informed refusal should be documented in such cases. Coming to pervaginal examination, that is two-finger test, must not be conducted for establishing an incidence of sexual violence, and no comment on the size of vaginal introitus, elasticity of the vagina or hymen, or about past sexual experience or habituation to sexual intercourse should be made, as it has no bearing in the case of sexual violence. No comment on shape, size, elasticity of vagina. Injury documentation is very important. Injuries must be recorded with detailed size, shape, and contour and color. And bleeding, swelling, tenderness, discharge. This includes both micromucosal injuries which may heal within a short period of time, and that of a severe injuries that would take longer time to heal. If the past history of sexual violence is reported, then record relevant findings. Sexual violence is largely perpetrated against female, but it can be perpetrated against male, transgender, genders, and intersex persons. The nature of forensic evidence, it totally depends on three factors: nature of sexual violence, time lapse between the incidence of sexual violence and examination, and whether the survivor has bathed or washed herself. The issue of whether an incidence of rape or assault has occurred is a legal issue and not a medical diagnosis. Doctor should not, on the basis of medical examination, conclude whether rape or sexual assault has occurred or not. Doctor should record the medical findings in the medical report. Immediate drafting of provisional opinion after examination of the survivor on history and clinical examination. Normal examination findings neither refute nor confirm sexual violence. Circumstantial other evidence may please be taken into consideration. Absence of injuries may be due to inability of the survivor to offer resistance and delay in reporting for the examination. Treatment guidelines and psychological support. Sexual transmitted disease, we all know how to treat. Pregnancy prophylaxis in emergency contraception can be think of. And lacerations, they should be cleaned with antiseptic or soap and water, and injection tetanus toxoid, and if needed, they should be repaired and sutured. Follow-up is very important. One should emphasis on the importance of follow-up is must. Call the survivor for re-examination 2 days after the assault to note the development of bruises and other injuries. Thereafter, at 3 and 6 weeks, document all follow-ups, it's must, and repeat tests for gonorrhea, pregnancy, and VDRL after 6 weeks, and assess the psychological status of the person and provide psychological support. So these are these components of a comprehensive healthcare response. They are given in a table form. Coming to guidelines for interface with other agencies such as police and judiciary. We should have some standard operating procedure. When a survivor reports to police, the police must take him or to the nearest health facility, examine him, and doctor to ask survivors whether they were examined elsewhere before coming to them. And if they are examined somewhere else, they should provide the documentation of that doctor. And in that case, health professional must refrain from carrying out any examination just because the police have brought their requisition and also explain the same to them. Health sector has a therapeutic role and confidentiality of information should be there, privacy should be there. Police should not be allowed to be present when the details of the incident of sexual violence, examination, evidence collection, and treatment are being sought from the survivor. Police cannot interfere in duty of doctor. They have to wait for you. In case of unaccompanied survivors brought by the police for sexual violence examination, police should not be asked to sign as witness. Doctor should sign. Doctor must not entertain questions from the police such as whether rape occurred, whether survivor is capable of sexual intercourse, or the person is capable of having sexual intercourse. And guidelines for interface with other agencies such as police and judiciary both recognize that any registered medical practitioner can carry out this medical legal test. Interface with health system and public prosecutor. Doctor must review the notes of the case to equip him or herself with the history that has been provided by the survivor to the doctor, the police, and the magistrate. If there is any difference in the histories, the same should be clarified in advance with the public prosecutor. It is possible that the survivor revealed additional information to the doctor based on her comfort than the police or the magistrate. This happens many times. Examining doctor should prepare themselves well in time with the case documents before reaching the court, and effort should be made to dialogue with the public prosecutor. Interface with health system and judiciary. Doctors are considered as expert witness. A medical opinion has to be provided in the following aspect: if the survivor was administered drugs or psychotropic substance, alcohol, etc. Survivor has an intellectual or mental disability or physical health consequences such as bruises, contusion, contused, lacerated wounds, tenderness, swelling, pain, maturation, and all. Age of the survivor if she doesn't have a birth certificate. Absence of injury can be there, but the doctor has to give them as per his medical knowledge. Lack of injuries can be based on the time lapse between the incidents and reporting of hospitals. And many times because of fear, shock, surprise, and the under influence of drugs, the child or adult survivor unable to resist the birth pattern. The examining doctor will also have to provide a medical opinion on negative findings based on the related to forensic lab analysis. Yes. The examining doctor should clarify in the report that normal examination findings neither refute nor confirm whether the sexual offense occurred or not. Medical opinion cannot be given on whether rape occurred, as rape is a legal term. No comments on past sexual history, status of vaginal intercourse. It's unscientific and considered as biased by the court. The doctor appearing in the courtroom can be different from the one who carried out the medical examination. So the doctor making the court appearance should be thorough with the case file of the survivor, such as documentation of history, examination findings, and clinical interface drawn by the examining doctor. Interface with child welfare committee, we all of us know. I'm skipping this slide. So basically important is report the incidents to the local police, special police unit, record statement for police within 24 hours, go to hospital or shelter room for medical examination by female doctor, record statement for magistrate, and special court trial within 1 year. Coming to the role of health sector.
Is a place they can go. A visit to a local clinic is often one of the few opportunities women have to go out alone. And it's important for doctors and nurses to make sure this isn't a missed opportunity. When doctors, nurses, and midwives listened with compassion, survivors are more likely to share their story. When they ask the right questions, they can uncover what is really happening and challenge cultural attitudes that say it's okay for a husband to hit his wife. They can reassure women that it's not their fault and can work with women to help them stay safe. And where necessary, connect them with other services that can provide, for example, shelter, psychological support, legal services, and financial opportunities. More women can find their way to a life without violence when changes are implemented across healthcare and other systems. Changes such as private rooms for consultations, training that enables doctors and nurses to respond better to women's needs, and raising awareness of the harmful consequences of violence for women and children and how to prevent it. Making these changes helps foster a culture where violence is unacceptable and where women have the courage to speak out. Imagine if that could happen to each and every one of those 800 million women.
So we have seen the role of health sector. So friends, there is a man in every woman, he in every she, and a hero in every heroine. Give her an equal opportunity and you will see the benefit with your own eyes. Move ahead of the stereotypical gender binaries. Look around and there are not many things other than masculine and feminine. Build a society that gives an equal opportunity to all. Wow is preventable. Violence against women and girls is preventable. The health sector has a very important role to play in. The women doctors, we call them as Shakti Rupas because they act as a shock absorbers for the victimized patients when they come to the doctor, lady doctor. And the main doctors, they are the gender gap bridgers because they act as a role models for the men in the society. So violence against women So violence against women endangers the security of our own societies and it should end, and we should be having a gender neutral world. We should hold each other accountable. Thank you so much for your patient hearing, and I pay my deepest gratitude for this opportunity on behalf of my panelists as well as me. Thank you so much.
Thank you, Dr. Alka.
Thank you.
Thank you.
Thank you, Dr. Mukherjee ma'am, for a very informative and nice moderation of panel discussion. was a very informative, and I had to learn a lot of new lessons from it. Thank you, ma'am. Next slide, please.
Shikesh,
Yes, sir.
there's a question from the delegate, especially Dr. S.K. Kunshi, who is a senior dermatologist from Amravati. Dr. Alka, he has asked a question: how far the modern lifestyles of the changing lifestyles are responsible for increased violence against the girl child?
I don't feel modern lifestyle has increased any chances. It's the mindset which is not changing, sir. What do you say, Kanchan madam?
Yes,
It's
you
a
have
matter
very
for debate for
rightly,
us.
yes, you have very rightly put it. It is the mindset you have to change. That is the thing, and it is imbibed from the childhood. So that
If
needs to be
you
changed.
want to say about the clothes the women are the girls are wearing today, if you are commenting on that, sir, then the things are different nowadays. Nobody listens to you. The girls, they have their own identity. They are earning now, and we all have one or two girl childs. पहले के जमाना गया है सर कि जब बहुत सारे बच्चे हुआ करते थे और काफी सारे लड़कियां हुआ करती थी. अब एक या दो होती हैं और उसके अंदर में सब लोग, मुझे नहीं लगता कि कोई आपकी ये बात पे सहमत होगा. मनीषा, व्हाट इज योर टेक?
मॉडर्न लाइफस्टाइल सर अभी कैसा हुआ है कि आप लोगों को ये पता चल रहा है कि ऐसा कुछ होता है, और पुराने जमाने में सिर्फ फर्क इतना ही था कि आपको पता नहीं चलता था कि ये सब हो रहा है. दैट इज द ओनली डिफरेंस.
बिकॉज
पहले भी था, हो रहा अभी भी है, बट अब लोग जागरूक हो गए हैं.
Women are vocal now. Vocal.
Yes, they are coming out.
Yes.
People are coming.
Especially, anything you want to add?
Yeah. We are, because of social media, this awareness is increasing. तो हम लोग एक्चुअली बॉयज को बचपन से अपब्रिंगिंग वैसी होनी चाहिए, एंड वी शुड टेल देम दैट इट्स ओके टू एक्सप्रेस योर इमोशंस. तो वो सेम होना चाहिए बॉयज एंड गर्ल्स. ऐसा कुछ डिफरेंशिएशन नहीं होना चाहिए इन द अपब्रिंगिंग. दैट माइंडसेट विल चेंज. It may take years to change, but definitely it will change.
So sensitization of our young minds is important.
Yes.
It's a need of the day.
Yes. Satish sir, I feel the answer has been given.
Yes, sir.
Any other questions, sir?
You may proceed further.
Okay, thank you, sir. Next slide, please.
Thank you so much.
The moderator for the chairperson for the next session is Dr. B.B. Sahani, sir. He is a fellow of Indian Academy of Pediatrics. He is the past president of IMLIA and IRP Medical Group, state of and the past executive board member of IRP. So I request respected Dr. B.B. Sahani, sir, to proceed.
Thank you, the organizers, and thank you, Dr. Satish Agrawal, especially. Now we have this session in which Dr. Satish Tiwari will speak first, instead of as was advised earlier. And Dr. Satish Tiwari needs no introduction. As such, he is a founder, president of the IMLIA, then founder convener of Human Milk Banking Association, president of IYCF. He is a professor of pediatrics in Medical College Amravati. He has delivered so many orations: Nirmala Kesari, Dr. N.B. Kumta, Dr. Shirole oration, Dr. Khoshal oration, and he has been an editor of many textbooks on medical legal issues and adolescent nutrition and infant nutrition. Dr. Satish Tiwari, sir, we are very eagerly waiting for your deliberations. Dr. Satish Tiwari, sir.
Yes, thank you organizers for giving this opportunity to speak in front of this August gathering. I once again congratulate Dr. Satish Agrawal and his team for taking up as a president of Maharashtra State IMLIA. Now the topic which we are going to discuss today is medical legal and ethics in curriculum. That brings us to very important question: do we need these things in curriculum, or already these things are there in curriculum? So first question, why we need these things in curriculum? We all know that few years back or few decades back, doctors were supposed to be almost God or semi-God. This was the perception of the community. And many of us had a perception that yes, really we are God. And many of us were feeling that we are sitting on some chariot or
Yes,
a
sir.
rath, and there is उनके पैर जमीन पर नहीं पड़ते. But what has happened in third
Who
millennium?
is speaker?
There is a technical explosion.
Acha, not
There is
Dr.
over
Satish.
dependence,
Yeah.
misutilization of machines and instrument, and we have forgot the importance of human touch. The purity and sanctity of art of healing, that is medicine, has been forgotten, has become a cold science rather than ethical practice. So please remember, it is not a mere academic exercise. The practice of medicine, we have to justify the decisions ethically and academically. So if you look at the background, in ancient days, the practice of medicine was supposed to be a highest standard of professional conduct, uninfluenced by motive of profit. So profit was there, but the practice should be uninfluenced by motive of practice. The Hippocratic Oath, which is almost 25 centuries old, says the practice of medicine is service to the humanity. Do away with the sufferings of the sick. Do the practice with nobility and dignity. And whether we can help a patient or not, but never do any harm to anyone. Now this Hippocratic Oath is replaced with Charak Oath. So what is the present scenario? We are in an era of advertisement and commercialization of medical practice. You can see this photograph where the weekend offer of a consultant for ₹1 only. And somebody has rightly said whether this is the advantage or whether it is an insult to the consulting doctor. On part of patient, there is a soaring expectation. There is a disbelief, hate, and suspicion. Ethics have been blown into pieces as per the opinion of the policymakers, by the community, by the judiciary. And overall, the doctor-patient relationship is in doldrums and judicial interventions are increasing. So what is basically happening in the medical practice? Policymakers have badly failed, and they have failed at each and every level. The overall situation seems to be disheartening. If you look into government health sector, there is inefficient services, and that results into promotion of the private sector. As far as the medical education is concerned, there is no control over admission policy and the fee structure. So because of the excess fees, most of the students, if they are taking loans, they become an indebted student, and ultimately by the time they get the qualification, they become indebted doctor. So overall, the legal control on the medical education or medical practice or the healthcare is only in words, and it is not in the spirit. What is happening? What is the effect? We are forgetting the scientific approach. Because of this, the patient is discredited. The practitioners are seen as a traders. You can again see this advertisement, MBBS MD radiologist द्वारा मात्र ₹1 में ultrasound, only ₹1 cost for a ultrasound. So the use of technology has been done for making the money faster, And because of this, directly or indirectly, we are getting involved in the criminal acts like violation of organ transplant, the PCPNDT Act, IMS Act, and various other acts. So now, is it we are saying that all these issues should be included in the education, or the authorities also saying that there is a need to include this in medical curriculum? This is 2011 notification of the Maharashtra University of Health Sciences. So almost now 11 to 12 years. The letter number is there. The date is 12th July 2011. And according to this academic notification of Maharashtra University of Health Sciences, the communication skill, the medical negligence, professionalism, and ethics should be included in the undergraduate curriculum for the 2011 batch onwards only. So now all these things are in curriculum for last 10 to 11 years. Not only Maharashtra University of Health Sciences, National Medical Commission or the Medical Council of India in 2018 and 19 came out with the competency-based medical curriculum, and it all includes these things. If we can see this advertisement or the cutting again, 2018 MD Medicine examination for Lucknow University, violence against doctor is used in the question paper for the MD Medicine examination. Not only this, the competency-based medical education includes ATCOM model, and ATCOM model is attitude, the ethics, communication skill. So all these things should be taught to Indian medical graduates or the future Indian medical graduate, and who should be a lifelong learner in his career. So all this thing has to be taught in future also. So how to talk to the patient, how to communicate with the relatives, following the ethical principles and professionalism, everything is now in the curriculum. So what we have to do? We have to do a lot of soul searching. The profession and commerce need to be separated. We have to decide whether we are practicing for the classes or for the masses. So whether really the 5-star healthcare facilities, the private medical colleges, the 5-star medical colleges, are they needed? Or we need a human touch and ethics in the practice. The first question that comes to us when we talk of all this, many of our colleagues ask, can an ethical doctor survive? Then, is there political willingness on the part of policymakers to change the things, or is there only apathy and anarchy of the politicians that is destroying the atmosphere in the healthcare setup? Again, to discuss this, all we have we are having the Maharashtra State chapter of the Indian Medical Legal and Ethics Association. We discussed in the morning, the aim of forming this association was to create awareness about the medical legal issues, ethics, and the various problems in the community, in the judiciary, in the society, and of course with the policy makers. This is our website where you can get details about this association. This is our quarterly journal which we are publishing, as Dr. Mukul Tiwari said in the morning. We are publishing it now for last 9 to 10 years without any advertisement from pharma company. The association is strong enough to publish quarterly journal without any pharma ad. Then of course the services which we are giving to our members, is the medico-legal guidance in hours of crisis, expert opinion, services of the legal expert, professional indemnity services, which we all know that is very important in the present era, academic activities in form of textbook and conferences. Another very interesting story is related with this textbook. We might not have discussed in past many times, but today on this occasion of this topic of medical legal in curriculum, I would like to inform you that when we were coming out with the first edition of this book, almost everything was finalized and the book was even proofread. And when it was going for the printing, the JP people told that we cannot give name textbook to this book. Then we just discussed the issues with the JP. They said nothing doing. We can write a reference book on medical legal issues. We can write desktop ready reckoner. We can write a recent advances in medical legal issue, but will not give the name textbook on medical legal issues. When we discussed in detail why the textbook name cannot be given, then they said that textbook can be only for the issues which are there in the curriculum or in the education. And at that time, we gave them the letter of the Maharashtra University of Health Sciences that all these things are already included in the curriculum in 2011. And then they finally agreed to give the name textbook on the medical legal issues. So that is why it's already come in the curriculum and not in the last 1 or 2 years, but last 10 to 11 years. So the carry home message for today's topic, the things are changing in the healthcare practice. These are the National Medical Commission guidelines in their chapter 3.5.1. According to National Medical Commission guidelines or the regulations, a medical practitioner should practice selflessness, integrity, responsibility, and accountability, respect and maintain professional boundaries between patient, colleague, and society. So professionalism should be there. Demonstrate ability to recognize and manage ethical and professional conflicts. Abide by the prescribed ethical and legal code of conduct and practice. And demonstrate commitment to the growth of medical profession as a whole in India. So these are the clear-cut guidelines about the medical graduate or Indian medical graduate. So basically now we have to decide whether we want to worship Goddess Lakshmi, which almost every society member or the community member, the judiciary, the policy makers, they feel that the doctors are after money only. Whether we want to worship the Goddess Saraswati, that means the academics. So many of us still feel that the academics has not died down from the medical practice. The third photograph is of Gandhiji, where he is doing a social service in the form of treating or giving the medical care, maybe naturopathy to the patients or to the affected person. And the fourth thing, whether we want to worship the Tanda Nritya or we want to worship Lord Shankara, which I feel many of us are now doing in the present era or the circumstances. So there is a lot of Tanda Nritya. And one of the example of this I say is the what is Vapam Gotala or the Vapam problem which has occurred in the Madhya Pradesh and the surrounding states. So there is lot of Tandav there in the medical education. So we have to decide what we want to do in the medical education, the healthcare setups, whether it is a private or government. And I once again thank the organizers for giving this opportunity, and I wish all the best to the newly formed Maharashtra State branch of the IMLIA. Thank you. Thank you.
Thank you, Dr. Tiwari, for your excellent deliberation and excellent advice about how to include in curriculum the medical legal aspects of the medical sciences. And I am very sure that there might be some, if there are any questions, Dr. Satish Agrawal can tell us.
Dr. Sani sir, if you permit me, I would like
Yes.
to Dr. Tiwari sir, because many of our colleagues they do ask, is there any course on the subject, medical legal subject, which they can do after MBBS or after post graduation, or is there any planning for such courses?
There are some certificate course run by some universities and some medical colleges, certificate course and diploma course. Now IMLIA itself is coming out with the certificate and probably diploma course. I think most probably next month we'll start with this course. Initially it will be online course. We have already finalized the curriculum. We have finalized the faculties. Now we're going to record the lectures, and by the next month, this course will be available online for all the members of the IMLIA and for the even others, those who are not IMLIA members. So this will be a course which we are coming out in the next month. And of course, as discussed, some of the law colleges and some of the universities, they are running a certificate or diploma course on the medical legal issue.
Thank you, sir, and good wishes on all support are ensured. Over to Sani sir again.
Yeah, our next speaker is Dr. Anurag Pangarikar. Dr. Anurag Pangarikar. He will speak on discharge against medical advice and discharge card. He is himself a legal professional along with the MD Pediatrics. He is a practicing pediatrician at Bid, Maharashtra. He is a organizing chairperson of Markapon 2014 and president of Rasik Foundation Bid. He is also a president of IMA Bid. Dr. Anurag Pangarikar for a very important topic, discharge against medical advice and discharge card.
Good noon, everyone. At the outset, I'm thankful to Indian Medical Legal Association for sensitizing me in these medical legal talks, because since when I have joined Indian Medical Legal Association, the orientation towards patient management had changed a lot for me. I congratulate Dr. Satish Agrawal sir and Hemant Gangulia sir for their new posts, and we all Maharashtra doctors would be very safe in hands of these two giants. I would like to share my screen. Rather, I will be concentrating more on writing discharge card. This is the place where we lack many times our junior doctor or our staff who fills the discharge card. Sometimes we sign or we don't sign and we hand over the discharge card to patient. So let's have some insight what we are doing and what we are expected to do. Actually, whenever a patient comes to us first duty of us to see is whether this is an emergency patient or a routine patient. If emergency patient, every patient we have to manage and settle and then to shift to at appropriate place. But the non-emergency patient, we have option whether we would like to take this case or we would not like to take this case. When we take this case, it is our duty to treat it properly, to investigate it properly, and to see that whatever treatment we have advised is being followed or not followed. And after that, the time comes when we have to discharge the patient. We cannot do like this, we are going to a ward and saying this patient is discharged. Not like that. It is a process. In that process, we have to discuss with the patient or with the family the process of discharge. We have to explain them that this patient has improved, further treatment can be taken at home, the danger signs to be explained. That what we have to explain will come in the last part of this session. The next thing we have to do is to hand over the discharge card, to collect bills. The advice after discharge has to be explained to the relatives. There can be two conditions except rather than only discharging. There can be forceful discharge or discharge against medical advice. Forceful discharge can be a complaint by relatives saying that we were not feeling well, still we had complaints, still the doctor has discharged us, and that's why our patient deteriorated at home. And second condition is discharge against medical advice. Few people write leave against medical advice. Few people write request, discharge on request and everything, but the meaning remains the same. Discharge against medical advice means when the treating doctor feels that the treatment has not yet completed, patient needs some more stay in hospital, some more care under him, but still patient wants to take the relatives want to take the patient at home, or the patient himself want to take discharge from the hospital. So discharge card is the only document which is going out of your hospital, and that mirrors the care given by you. There are certain records which must be given to a patient as a matter of right. So if the patient has improved and you are discharging, you must hand over the discharge summary. If you feel that patient has to be referred to some specialist in such conditions, you have to hand over referral notes. And if patient dies of natural cause and you can give death certificate, you have to hand over death certificate. So whenever you are keeping that patient IPD with you, you have to give some document to the patient when he is going out of your hospital. These records are right of patient. So all these records should be given without any charge. I cannot charge in my bill that 100 rupees for discharge card, not like that. Including all the patients who live against medical advice. So hospital bills cannot be tied up with these sensitive documents, as these documents are necessary for the patient to continue the care what you have given for the disease process. And these documents cannot be legally refused even when hospital bills are not being paid. So what is a discharge card? A part of patient record that summarizes the reasons for admissions. In simple words, these are chief complaints, and for which you feel that he has to be in your admission care. Significant clinical findings while you admitted the patient. On these significant clinical findings, what is your provisional diagnosis? Any procedures performed by you. So there are many case reports in which the procedure of operative like polypectomy was done during DNS operation, that was not mentioned. Like that, there are many case laws regarding that. What treatment was rendered by you? And at the last, what is the condition of patient on discharge? any specific instructions given to the patient or family that we will again discuss in the last part of the lecture. It is the primary duty of the treating doctor to see that all the documents with regard to management are written properly, and he has to sign it. An unsigned medical record has no legal validity. So at no place you can say that my RMO has filled his discharge card, he has filled it wrongly and like that. It is the duty of treating doctor himself. So discharge summary contains patient's name, any unique identification number, name of treating doctor, date and time of admission, date and time of discharge. I am specifically mentioning time because in critical patients where time is a matter, or during your referral, if patient admits at some other place, so the time spent from your hospital to that hospital by the patient can be a safeguard for you. In case of death, the summary of case also includes the cause of death if it is a non-medical legal case. So you must write the reason of hospitalization, chief complaints, description of initial diagnostic evaluation, probable diagnosis and alternative diagnosis, procedure and treatment provided. During your progress in the hospital, you must add any new complaint, whether added in addition to the chief complaints. What deterioration or complication adverse events occurred in your hospital. Adverse events are a part of natural disease, or that can be due to medicine. And that can be a normal complication of the disease or normal adverse event about after the drug. But you must mention it in your notes. Medications given, the dose, route, duration. Many people write appropriate medicines were given. So that is not correct. Consults. If you have consulted any specialist, that must be mentioned in the discharge card. Procedure findings, your surgical findings, test results, etc., which are significant, or if that helps in negative history, that has also to be mentioned. Allergies noticed during your hospital stay must be mentioned in the discharge card prominently. On the discharge, how was the patient doing at the time of discharge? What is your diagnosis at the discharge? Whether that patient has cured, improved, deteriorated, or died. Whether that patient is discharged to home or discharged to other hospital. And in the patient and family instructions, you must include discharge medications, the duration of discharge medications, then the follow-up when you are advising him after 5 days, after 7 days, 1 month, 3 months, like that. This follow-up is with whom? So follow-up with Dr. Pangrikar in the OPD number 12 in this hospital, 12 to 2 on this date. If you write this, that will give the patient clear-cut guideline regarding follow-up. Any dietary changes that have to be done should be mentioned. Follow-up tests or procedures. Sometimes we discharge a patient of anemia and we advise CBC after 5 days, 7 days, 1 month. That has to be mentioned in the discharge card. Then patient should be guided after discharge when to obtain urgent care. Suppose a patient of convulsion, epilepsy, you have discharged, then you have to mention it. If patient again throws a convulsion, you must take these precautions, give a lateral position, allow the secretions to drool out, and follow up in our hospital, in the casualty, or call this number like that. In case of emergency post-discharge, where to contact and consult. What is functional ability? Suppose a patient of hemiplegia cannot walk. So he cannot take care of his routine activities. That has to be mentioned that he needs support while these activities. This patient is not supposed to walk without any support or without an attendant, like that. Recommended lifestyle changes and safety tips, maybe in pediatric patients, maybe patients who have some disability, or patients of epilepsy. You have to give safety tips. that he should not be left alone near water, near fire, near high places like that. Attending physician's signature and date should be mentioned at the end of the discharge card. And the most important point, which we forget, is keep a copy with you for your records. Many times you give the discharge card, but the patient in his complaint says that all these things were not advised to us. We were not given discharge card. We were not given reports. So whatever reports, X-ray films, MRI films you are giving to the patient, you must get that signature on your paper that received these investigation reports, received discharge card, and the instructions are we can understand the instructions given by the doctor, because many times the language written on discharge card and the language which patient understands can be different. Get sign on your office copy by patient or relatives that received and understood the card and investigation reports. This is a model pro forma of discharge card. Thank you.
Hello.
Yes,
sir,
sir.
I have a
Thank
question.
you. Thank you, Dr. Anurag, for
Mahesh
your very
Baldwar.
crisp and nice presentation. And we have got some questions, and I think Dr. Mahesh Baldwar is ready with his question.
Yeah. What I want to ask you, you fill a discharge card and you have treated the patient for malaria, and there is a medicine written Lariago, and patient happens to, you have not detected, a patient was admitted with convulsion, etc., with malaria fever, and you are diagnosed febrile convulsion. Later on, they find that patient child is also mentally retarded and cerebral palsy, which you are not mentioned and you were never knew about it. And now he correlates the two. This is one scenario. Secondly, a hysterectomy patient, she develops some problems, and also at the age of 40, she has a problem with the vision, and they try to correlate the two. Third scenario is an old lady. She has some surgery done for her cancer cervix or whatever, and then later on she finds that she also developed cataract. She also developed various changes related to the skin, etc., and they connect the two. Now, in this scenario, how are you going to protect through discharge card?
Means those for the lady which was operated for hysterectomy, and now she, because these are the normal, now she has cataract, so these are the normal process, and this is not related to the procedure which was performed.
No, in all three that are medically unconnected, but
Yes,
we
sir.
are trying to connect it. That your discharge card does not mention this.
Means these diseases were existing at the time when the patient was admitted, and these were missed by the doctor, like that?
No. See, mental retardation, cerebral palsy may be there.
Maybe there.
Patient got admitted with convulsions and malaria fever. You could not detect. That is quite possible.
Yes.
But now they are having a cause-effect relationship with Lariago, because there is one decided case by Supreme Court. The lawyer gives the idea, you connect the two and let us file the case. You got the
Yes,
what
sir.
I am trying to do. So they, in such a scenario, how to protect our medical fraternity? Because here the discharge card is becoming my news rather than becoming helpful.
Yes, sir. In that condition, maybe it is not the sole cause of mental retardation that chloroquine can be the factor.
Yeah, I understand. So the problem, the what you have to, we have to see. This is a post hoc problem. and after the event is over. So it is not related to the immediate whatever causa causans. See, the immediate cause was in first case malaria, second case whatever the cause reason for hysterectomy. There are no cause and effect relations. Like, it happens in the abdominal surgery, vaginal fistula, rectovaginal fistula, and hysterectomy. That is unrelated. That is related.
That is related.
These are unrelated events. But this is what the problem which can be created by lawyer friends by connecting the two. So discharge card should, like in the retinopathy of prematurity. You are told orally, but you forgot to put in the discharge. Yes. So at that time, one does not realize, because he feels that he has done, then the child has survived, which is hardly 1.1 kilo or 950 grams, and child has, and everyone is happy. So here, there is any way we can, through discharge card, we can save our medical fraternity, because you have studied so much. So I thought that I will ask you. Anyone who are listeners and panelists, etc., can see. This is every time I get grilled over this. They bring a discharge card which does not show this, and the person is alleging something alien, absolutely unrelated to the case itself. I think Dr. Satish Tiwari is aware about this mental retardation.
Dr. Satish Tiwari.
He is aware about this mental retardation problem, Larry getting connected. So he is aware about that.
And that, that patient had family history of...
No, nothing. Actually, there are nothing. But it just, doctor, because actually you are treating malaria, 104, 105 fever, and suddenly there is a convulsion. So, and Lariogo is given. So they are trying to connect Lariogo with the mental retardation.
Dr. Tiwari, would you like to comment?
Anyone, any safety measures, we can put it in the discharge card in any manner. So these unconnected, causa causans, which is not the proximate cause for the problem, can be avoided.
Yes, what is the query?
I think he did not get it. So anyway, you are aware about Dr. Satish Tiwari. You are aware how people connect, from discharge card.
Yes.
If there is a history of say convulsions with Lariogo given for malaria fever, then they connect with the MR with CP. Or hysterectomy patient tries to connect with the at 40 years, they try to connect with the loss of vision or diminution of vision. Because of that 40, the presbyopia occurs. At the age of 60, they try to connect with the cataract. At the age of any surgery which is done, at the age of 60, they try to connect. So there is no cause-effect relationship. But since we have not mentioned that, you have not mentioned about this, the problem occurs. It's a terrible situation, because some unrelated things they connect in the, and they shoot the complaint.
So what we understand is that in discharge slip, all the pre-existing or related problems should be mentioned, that these were existing before.
Yes, definitely.
What my idea is to mention that these are the proximate cause, and see, it is like this. I went out, black cat crossed my, and I met with the accident. There is no cause-effect relationship. It is just conjecture. So we are explaining this way, that I came home and suddenly started raining, so I am saved of that I did not get wet. So these are all events which may occur in tandem or concurrently, but they are actually having no cause and effect relationship. So we are trying to explain by giving these examples. But sometimes it becomes very difficult,
So whether we should write something additional, that what you are suggesting?
No, since you have everyone has his own out-of-box ideas. What is my idea, I am telling you. But since you have studied so much, So I thought that can it be something be written in the discharge card to prevent these problems? I don't have any out of box idea except for explaining this way that I went out and my car, the cat crossed the way and I got accident. No relation between the two. I came back from out to my house and it started raining. I am saved from rain. So it is. These are two events which are in tandem or concurrent, but they have no cause. So primary causa causans is not there. The proximate cause is not there. This is the way we explain, but I thought discharge card always creates some or other problem. So this is one problem I am facing. So I thought I will ask you. Anyway, sir, very excellent talk about this thing.
Thank you, sir.
It was quite informative. But these problems, if you get an idea, you can talk to me. You can put on WhatsApp also. There is no problem.
Baldava, sir.
Yes, sir. Yes, sir. Yes.
Sir, if you allow me to say, what will
you don't ask me my permission.
Sir, what will be your answer if you ask the same question?
Huh?
What will be your answer if you are asked the same
I
question?
am giving example. Actually, we are not telling the discharge at that time. My answer I told you, no. Okay, as I went out and the cat crossed the way and I got accident. What is the relation of cat between the accident? Similarly, we try to explain to our judge. There is no causa. Means every event, two independent variables necessarily do not have cause and effect relationship. So I came home and it started raining. So I am saved of rains. So there is no cause effect relation. It rained or it was to rain, so it rained. I came home in time.
But what you mean is that card is okay. The discharge card is okay. Then there's nothing.
Discharge card is okay, and cause effect relationship does not exist. There is something like a proximate cause which is mentioned there. So I am facing this difficulty anyway. See, panelists can see sometimes we are trying to find out preventive and curative aspects of whatever we are facing in reality. But since we right now we don't have any idea, in due course, people might get out of box thinking and might see all these over years. I am trying to get lot of out of box ideas. So I thought it is really fit to ask you.
We will wait for your advice sometime when you get a solution to this.
Yes, sir. Thank you, sir.
Okay, Dr. Satish, any other questions? No. Dr. Satish, are there any other questions?
From my side, nothing. If anybody else wants to ask anything.
No, then I think I will thank Dr. Anurag for the excellent presentation. And
thank you.
Sani sir, would you like to sum up?
Yes. What I would like to say is that what he has brought, Dr. Anurag, is a very, very important thing, because we don't take care of when we are writing discharge. Most of the discharge slips which are given in hospitals or in peripheral hospitals are very, very shabby. They don't mention what proper treatment has been given, what investigations were there, or what pre-existing disease was there. So all those things should be mentioned in the discharge to save us from the future litigations. So a discharge card should not be taken lightly, and it should be taken very, very seriously, as Dr. Anurag has told us. Thank you.
Over to you, sir.
Yes. Thank you, sir. Thank you, Dr. Sahani, sir, for chairing this session. Next slide, please. The chairperson for the next session is Dr. Anurag Verma, sir. He is MD Medicine, LLB, and LLM also. He is a consultant physician. He is also a medical legal advisor. He is National Secretary of IMLIA. He is honorary medical legal consultant, MIC Private Limited. He is a member of MLAG. He is associate professor at HD College of Law, Kashipur, and he is a faculty to many national and international conferences. So over to Dr. Anurag Verma, sir.
Dr. Ushkesh, you need to introduce Dr. Rajesh Bhup, sir, the other chairperson.
Okay, sir. And second chairperson is Dr. Rajesh Bhup, sir. He's a consultant pediatrician at Amravati. He's the national treasurer of IYCF. He is the ex-national treasurer of IMLIA. He is the ex-national treasurer medical legal group of IIP and vice president of Maharashtra IIP also. He is the coordinator for Central India's first human milk bank. Over to Dr. Bhup, sir.
Thank you, Dr. Rushikesh. I am privileged to be part of this important event. The topic we are discussing is dialogue session. What we learned from Dausa, Rajasthan case as a medical practitioner. And for this, we have got two panelists, Dr. Mukul Tiwari and Dr. Satish Agrawal. Dr. Mukul Tiwari, as we know, he is National President IMLIA. He has done MD, DCH, FIP. He has issued FIP. He is pediatric consultant and director at Apex Hospital, Gwalior. So welcome, Dr. Mukul Tiwari, sir. Our another speaker is Dr. Our own Sir Dr. Satish Agrawal, my good friend. He is MBBS, DCH, DNB, MD. His achievements are. Satish
Rajesh, sir, we may skip this thing because it was introduced in the beginning.
Okay. So welcome, Dr. Satish Agrawal too. And I invite these two speakers to start their deliberation. Thank you.
Thank you, Dr. Rushikesh. Thank you, Dr. Rajguru, sir. And welcome to this dialogue session. Basically, the concept of dialogue session was by Dr. Mukul Tiwari, sir, only. As he said, we are facing a very sensitive issue, which happened at Dausa, Rajasthan. And we need to discuss this issue, and that too without the help of any graphics or presentation. So we need to have a dialogue session. But we are fortunate to have National Secretary Dr. Anurag Verma, sir, also, who has cleared his LLM. So we'll be including him as a panelist only rather than the chairperson. So Dr. Anurag Verma, sir, Dr. Mukul Tiwari, sir, welcome.
Dr. Mukul Tiwari is not there, whether he has a internet connection problem or what?
I will contact him, sir.
Okay.
So to start with, I'll just narrate the incident in a very brief. Like at Dausa, Rajasthan, Lalsot, a female delivered a child on 20th of March. And the night she bled heavily, what we call as a postpartum hemorrhage, and she succumbed. The treating gynecologist was Dr. Archana Sharma, who was a gold medalist in gynecology and was providing very good support to the husband at Dausa. Now, from medical point of view, PPH, that postpartum hemorrhage, is a common complication. But for this society and common people, they lost the mother. And it created a havoc. Now this incident, it has got very many implications. It is from the gynecologist point of view, the society lost a gynecologist as a case was filed against her. Article 302 was imposed upon her. People along with the dead body gathered in front of her hospital. They were raising the slogans. There was an agitation. Dr. Archana Sharma couldn't sustain the pressure and she committed the very extreme step, suicide. So we in the society lost a very learned and a dedicated gynecologist, Dr. Archana Sharma. The second implication is imposition of Article 302, which according to Supreme Court judgment also may not be applicable. So who is at fault? Another aspect is the societal attitude towards the doctors, who at times treat medics as God and at other times treat as killers. And what about the external sources who are creating these problems for the medical profession and making them as soft targets? So if Dr. Tiwari sir has joined, So, because we have got a very esteemed faculty, Dr. Anurag Verma sir, who apart from a known cardiologist, a very good practice cardiologist, has got good knowledge about this legal system and has recently passed his LLM examination. So first of all, congratulations to you. And the question to you, as I said, Article 302 was imposed upon her by the police officer over there. How far was it right and who was wrong in imposing that Article 302? Dr. Anurag Verma sir.
Sir, imposing Section 302 of IPC that narrates about the punishment of murder is absolutely wrong. And what has been described as about this section, it is imposed when there is clear-cut murder. Murder is different as compared with culpable homicide. All murders are culpable homicide, but all culpable homicides are not murders. So imposition of 302 in any case is wholly inappropriate, and it has been imposed, I think, because of the pressure by the politicians, by the media people, and the attendants who are totally ignorant about. And it is the police officer who has imposed this section is wrong in every respect. So if it is imposed, it is absolutely wrong in my opinion. Yes, sir.
We are fortunate to have Dr. Mukul Tiwari sir, the National President of India. Sir, before you joined, I just narrated the incident. And now the question to you, it is said that Section 302 cannot be applied to medicos. So any reference to it so that we all medicos get benefited by that?
Sir, I should
probably
interrupt.
Dr. Archana Sharma was not aware of the fact.
It is not. Sir, you have said Section 302 cannot be applied to medicos. It is nowhere. Actually, it cannot be applied to any person who is not I mean, to be charged under this. Section 304, and that is the thing, Section 304 and all sections of culpable homicide, these are not to be applied to doctors as per judgment of Jacob Matthews versus State of Punjab. In these cases, Section 304A, which deals with negligence, death due to negligence, that is to be applied. Yes, sir. Please carry on.
Dr. Anurag.
Yes, I agree.
Yes, sir. Dr. Mukul, sir.
I agree with Dr. Anurag Verma's version. And what he says is right and should be followed.
Dr. Mukul, sir, because many times the same thing happens at all the places apart from Lalsot, Dausa, anywhere. Because if suppose some mishap happens, the blame is on the doctors. And if suppose such incident happens again, and they charge the doctor of the murder or homicide, so what is the real procedure to be followed?
No, procedure to be followed by the police or by the doctor?
By the police, sir.
No, I think Dr. Anurag Verma should complete this answer.
Yes, I should tell you, as per judgment of Jacob Matthews versus State of Punjab, Supreme Court, when passed the judgment, Supreme Court said that until and unless clear-cut laws are framed in this regard by the central government and the state governments in consultation with the MCI, till that time we are proposing these guidelines which are to be followed in these cases where there is a death in a hospital and the doctor has been implicated in that for the negligence. And it has said that if a complaint may not be entertained by the court, because the complaint is to be made in the court. So first it has said that the complaint may not be entertained by the court unless the complainant has produced a prima facie evidence from an equally competent doctor that the doctor in question has committed this gross negligence. And it should be investigated by the investigating officer. And if he finds that some negligence up to this degree has been committed by the doctor in question, then the FIR can be filed and ordered by a court. As far as this, as far as FIR is to be conducted, there the investigating officer which goes for investigation, he has to produce the facts collected in investigation to a medical board. and he should not proceed beyond that. And if medical board is of the opinion that such negligence which comes in the category of criminal medical negligence has been committed by the doctor, then the proceeding should be started against the doctor. This has been very well said. And in case of another judgment, in case of Martin D'Souza versus Mohammed Ashfaq, this judgment by Markande Kaju and one more, I think it was Justice Lothia. They have said that they said about the consumer courts also, that in case of consumer complaints also there should be a medical board's opinion that this is fit for to be placed before the consumer courts, that the negligence has been committed by the doctors. And in case of criminal medical negligence, the procedure which has been laid down by Jacob Matthews versus State of Punjab, that should be followed. And if the police officials who do not comply with these directives and guidelines of the Supreme Court, then the legal action will be taken against them also. Then in another case of V. Krishna Rao versus Nikhil Super Specialty Hospital, it was related to some other matter of expert opinion. But they have erased that part of dealing with the civil cases, consumer cases, because then they said that the speedy justice will not be possible in cases of consumer complaints. But they have maintained, they have not said anything, and they have also maintained the guidelines as far as criminal medical negligence is concerned. So now the guidelines which have been proposed by the Supreme Court in case of Jacob Matthews versus State of Punjab, those guidelines stand. That is the situation up till.
So, Dr. Anurag, the take-home message first is the onus of proving the facts lies on the patient or the relatives one, and second thing,
Sir, onus of fact lies, that is in case of consumer complaints. In case of criminal.
Expert board or the board is set up, and then the board decides whether the negligence or this crime was conducted or not.
Sir, in case of criminal matters, the proof or the accusation or the who is guilty, that will be decided by the court, by investigation. The onus of the proof lies on the petitioner in case of consumer complaint, civil complaint.
Dr. Mukul Tiwari sir, Dr. Anurag also said that police officer probably they impose this section 302 probably out of ignorance or by some other factors. What is your opinion?
Can you repeat your question, please?
Sir, we all feel that the imposing of section 302 against Dr. Archana Sharma was improper. Yes. It was improperly put on by the police officers. Was it put on by ignorance or due to some other factors? What is your opinion?
It might have been due to ignorance. But Dr. Archana Sharma, we are talking about the lessons learned, right? So the lesson is that even if he had applied.
So you got muted. Please unmute yourself.
It was a phone call. It's a big problem. Phone calls coming in between. And if you make it offline, then we cannot talk also on Zoom. The lesson is that Dr. Archana Sharma should not have panicked. She should have been more patient, because by next day or by after a few hours, the help would have arrived from Jaipur or from DOSA, Indian Medical Association, or local medical associations, whatever are there. And we saw that Jaipur Medical Association is very active and very strong. And I think DOSA is a small place and they don't have a proper medical association. So help would have arrived from DOSA, from Jaipur in a few hours. She should not have panicked. If such thing happens to any of us and police applies a wrong IPC, then instead of taking the extreme step, we should consult our colleagues and they can go to the police and help and insist on them to change the IPC code, IPC. Sorry, phone was again coming. What can I do to keep these phones away? I don't know.
So you may keep this thing on some other number forwarded, so it will get forwarded to other number automatically.
Yeah, maybe that. But now there's no time because we are talking.
Call mute bhi kar sakte hain.
We accept it. Sir. Continue.
Whatever, I think the police officer SHO there, he was a very ignorant and uneducated person, and he came, either he was under the pressure from the politicians or there was some monetary attraction to him, because this the deceased patient's husband, we have heard the conversation between him and between there's one more person who's arrested right now. He's under arrest. The name is Sambalia Joshi. That there's a talk of getting 50 lakh, and he's saying that you are a fool. Why you have settled for 3 lakh? He's saying that they are offering me 3 lakh. He's saying why you should have taken 50 lakh. And then we heard that the paid doctor was demanded 1.5 CR also. So there was a racket going on at the same time, racket of blackmailing the doctor. They become instantly active. And in Rajasthan, I don't know that such rackets are so much prevalent, because medical legal awareness among patients, it began from Maharashtra. The so-called social activists and social workers, we first heard from Dr. Satish Tiwari in 2002, 3, 2001, when this medical legal group of IAP was activated. At that time in Madhya Pradesh, there was no such lots of awareness. And initially it was good. It was just patients' rights. Then it went beyond that. It deprived the doctor of his rights also gradually. And they became too much aware of their rights, rather over aware of their rights. And they crossed the boundary, the so-called social workers and patient relatives. So now it has become a big nuisance. Initially in 2001, 2, 3, when I used to meet Dr. Satish Tiwari, I had come to Amravati in, I think there was a state conference along with medical legal conference. I think it was the year 2003.
2005.
2005, yeah. Dr. Satish sir had invited us. And although I used to give talks there, now I used to give talks in such forums, I used to wonder why there is so much hullabaloo about this issue. Because in Madhya Pradesh, there was not much hullabaloo at that time. But gradually, beginning from Maharashtra, and maybe you people must be knowing better if it was in some other states also. But it is spread like wildfire, and it has gone to every state, this problem. In Rajasthan, let us come back to the topic that Dr. Ashna Sharma, the lessons we have learned from this, that she should have been more patient. And they should, in a small place she was practicing, the place was Lal Sot. It is near Dausa, almost a part of Dausa, near Rajasthan, near Jaipur. So one thing is that you should keep your local organization very active. Like in Gwalior, our Indian Medical Association is very active. And whenever a mortality happens in a hospital, immediately about 15 to 20 to 30 doctors reach at that place. And doctor strength is a big factor in which acts as a buffer against such incidences, especially of violence. Regarding blackmailing, this was an extreme case. This has been an extreme case, but we don't know whether such cases will increase in future. And if they increase, then they will make the lives of doctors miserable. And already doctors who are going for marriage, they are searching for brides or grooms who are not into subjects like ICU or surgery or gynae. They are seeking spouses who are in dermatology or radiology or pathology. I think I have gone beyond the original question. Coming back to Dr. Satish Agrawal, sir. I cannot see Dr. Satish Agrawal.
Sir, I am very much over here. I was
I think I took a long time.
Sir, we want to listen to you. And very nicely you have told all the lessons we could learn from there. Because we were not there, so in the beginning I said it has got very many implications, right from the professional angle, right from the societal angle, right from the police angle and the legal angle. So you have elaborated everything so nicely. The next question is, Dr. Archana Sharma was a gold medalist in gynecology. Her husband is a neuropsychiatrist. All are very good academically because they publish all good papers and they are working at very good places. So why Dr. Archana Sharma could not sustain this pressure and went to such an extreme state of committing suicide? Was she not mentally tough, or we intelligent doctors are not mentally tough? Dr. Mukul Tiwari, sir, what do you think?
No, see, this is a big problem among doctors of not being mentally tough, but being forced to do cases which are very serious in nature, especially in gynae, surgery, cardiac surgery, urological surgery, all surgeries in fact. And Dr. Archana Sharma, as we hear from her record, they were taking all the serious cases. I would definitely say that practicing in small places, if any cases looks like critical or serious, I think it was third cesarean done on that patient. So it is better to refer to Jaipur. Instead of being very proud that we are doing cases which others cannot do or which others have refused. Be very easy on referral and don't take it to the heart that your patient has gone to some other doctor or some other city because you could not do it. Let them go. But if you don't have enough infrastructure, don't do. I will not say that Dr. Ashna was at fault because third cesareans are done in many places and they survive. एक हिंदी में कहावत है जिसकी लिखी है वो जाएगा. So it is something like providence or fate. Whose time has come will go. Whether the patient is in Apollo Hospital, Delhi, or the patient is in Lal Sort near Jaipur. Whose time has come will go. So I will say your question was that was she not mentally tough? I think she was mentally tough because that's why she took this third cesarean. But I think the circumstances became so strong and this threat of blackmailing and the demonstrations outside, that something snapped in her mind and she took this instant decision. Something snapped. And it may happen to any of us who think they are very tough mentally. Something may snap at any time. Thank you.
As we keep on saying, we need to know our limitations of the hospital, limitations of the staff. Even though we are very much skillful and capable of doing things, but we need to know our limitations. And second thing, we keep on taking no need of any false assurances. We are going beyond the capability or the potential of oneself.
Yes.
Dr. Verma, as Dr. Mukul Tiwari said, we people, the medicos, are supposed to be very soft target. The politicians, the so-called the social activists, or some other people, they make us target for extortion of certain things to be done according to their will. As sir said, certain cases are to be done forcefully or at will. Why do you think so? What could be the cause for we people to become soft targets? Why can't we resist it?
Anurag ji, who has to answer this question?
मुकुल सर आप बताइए.
We are very soft targets. What power do you have? You're not mafia, you're not into construction activity, you're not into such business activities which require a group. All the doctors are sitting like ducks in their chambers. Yes, in some places, like I said in Gwalior, we have a peacekeepers association working with us, which has about 20 strong men. And the nursing home association pays them monthly. So they take rounds of the different nursing homes, and they are all belonging to strong communities, and they are all body builders. They are coming to our nursing homes once a week, and whenever any problem happens in any nursing home, they immediately reach there. So presence of 8 to 10 strong men at the spot will boost doctors' morale definitely. And it will help a lot, although it is some expenditure. But let me tell you that इसमें कंजूसी करना, some doctors इसमें कंजूसी करते हैं. In Gwalior also, they think why should we pay 5,000 rupees per month to this peacekeepers organization. इसमें कंजूसी करते हैं, then they will lose their life or bigger amounts by not hiring such persons. So my advice to doctors attending this session is that in every city there should be you should hire a peacekeeper organization and pay them regularly. Never mind this 5,000 rupees a month, because it will save you a lot of tension and it will bring back this money in many other ways. It will bring back many folds because you can practice confidently and without being afraid all the time. As for the original question of Dr. Satish Agrawal, doctors are very soft targets, and there's no other softer target than the doctors. Even in shops, shops are close by. So if somebody goes and attacks or does violence or verbally abuses a shopkeeper, the nearby shopkeepers come immediately. In your nursing home, you are sitting apart. The next nursing home will be 1 furlong away. You are sitting alone. Your staff is maybe 4 persons, 5 persons, 8 persons, and they may be mild people. They may not be fighting type. So if anything, the brunt is to be taken by you. So yes, we are very soft targets, and we should become strong by hiring the strong man. That is the only way. Or we should keep a back door ready to escape as soon as possible. And we should not take all this tension. Like in Dosa also, I will say that Dr. Ashna and her husband, they should have moved to Jaipur instead of sitting there and watching all the demonstrations going outside their nursing homes.
Dr. Mukul sir, what's your statement? Like as you said in Gwalior, a team of IMA members are already. So is the case at Amravati. We call it the RAF Rapid Action Force. Moment any mishap happens at any of the nursing home with any of the IMA member, just a message pass on the WhatsApp group, and a group of 10 to 15 people, they get gathered over at this concerned nursing home or the OPD. And 99.9% the matter gets solved over there only without much consequences, because most of the people either they know one or the other, or the departments they are known to one or the other medicos. Second thing, as you say, as you said about the shopkeeper, there's a unity among the goldsmiths. If any of the raid happens or any other tax is imposed upon them, the whole market gets closed. So should be unity amongst we people, the organization. And second thing is the open communication. If somebody is troubling me, somebody is extorting money from me, somebody is demanding something undue, so it should be an open communication in the organization. Second thing, as I said, if something is happening beside my nursing home, so I should be the first one to reach over there. This next time when something happens at my nursing home, the person will come to me. And that is how, जैसा आप कहते हैं शुतुरमुर्ग अपने नीचे गर्दन छुपा के रखता है, same thing happens with people. Sir, now as I was talking about the organizations to which we belong, either organic organization or Indian Medical Association, so The role played by these organizations in DOSA case, how far was it appropriate? Any of Dr. Mukul Tiwari sir or Dr. Amravati Verma sir? The role played by the organizations like Indian Medical Association, because it got spread all over the country. Even we had blind badges to our arms, and we were prepared for a strike. So it spread like anything. So we had our support. Was it appropriate and up to the mark, or were there some deficiency or some alternatives which the organizations could have done?
Should I speak, sir? Sir, please unmute yourself, sir.
Dr. Amravati Verma sir, you please answer the question.
Yeah. What should have been done? In my opinion, I'm very impartial in saying that as just Dr. Mukul Tiwari sir has said, there should be a very strong local association. Because in this case, what happened? I think she took this decision of committing suicide as to my mind, this thought has come that she had no support from the local Foxy or local IMA. I should be very true in saying this. That's why she has taken this decision. And number two, in these cases, what these now these type of incidents are quite frequent at our place also. And what happens that after all, the doctor who has been dealt with by the attendants, he has to take brunt and he has to fight it afterwards. Only for a while, people of IMA they come, and that too consists mainly of the friends, and not all the members of IMA come. So it is very essential to participate in the local IMA meetings, and one has to strengthen the local IMA. Because at that time, only local IMA can support. In this case, what happened that in central IMA, there was a decision of a strike, pen in the strike at night. When we woke up in the morning, we heard that the strike has been called off by the national IMA. While in Rajasthan, they were prepared. They conducted various march, and they were totally bent upon this thing to continue the strike. So there was some disunity, there was some misinformation, some lack of information as far as this was concerned. So in my opinion, we should take some decisions to cope up with these situations, and we should follow those decisions. Like Dr. Mukul sir has just narrated that they have created some peacekeeping force in Gwalior. That is very important. And people are really afraid of this thing, and the local IMA members, they should reach within no time to the site of incident. That carries a very great impact on diffusing these situations. That is my opinion.
Dr.
IMA
Mukul,
people,
Dr. Mukul Tiwari sir, I hope he is there. Okay, Anurag sir, you continue. You're saying something.
Yeah, what I was saying is only this thing. And I should, what other points they come to my mind is that one should never hesitate to contact colleagues for help in these type of situations, because they physically they are also helpful, and they are a kind of stimulant psychologically also. Psychologically, the doctor has to be strong in this type of these times, and they give moral support to the doctor. And as far as what is to be done in these situations, I will advise that the medical people, the doctors, they should at once contact the medical legal people who are amongst us, and as well as lawyers, because legal help can be best given by the lawyers only, and by the medical people what has to be done. And by unity, the medical professionals, they can face police or bad politicians also, media persons also, and miscreants also, by their unity, brotherhood, and timely action, and with their professional behavior. And now these are the times where with a good doctor-patient relationship, proper documentation and proper record keeping is also very important, because if there is proper documentation, proper consent taking is there, then in this type of incident, the attendants they are themselves demoralized to take these type of steps. There should be a proper security in the hospital, and the doctor must have indemnity insurance and insurance of the clinical hospital also. And one thing is also very important, that we should not indulge in medical jousting, and we should stop criticizing our colleagues. And one more thing we should keep in mind, that the patient is not loyal to any doctor, because now the era of family physicians have gone. Doctors are there are so many doctors for same disease, and the patients, they are not dependent on only one doctor. So in case if there is any dispute and there is only mild indication for that, then the doctor should take the side of their own colleagues, which other people they do. So if you take side of your own colleague, then the other person will not be taking any other arguments and any other action which is not desirable. And the doctors, whether they are super specialists or in any specialty, they should participate in their local IMA meetings, and there should be a sense of equality among the doctors. It is not that somebody is super specialist, somebody is a specialist, because to fight with these situations, all are equal. This can happen to anyone. No one is spared. I think if I say as a physician, I will not face certain situation, many physicians face, and everybody is exposed to these situations. That is my opinion.
Excellent. So the take-home message from you, first of all, there should be unity. There should be a strong organization where each and every one of us should contribute, irrespective of the designation, seniority. Third thing is awareness of the medical legal facts. As probably Dr. Archana Sharma may not be knowing that Section 302 may not be applicable to her, neither the police officers, he knew the things. Awareness is the most important thing. And the most important thing is about the protection and security of ourselves as well as of the hospital premises. The best thing to do is the indemnity policy, which our medical legal group and Dr. Satish Tiwari are always advocates. And before we close, because we are now reaching at the end of this session, the most important aspect is the societal aspect. This society which label us as to be God, and any mission, then we become the killer. So if society would have been at her side, probably thing would not have gone to that extent. And the main thing to suffer is ultimately society. If Dr. Archana Sharma and her husband, they came all the way from metros to serve the area like Lalsod, a very rural area with the skills, experience, and knowledge. If such people they stop coming to the rural areas, ultimately the rural people will be deprived of such skilled services, and they need to go to nearby big cities. So we need to make this society too aware of the facts. They should not fall prey to so-called social activists, the political leaders, or any kind of pressure. And ultimately, it is the medical profession who is going to serve them in case of difficulty, disease, or disorders. So, thanking the panelists, Dr. Amravati.
One thing more, Dr. Satish Agrawal sir, I would like to tell. I will take only 2 or 3 minutes. But I think it is necessary that we should be aware about these aspects also. Since all of us are doctors, we should know how we are protected from by the law. So as you all know, I'm not going to details of those sections like section 87, 88, 92 section IPC even says that the doctor can proceed for any treatment or any surgical procedure without even by consent in case of emergency. Now, what we should know, what the doctor can take steps against what the steps, because the crux of this complaints about this DOSA episode was that the culprits who were among the police, they should be dealt with firmly and some legal action must be taken against them. So I should narrate and we should look into it. Anyone can go to the sites and see what legal action can be taken with the police officials. And this pertains to some general knowledge about this also, that there is a provision of police complaint authorities in every district, which has been created by Supreme Court, and retired judges are members of those. So any complaints against these police officials can be
Dr.
lodged.
Anurag, sir, I'm interrupting you because we need to take a final take-home from Mukul Tiwari sir, and we can't exceed the time because we are the host. Dr. Mukul Tiwari sir, last minute, your comments.
Yeah, thank you, Dr. Anurag and Dr. Satish. I would like to say that our national body people are definitely disappointed with our national body for calling off the strike after giving a call for it. But the local bodies like the Jaipur Medical Association took a very strong step, and they fought for full 7 days to ensure justice for Dr. Archana. So instead of relying or looking towards the national body all the time, we should make our local bodies stronger. And as I said, the ways for that the doctors should make rapid action force doctors only, and also should hire the muscle men to help them. Without that, they cannot go on further. So this is my parting message, and they should be legally very aware and strong, mentally also very tough. Whenever they enter any critical field like gynecology, it's a critical field. All surgeries are critical field. Either you do not do surgeries, or if you are doing, you should be mentally tough. Otherwise, you leave it and do IVF in gynae. Safe subject, safe field. And I would like to know the opinion of Dr. Satish Tiwari sir also in this. I can see him there.
I think that as rightly discussed in last 45 minutes or so, we have to have the overall empowerment of our colleagues. So not only as rightly said that they should be psychologically, they should also be empowered. They should not fall prey to the failures in the practice or failure on the part of judiciary or the police authorities or district authorities. And of course, we have to take the help of our colleagues, and there has to be unity as rightly discussed.
And psychologists also.
Yes, psychologist, but I do not know here what was the problem, because we are saying her husband himself was a psychologist.
Okay.
Sir,
may I add one line?
Sir,
yes, sir, please.
Sir, please.
Yeah. See, those who are most intelligent and most skillful, they are most vulnerable to legal problems.
Right.
Because they take higher risks, and higher risks are not allowed in legal parlance.
Right, sir.
Excellent.
So, and this is my dictum, and which is in the book. This is my law. I have coined this: more intelligent and more skillful are at more risk. They take more risk, and they are at higher risk of getting prosecuted.
Dr. Baldava, that's why if you remember, we are saying we should write as a consultant and not as an expert.
Yeah, absolutely right.
Yeah, we should not claim that we are expert. We should claim that we are consultant.
No, Dr. Tiwari sir, we have forgotten that we are MBBS.
Yes.
We are always, whenever I am getting a case, I tell them, get your MBBS mark sheet. That is showing you the real. There they are getting 65, 70, 80% marks. I said there is a big gap between 100. The judiciary is expecting 100%, but you have in fact got at the MBBS level only 60, 70, 80% marks. And MD level also, no one expects to get you 100% marks. Everyone, the passing level is 50%. So, but at the time when the judgment, see, basically the doctors are perceived as the money sharks. This is the problem with the society and the judiciary. But whereas even in corporates only 5% of the total revenue goes to the doctor, 95% goes to the hospital.
Sir, there is a recent judgment
Sir,
from I think Kerala that the doctor should place their mark sheets, how many percentage of marks they have got in their clinic, so that the patient should decide that what type
I
of a doctor,
always
how
put
intelligent
it.
doctor
I
is.
tell my doctors, don't feel ashamed just by how capable you are. So you show the capability that these are the marks you have got. This is your capability. Rest you let. See, there was a big syllabus. Out of that, you read a couple of things.
Baldawa sir. Dr. Baldawa sir.
Please go ahead.
Whole polite, all the due respect to you, because we have exceeded time by 5 minutes.
Yeah.
So before chairperson stops me, just give me the permission to end the session over here. Over to Dr. Rajesh Buk sir.
Thank you, everyone, and thanks very much, Dr. Satish Agrawal and Dr. Anurag Verma.
Thank you, both the esteemed speaker.
Thanks to you also, sir.
Thank you, Mukul Tiwari sir, Dr. Anurag Verma, Dr. Satish Agrawal sir, and Baldawa sir and Tiwari sir for adding and giving their expert comment. Now we come to our next talk, that is on recent amendment in POCSO Act, and we have got Dr. Sudesh Doshi with us. Dr. Sudesh Doshi has done MBBS, DGO, LLB. He is senior obstetrician and working since last 25 years in rural setup at a religious place, Pandharpur. He has experience of delivering over 12,000 babies at his nursing home. He was chairperson of medical legal committee AMOX. He is member NIMC FOXY. He was past president Pandharpur OBGYN Society. He is member of EMLIA and is member of EMLC FOXY. So we have got a very talented speaker with us, Dr. Sudesh Doshi, to talk on recent amendments in POCSO Act. Dr. Sudesh Doshi, please.
Yes, sir. Am I audible?
Yes, yes.
I will just open the presentation. Are my slides visible?
Not yet, not yet.
Well, I will close and then do it again. Let's open and then share. Are they visible, sir?
Yes, yes, yes. Full screen, please. Slideshow.
Thank you. First of all, I apologize that I couldn't start time as an obstetrician had an emergency. Thank you, Dr. Satish Agrawal, sir, and all the dignitaries for allowing me to reschedule my talk and take in the last. So I'm supposed to talk on the recent amendments in POCSO Act. POCSO, as we all know, and all the esteemed faculties here know, is a Protection of Child from Sexual Offences Act. And there are amendments in 2012, and again, rules were coming in 2019. We'll go through the general features of this act, where the child has been coined as a term and defined as any person below the age of 18 years. So here we need to understand that child is either a male or a female. POCSO is not only sexual offences against female children or a girl, but also against the male child also. Now the POCSO has different chapters in it and the sections in it. Now they have graded these offences in different terms. The highest grade has been a penetrative sexual, has again been graded into two things: a penetrative sexual assault and a aggravated penetrative sexual assault. Secondly, there has been defined as a sexual assault, which is not penetrative, and an aggravated sexual assault. Then the definition of sexual other things also been given. Now, penetrative sexual assault has been defined in this act in section 3 as a person is said to commit penetrative sexual assault if he penetrates his penis to any extent into vagina, mouth, urethra, or anus of the child and makes the child to do so with him or any person. Now, this is very comprehensive because previously, as we know in rape, if the penis is penetrated into the vagina or not, if it is in interpret when that would constitute rape or not. Now all these fallacies are gone, and a very comprehensive definition of penetrative sexual assault is given. One more thing which has been included, that he inserts not only his penis, but to any extent any other object or a part of the body, not being the penis, into the vagina, urethra, or anus of the child, and makes the child to do so with him or any other person. Plus, it has been made more comprehensive that if he manipulates any part of the body of the child, sorry, so as to cause penetration into the vagina, urethra, or anus of the child, and make the child to do so with him or any other person, and if he applies his mouth, even oral intercourse has been taken as penetrative intercourse to the penis, vagina, anus, or urethra of the child, make the child to do so, has been defined as a penetrative sexual assault. Now, today's topic was what is new. In the amendment, all the punishments which were there in prior law have been increased and have been upgraded, and more severe punishments have been given. For example, in previous law, the punishment for penetrative sexual assault was a term which shall not be less than 7 years, but which may extend to imprisonment of life and shall also be liable to fine. But now the term of punishment has been increased from, as we can see in the new law, from 7 years to 10 years. Secondly, a few more things have been added, where it is said that whoever commits penetrative sexual assault to a child who is less than 16 years of age shall be punished with the imprisonment of term which should not be less than 20 years. So if the penetrative sexual assault is from age 16 to 18, then the punishment is for 10 years. If it is less than 16 years, then it should be 20 years, and it may extend to imprisonment for life. That is for on the remainder of natural life of that person, and shall also be liable to fine. So now we can see that in the newer amendments which came in 2020, the punishment sections have been made more severe and more deterrent. Now, what is aggravated penetrative sexual assault? Now, the law has, this is in very comprehensive definition. I put only a part of this definition into it, that whenever a penetrative sexual assault has been done by a person who is more responsible, like who is a police officer or a member of armed forces or security forces, or being a public servant, or being in the management or the staff of the jail, remand home, protection home, observation home, any place of custody, care, or protection, or being management of staff of a hospital, government or private, or management of religious institution, educational institution. So a person who is supposed to be more having more responsibility, if he commits this punishment, then it is supposed to be aggravated penetrative sexual assault. And what is the imprisonment for that? Previously, it was rigorous imprisonment for not less than 10 years, and which may extend to imprisonment for life and liable to fine. But now the punishment has been increased for a term which should not be less than 20 years, but which may extend to imprisonment for life and for the remainder of life. And the fine imposed under subsection shall be just and reasonable and paid to the victim to meet the medical expenses and rehabilitation of the victim. So again, the imprisonment has been increased from 10 years to 20 years of life. It has become more deterrent. Now, less severe crime is sexual assault, where touching with sexual intent, it is important, with sexual intent, to vagina, penis, anus, breast of the child, or make the child to touch the vagina, penis, or anus, and causing the child to such parts of the body of the offender or any other person, or any other act with sexual intent involving physical touch except for penetration. So this will be a lesser severe assault crime, and the imprisonment for a term which shall not be less than 3 years, but which may extend up to 5 years and shall also be liable to fine. So sexual assault, which is non-penetrative, punishment for 3 years, but may extend to 5 years. Penetrative sexual assault, punishment for 10 years, and punishment for aggravated penetrative sexual assault will go for 20 years. Now, what is aggravated sexual assault? Now, it is a sexual assault with what has been described in section 5, that a person who is more responsible, who is has the child in his custody, will be more liable to more amount of punishment. One more section has been added in aggravated sexual assault, that a person who persuades, induces, entices, or coerces a child to get administered or administers or directs anyone to administer, help in getting administered any drug or hormone or any chemical substance to a child with the intent that such child attains early sexual maturity. This will also come under aggravated sexual assault. Now, minimum imprisonment for sexual assault is 5 years of either description, which may extend up to 7 years of fine. Now, a more less severe crime is sexual harassment. So we have, in terms of increasing intensity, sexual harassment, sexual assault, aggravated penetrative sexual assault, and aggravated penetrative sexual assault. So sexual harassment is an act done by one with sexual intent, namely utter any word, sound, make any gesture, exhibits any object or part of the body with an intention, or such word shall be heard, or such gesture to be seen by the child, and make the child exhibit his body or any part of his body so as it is seen by such person or any other person, or show any object to the child in any form of media for pornographic purposes, and repeatedly or constantly follows or watches or contacts child directly, indirectly through electronic or digital media. Now, this is sexual harassment. Or threatens to use in any form of media a real or fabricated depiction through electronic, film, or digital, or any other mode, or any part of body of the child, or involvement of child in sexual attack, or entices him. Here, any question which involves sexual intent should be a question of fact. And for such sexual harassment, there is imprisonment up to 3 years of either description or fine. Now, further we go, this use of child for pornographic purposes. Now, this was added with more zeal in 2012. Previously, it was not there. Where if a child is used for pornographic purposes, then there is a severe punishment. Now, it has been defined as if you use a child in media, that is programs or advertisements telecast in television channels, internet, electronic print, etc., representing sexual organs of the child, or representing using the child in real or simulated sexual acts, indecent, obscene representation of the child, then the punishment also has been increased. In section 14 previously, the punishment was imprisonment up to 5 years of either description, and for subsequent offense, it was 7 years. Whereas now, the punishment has been increased for a term which should not be less than 5 years, and in event of second or subsequent conviction, it should not be less than 7 years. Minimum imprisonment for 5 years of either description, which makes them to 7 years. This is the punishment. Now, section 15 has been added in the new law, which gives punishment for storage and possession of pornography material which contains children. Now, this has been explicitly defined that any person who stores or possesses pornographic material in any form involving a child, but fails to delete or destroy or report the same to a designated authority, then with an intention to share or transmit child pornography shall be liable to a fine not less than 5,000 rupees, and in event of second or subsequent offense, with a fine shall not be less than 10,000 rupees. So if you have a clip which is in your mobile or on a pen drive which shows child pornography, then if you are supposed to store or possess it, then you should immediately delete it, or if you have it, you should immediately report it to the officer. Otherwise, you are likely to have a monetary fine of 5,000 rupees. Now, if you propagate it or display it or distribute it at any time except for the purpose of reporting, then you have imprisonment which may extend up to 3 years. So if you have a clip with you, then you should destroy it. But if you keep the clip with it with the intention of propagating it or broadcasting it, then you will have imprisonment of 3 years. And if you use the same for commercial purpose, then shall be punished on first conviction with imprisonment of 3, which may extend up to 5 years. And if it is subsequent offense, then not less than 5 years and may extend up to 7 years. So even possessing a film or having a clip which contains child pornography is liable to fine and punishment. Now, there is also obligation of media, studio, and photography facilities to report cases. If a personnel of media, hotel, lodge, hospital, club, or anything photography facility, they should report it to the special juvenile or local police if they find any material of pornographic, sexual, exploitative, obscene nature related to child. If do not report it, then there may be imprisonment of 6 months or fine. Now, there is section 41, which says that nothing in section 3 or section 13 should apply to medical examination or treatment of a child with the consent of parent or guardian. So medical examination of a child is exempt from all these clauses. Now, what we medicos are more important, or what is more important for a pediatrician or a gynecologist, is that reporting of offenses. Now, here it is written in section 19 that anyone, including a child, may report even on apprehension of offense to special juvenile police unit or local police, and must give an entry number and recording writing. Now, what is the problem is, when a patient comes to a gynecologist on day-to-day basis, she's married or unmarried, what is, if she's 16 years old or less than 18 years old, and if she's pregnant, then it becomes the liability of that gynecologist or that pediatrician to report immediately to the police. Why it is important? Because if you do not report it to the police, then there is punishment for failure to report or record a case. For example, I sit in the OPD and a 16-year-old married person comes and she says she's pregnant. Then under POXO, a crime has been committed of a penetrative sexual assault by her husband, because he has had penetrative sexual intercourse with his wife. So now it is my responsibility to report to the police. So if I don't report to the police, then what are the offenses? Then the offenses should be punished with imprisonment of either description, which may extend to 6 months, or with fine, or with both. So it becomes very difficult situation in places like Rajasthan, like so many people are coming from there. Rajasthan child marriage is very rampant. Even in Maharashtra, a few parts where I practice, child marriage is very rampant. Now it becomes a very tricky situation. For example, that newly wed woman who is very happy comes with her mother-in-law all decked up and with her new sari and with her all things, and she's very happy that she's pregnant. Now if she comes to me and for registration for pregnancy and delivery, and if I send her to police station, what should have happened? It is practically very difficult to implement this, but the law is there, and so now we have started reporting any person who is less than 18 comes to our office and is less than 18, I have to report her to the police. Now there are some side effects of this reporting, because tomorrow what will happen if the patients come to know, they are not going to stop child marriage. The child marriage law has been passed so many years ago, but still we have failed on this front to stop child marriages. So now what will happen, that if a person is pregnant, she comes for medical treatment to me, and if I report her to police, then people will stop taking medical treatment, and I don't know whether I would be offended or I would be a criminal for not offering services to the patient who is in need. And that would, maybe some case would happen, and there would be a maternal mortality for patient because she is less than 18, she did not report to medical authorities, because she will be punished under POXO, and she doesn't seek medical care and something goes wrong, then I don't know who will be held responsible. So this is a thing where we all medical community should come together, ask the politicians, and this should be amended, and maybe doctor should be exempted from this reporting, because the people may not approach the doctor to seek medical treatment. Similarly, if we sometimes happens that we report it to the police, but police just refuse to take the reporting, in that case the police also may be punished, because any person being in charge of any company or institution who fails to report the commission should be punished, and it should not apply to the child. If the police does not take the cognizance of the reporting, then the police is also likely to be punished, because the law says so. Now there is a punishment for false complaint or false information. Now this punishment is up to 6 years, so false information also cannot be given. Do I have some few more slides, sir? Hello?
Yes, you have 5 minutes.
Okay. Then I will go into the procedural law. Now there has been procedure given for recording the statement of the child. Now this has been written in the law, and 2020 rules also come. Now recording at the residence by the police is not in uniform. For example, if a child has been a victim under POXO, then the child should not be called at the police station, but the recording of his evidence should be done at residence by the police who is not in uniform. The accused must not come in contact with the child during the recording. The accused and the child should be kept separately. It should be done in the presence of parents or person of trust and confidence. Child should not be kept at police station at the night. He should be sent home or in the children home. The police shall ensure protection of the identity of the child from the media. Magistrate shall record the statement under Section 164 of Criminal Procedure Code in actual words of the child as far as actual. Translator and special educator should be available. audio-visual recording to be made wherever possible. Now, there are few things which are to be followed for medical examination of a child, which have been given in the law. It is to be conducted in the terms of Section 164A of the Criminal Procedure Code. As far as possible, it should be done by a woman doctor if the victim is a girl, in presence of parents or persons of trust of victim, or a woman representation of the medical institution. Now, we'll conduct the trial. Now, these trials are to be conducted by special courts. Courts of session of the district to be notified as a special court. Will try other offences to be tried with offences under the Act, including Section 67B of the Information Technology Act 2000, and special courts shall have the powers of courts of session. They would take cognizance directly upon complaint or police report. Questions to the child to be put through court, not required to repeatedly testify in the court. No aggressive questions or character assassination to the child should be done. Frequent breaks to be given to the child. Child-friendly atmosphere ensured by presence of parents or persons of trust. Identity of child should not be disclosed. Trial as in and juvenility to be determined by special court, and proceedings should not be invalid for erroneous determination. Evidence of child to be recorded within 30 days of cognizance and trial to be completed in a year as far as possible. And assistance of translator, special agent should be available. Child should not be exposed to accused while deposing. Video conferencing, single visibility mirrors or curtains may be used. Trial shall be in camera. Commissions under Section 284 Criminal Procedure Code may be resorted to wherever necessary. Legal assistance to the child through Legal Services Authority. Special public prosecutor to be appointed, not less than 7 years of experience. So all these things are given to keep the dignity of the child. The child should not be made intimidated or something. So a detail has been given in the Act. Now, one more important thing, statutory presumption is that in Section 29 and 30, presumption of to certain offences, persons prosecuted under the Act shall be presumed guilty unless proven innocent by the special court, and presumption of culpable mental state. Persons charged under those offences which require the existence of such mental state, it shall be presumed unless proved otherwise by the court. Now, this is a very hard thing because once you are booked under POCSO, then it will be going to hell a lot of trial, provided you are not guilty. Now, government also should have restitution, compensation, and alternative punishment for all these things, and guidelines have been given for that also. In addition to punishment, special court should act in appropriate cases compensation to the child for any physical or mental trauma or immediate rehabilitation. State and central government shall take steps for public awareness of the provisions of the Act. National Commission for Protection of Child Rights and State Commission shall monitor the implementation of the Act. Now, this is one more thing which has come into the amendment is entitlement of children who have suffered sexual abuse to receive information and services. Now, these are to receive a copy of FIR, to receive adequate security and protection by police, to receive immediate and free medical examination by civil hospital or primary health center, to receive counseling and consultation for mental and psychological well-being, for recording of statement of a child by woman police officer at child's home or any other place convenient to the child, to be moved to a child care institution where offense was at home or in a shared household, to the custody of a person whom child reposes faith. Because this happens many times that someone who is in the care of the child, maybe uncle or a grandparent or has done the act under POCSO, and so the child may have to be moved to a child care institution or to some other home of his relative. For immediate aid and assistance of recommendation of CWC, for being kept away from accused at all the times during trial or otherwise, to have a special educator for the child or other specialized person who, when the child is disabled, for free legal aid, for support personnel to be appointed by Child Welfare Committee, to continue the education to private confidentiality, for list of important contacts, including the district magistrate and superintendent of police. So this has to be given to the child. This is entitlement of children who have suffered sexual abuse to receive protection. So this is all what POCSO was about. I tried to concise it as much as possible because, as we all know, POCSO is a huge act and we have talked on it a lot of times. Most important thing what I was asked to is what are the amendments. The amendments important is that all the punishments have been made more severe, more detrimental. That is just in 2 lines about amendments in POCSO. Thank you. Thank you for giving me the opportunity to have a talk with you. Thank you very much. I'm open for questions provided the time is there. Thank you, sir.
Thank you, Dr. Sudesh Doshi, for updating us about recent changes in POCSO Act. If there are any questions, they are welcome. There are no questions.
I have a question. I have a question to him.
Yes, sir. Yes, sir.
See the say doctor sees now he has been seen by subsequently by so many other doctors. First gynecologist sees, he sends to second, or the patient goes automatically second, then subsequently to the public hospital.
Yes.
Now they have reported about this, but this fellow now realizes that since he has not, now the say 15 days have passed.
Yes.
Now can he go and report to the police now?
I think he can go and report to the police, because in the law, the time limit has not been given that the offense is to be reported in such and such time. The time framework has not been given. So it would be prudent to go and report it to the police that I had come across this case, but at that time maybe the patient had given her fake age, not given her age 18, because many times what happens is people in OPD, because they know that less than 18 is not age of marriage, they give fake age. They say they are 19, they say they are 20. And when we ask for Aadhaar card or age proof, they say we will bring it next time. Many times their Aadhaar card is in their maiden name, and now they are married, and so they don't have Aadhaar card in their married name. So it really becomes difficult to assess, to know the exact age of the patient. We are demanding for Aadhaar cards, but I'm afraid because we are demanding for age, patient should not be shunned away from medical treatment because only her age is not available. So we cannot refuse treatment. But if the person has not reported, because in the law time frame has not been given that you should report in such and such time, I think he can take advantage of that thing and report it to the police.
One of the my doctor gynecologist friend, he did not report. He went subsequently 15 days later with all the. Then the police said, see, you are trying to hide the evidence. So we are applying section 201, 202 of IPC that you did not. So we again went to them. There is even 201, 202 does not mention about any time frame.
Yes, sir. Yes, sir.
And subsequently we stopped communicating in person to the police. This from Karnataka.
Yeah.
Karnataka police was involved in this. Then we said we are dealing with you now only through email or through speed post.
Yes, yes, yes.
So the reason for, as you mentioned very correctly, that doctor said that I did not have anything, and patient said that I am more than
19 years,
18 years old. So same logic was given, but the police did not accept it. And he said, you are trying to hide the evidence. And so we in subsequent letter mentioned that we are not trying to hide, we are trying to cooperate, and any other thing you want to, with whatever is with us. Because subsequently what happened, he went to another gynecologist, then next gynecologist, and then finally landed up in the general hospital.
Yeah.
And the second and third gynecologists were also sounded by, because some friend was there in the general hospital, because the third one referred to the general hospital.
Yes, sir.
So they sounded him that you better respond to them. Then second one sounded to the first one.
Yes.
That time by that time 15 days had passed.
Yes.
So there is no time frame as I understand, but most of the time the police men, they don't understand this, and they try to create a lot of ruckus, and they try to extract some money.
Many times their intention, the doctor is a soft target, they want to extract money.
Yeah.
And that time we have to be bold, and people like you are always there to guide, and we can tell the police that the law has not mentioned the time limit, and we are not hiding anything. We are also giving it to you.
Yeah. The initially that gynecologists were telling that what if 19 and whatever 21 is there. I said you are not read subsequent questions, subsequent sections, which makes you liable, and then unless proved otherwise, unless you prove yourself non-guilty, you are in the act.
Yeah. But the thing is, we should all, the police generally makes the doctor because he's a soft target. But the people, at least 100 people, minimum 100 people, even Corona people have attended the marriage. So all of them know that she is less than 18. All those should be also booked under POXO, because they have the age of the child is less, that girl is less than 18. They attended the marriage, they attended the consummation ceremony, all things is given in public. And even the politician there in the Sarpanch should be also held that you know that this child is in your village and you know the age of her thing and you attended the marriage. How come you don't know?
Yeah, absolutely right. Absolutely correct.
I think we should do something about this 18 age, because I am re-emphasizing it, because people may not come for medical help because they are being reported to the police. We have to do something about this, sir.
You are right, sir. You are right. Absolutely. We have to do something. But I think there is a hesitancy. Once the things become late, the hesitancy on the part of gynecologist or treating physician or surgeon, hesitancy is there. And they don't know that they have to prove later on. That is the problem.
Yeah. Thank you, sir. Thank you for your guidance.
Can I ask one question?
Yes, ma'am.
Sudesh, excellent presentation. You said that, when patient comes to us under 18 years of age and she's married and pregnant, and we report it to the police, right? So actually what happens to them later on? Any idea?
Yeah, if we report it to the police, then it is mandatory on the police to book under POXO. Then it becomes a very bad thing, as we all know what has happened in Solapur also, because that poor child and their mother and father and her husband all are booked under POXO. Her husband will be booked under penetrative sexual assault if she's pregnant, and the thing goes haywire for the families, and the whole family is destroyed because of this.
Right, and we don't have to, when we inform the police, we don't have to take, we don't have to inform these relatives, right? We just inform on our own.
The thing is, many times police also doesn't take cognizance. The simplest thing what we can do is put an email on the police officers or the police station's email ID, because if we send a letter, ask them to take a cognizance, many times they say, we will not take it, they will throw it away, they will not give reporting. So the best thing you can do is do an email on that thing. So our responsibility is over that. We have informed the police. The police will take action or not is the police's responsibility.
I think that is very good point, because quite a few times the police will not accept our statement or whatever, application. So I think better to just email and then do the formalities, whatever are to be done.
And also we have talked to senior officers also. They said that because government is saying we want to apply POXO, they applied it to few cases, and they were also regretting that it is very difficult to implement a law which is not implementable, and the sorry state of affairs under which the whole family of that victim and her husband and all had to go was very bad. Because in social circumstances, I know this is a crime to have a sex with less than 18, but why doesn't government understand that, okay, the age of marriage can be 18, but puberty becomes 13. Why they are denying the right of a person who is become sexual mature, who may have some sexual exploration with all social obligation to have intercourse? This is something against the nature, and we are trying to rule out something very different under our society or social norms. But it is going to be very difficult, because people are having puberty very earlier. Even we all have tried something fishy. We are not done sexual intercourse, but in our age of teens, we are all explorative. We want to know things. It is simple inquisition ki ye kya hai. Sometimes we have something new in the game or something like that. Sometimes we touch a female, sometimes a female touches a male. It is sole intention of exploring things, not intention of sexual intent or committing a crime. Now that also comes under POXO. It is going to be very difficult to apply all these things.
Thank you.
Dr. Doshi, you are right, absolutely. I think there is a maturity, desire, and the law. All three are in conflict, and plus the marriage age. They are in certain northeastern state. The marriage age is up to 16 years only.
Yes.
But this act is applicable to the entire country.
Thank you, sir. Thank you.
Thank you. So at the end of the session, I hand over mic to Dr. Roshikesh Nathan to carry on the further proceedings. Thanks a lot.
Thank you, Dr. Rajesh Bhoop, sir, for conducting this session. Next slide. The chairperson next session is Amravati Yadav. She is a MBBS and PGD MLE. She is also a LLB from renowned university. She is working as a resident doctor in Fortis Hospital. She is also a board member of Journal of India. She has been a speaker as faculty in various national and international medical legal conferences. She has published various medical legal articles in JIMLIA and other national publications. And she is presently working as a cardiology resident in Fortis Hospital, Gurgaon. So I hand over the mic to Dr. Nidhi Yadav.
Good evening, everybody. I hope I'm audible. So first of all, I would like to extend my gratitude to all the executive board members of Maharashtra EMBLIA and all my seniors for giving me this opportunity today. I would also like to congratulate executive board members of Maharashtra EMBLIA, respected Dr. Tiwari sir, Dr. Mukul Tiwari, Dr. Satish Agrawal sir, Dr. Anurag Verma, Dr. Hemant Gangulia, and Dr. Rishikesh. And heartiest congratulations to Dr. Satish Agrawal, founder president, and Dr. Hemant Gangulia, founder secretary, on installation of EMBLIA Maharashtra stage bunch today. And I welcome our moderator of session on medical legal issues in intensive pediatric unit, Dr. Sameer Sadawarte.
Hello.
He is
Hi.
MBBS. Hi, sir. He is MBBS, DCH, DNB, head and chief pediatric and neonatal intensivist at Fortis Hospital, Mumbai. He is accredited teacher for fellowship at MUHS in PICU and IAP intensive care chapter. He's ex-fellow at PICU and ICU from University of Toronto, Canada, Hospital for Sick Children and Sick Kids. Over to you, Dr. Sameer Sadawarte.
Hello. Hello. Am I audible now?
Yes, sir, you're audible. Please.
Okay. Thanks, Dr. Nidhi, for this welcome introduction. May I share my screen so that I can introduce my panelists also here? Okay. So some noise disturbance is there. I think if somebody is using two phones, please switch off one of that because some noise is coming from that. Hello. Can you please do that? Okay. Sorry, I'm just opening my session here. So today we're discussing about the medical legal discussion about the panel of my in-house. Dr. Kedar Malvatkar, he is a chief consultant pediatrics from the Wockard Hospital, and he's a past president of, he is the president for the Nashik current IIP, and he has been awarded for the 2020 for the FIP, and is the vice president of the central IIP 2018. We have Dr. Ashish Jain, one of the panelists. He is always there with us for all the medical legal issues and when we have the sessions. I need somebody is having a lot of background noise. Am I hearing? Sorry for that. Who is there? That please get it switch off or keep it mute. So Dr. Ashish Jain, he is a consultant pediatrician and medical legal advisor from the Gurgaon, and he's a member for EMBLIA from last few years, and he's a very active member. And he's always there for all the conferences as a speaker for this one. Dr. Ram Gopal Sheza is from the pediatrician from Thane, and is the owner of Nipun Multispecialty Hospital. He's the immediate past president of from the Thane, and he do every monthly Maha IIP sessions under Maha IIP, Maharashtra IIP medical legal chapter, conducting the CMEs for all the pediatricians every monthly. He also has a lot of knowledge for the medical legal cases and has done almost hundreds of postmortem in his 2 years of working as a medical officer at PSC. We have with us Sheikh Minaz Ahmed. He is from the pediatric intensivist and head from the Lilavati Hospital, and is an accredited teacher and DNB teacher for the students, and also doing the postdoctoral fellowship programs at his center. He is the ex-editor of JIMLIA. With us, we also have Shripad Jagidar. He is the director for the Hope Pediatric Critical Care from Amravati, and is the organizing secretary for Mahapedicon, and has been the joint secretary for MahaIP in 2019 and treasurer of Indian Medical Legal Association from 2021. With us also Dr. Satish Tiwari sir, founder president of Indian Medical Legal Association. He needs no further introductions. We already know him very well. So let's start with my question to the panelist here. So why there is surge in the medical legal cases in pediatric intensive care unit? Dr. Ram Gopal.
As the number of kids are
it's an emotional issue with the parents, and they do have one or two kids, and they don't want to accept any untoward incident. So every case is, whenever there is a negative outcome, it is reported to the police. So that is the main reason of increasing the number of incidents.
Do you know any aggravating factors there?
I think Satish sir can answer this in
Yeah. So Dr. Shripad or Dr. Kedar, who is there? Why you think that is aggravating now?
See, basically about 2 or 3 decades back, we were seen as gods or demigods, and we were respected, and everyone had a lot of trust and faith upon us. And there was a concept of family physician at that time. Now we don't have such a system working, and probably it is because of the changing mentality of the general population at looking at how the doctors looking at the doctors. Secondly, we have general physicians, GPs in between, but their role is different from what the family physician's role was a couple of decades back. Another multiple reasons are increasing costs of the medical care, increasing awareness of the patient's right, deteriorating doctor-patient relationships for n number of reasons, whatever they are, probably inability from the patient's point of view to accept morbidity or mortality, any patient, adult or children, looking at complications as negative, looking into the complications as negligence of doctors rather than complications in any particular disease. And the increase of social media and mainstream media influencing the general population, and also there are multiple middlemen now, be it anyone, their relatives or social workers or politicians or advocates or anyone. So there are multiple people influencing the immediate relatives. Most of the times we find that the immediate relatives are very happy with the treatment or very happy with the conduct or everything, whatever is the outcome. But ultimately, they are instigated by others subsequently a few days later or later on. So there are multiple factors involving this increase in the number of medical legal cases amongst us, especially amongst the children. And with the advent of CPA, probably the overdependence of ours on the investigations and the reports rather than the clinical judgment, and probably lacking the empathy which we used to have about 3, we means all the doctors in general, 2 or 3 decades back rather than what we have now. So I think there are multiple issues which are responsible for increasing medical legal cases against.
Okay. Dr. Ramgopal, I think you are using the 2 speakers. Please mute one of that because it's getting a lot of disturbances. Yeah, so we'll make it on the. Okay. So thank Dr. Kedar for the excellent way you expressed about the aggravating factors. Let's move on here. We have something called as a destructive criticism, where almost 24% of the people, 1/4, mentions that it is a damage talk because of the way we speak about the other colleagues. That is the destructive comments or like comments involving unsolicited feedback given to other doctor in front of the patient. That causes more. So that's the surge in the medical legal cases. What are the most commonest reasons for happening in the malpractice? Dr. Shripad? Dr. Shripad is there? Dr. Ashish, will you please tell me what are the commonest reasons? Yeah, Shripad.
Yeah, there are many reasons for common reasons for medical malpractices, and what the data collected for over a period of 4 years, maybe around 10,000 cases with medical professional liability claims were considered. And this data suggests that there can be various causes, like diagnostic error is responsible for 33% of the cases. Surgical procedural problems are related to the 24% of the cases. But there are major form, but there are still other common causes like medical management, medication problem, patient safety environment, obstetric related problems, failure in the patient monitoring, anesthesia related. So there can be multiple problems. whenever we have to dealing with, probably these three could be on the top list.
Okay. Dr. Satish Tiwari, sir, are you there? Dr. Satish Tiwari?
Yes, yes, I am
Yeah.
there.
So this is your slide. Can you please describe this slide once for the all on here?
Sir, kindly unmute yourself, Dr. Satish Tiwari. Sir.
Dr. Ram Gopal, you have the noise coming from your place.
No,
Ram
I
Gopal
am
Chedraji.
alone.
There is coming continuously noise from that place.
This slide is about the present circumstances in which the medical healthcare or the medical practice is there. We all know we are in the third millennium where there is a explosion in the various newer and newer instruments or the technical gadgets. We are over dependent or we are misutilization of many of these machines, like we all know about MRI and the CT scan. And because of all these changes, we have forgot the importance of human touch or the ethical issues and the sanctity of the art of healing or the practice of medicine. But basically, we have to remember that the practice of medicine is not only science, but also the ethics. Cannot be only academics, but we have to justify the various decisions. So that is how we should practice.
So that is the very important way, like when we are seeing a lot of medical legal cases are happening more and more, one should remember about the basic facts here. Okay, so let's see, ignorance of the law. Dr. Ashish Jain, what do you think? It is a good thing, bad thing, or is it a must one should know about the legal laws?
Yes, sir, your question itself has got its own answer and the whole platform has got its own answer. So there is no way, no respite to the ignorance of law, and as it is very rightly said that ignorance of law is not an excuse. So definitely it also matters to the medical profession too. And once a case of medical negligence or anything is filed against a doctor, so definitely it has to be proved by the medical negligence committee and all. And ignorance of law has got no concern. Secondly, if at all we talk about positive fronts, earlier in the afternoon, the important case of Rajasthan was being discussed. So that stood as a perfect example to the ignorance of law. And I think we doctors nowadays, it's not only about our clinical and medical management skills. It's much more than that, and we should come out of that thinking or thought process that if we know clinically very well, then we are sound enough to practice. We should be very medically sound. We should have memberships of medical organizations like IMLEA, and definitely law. There are so many good laws. Again, as it was being there are so many good judgments of the apex court, Supreme Court, which are in favor of doctors. And if at all we know about, we have been talking about IPC's judgments. So if at all we are well aware of these judgments, then we can definitely use to our this thing. For example, police cannot arrest a doctor just like that. So definitely these we should know the judgments very well, and also it also provides a safeguard to us if at all some judgment or some we do something unreasonable by lack of this thing, if lack of knowledge or lack of skill, then there is no respite to it, and we should know that. Thank you.
Yeah. So everybody knows about the Jacob Matthew case versus the Wells State, where the judge very clearly mentions that reasonable degree of skill and knowledge to the stick to standard care and to have the standard protocols must be achieved by the particular person. So let's see about the medical legal case management. We have to know about the identifications, we should know reporting, how to do exam, how to prepare our records, and how to have our final opinion after doing the investigation treatment. So let's go back to the cases when we're doing with the ICU, pediatric ICU. A lot of cases we are getting are the medical legal cases. So which cases we should inform to the police? So Dr. Shripad or Dr. Kedar, anybody wants to know when to inform the police and what are the things which we should inform?
So there are two.
Sripad? Yes, Shripad, you can
Yes.
Yeah, Sripad, okay. Sorry for that.
Okay, there can be conditions like where we have to report, and there are conditions where we must report these reports. So there are conditions where we must report is like case of homicide, case of suicide, when there is unnatural death, suspected poison, then there can be a on-table death occur in less than 7 days of married life. All these are cases where we have to report. There is a must obligation, and there are certain cases like some accident, like road traffic accident, but patient is stable, or some poisoning has occurred, like turpentine poisoning, home organophosphorus poisoning, or undiagnosed deaths. In this condition, it is always advisable from medical legal point of view that we should report this case to the police.
Yeah, so any false smell, something is wrong, something is not usual, maybe child abuse and neglect with additional forms. So we should confirm as a pediatrician, we should know and aware of that pediatrics population is a vulnerable population. And they are getting always victimized because of the parents' angers, frustrations, and from the media sources. So always better to inform the police when you have certain types of cases with you. Okay. So what's the current status of medical negligence? Like medical cases are occurring, increasing in numbers. So Dr. Kedar, will you please follow up about this part, about the situation, what happening about medical negligence in India?
Yes, cases are definitely increasing. There is no doubt about it. The numbers may be available with Tiwari sir and other experts in the field, but cases are definitely increasing. Doctors are more and more doctors are going for the increased amount of insurance and the indemnities policies. The insurance companies are also increasing their premiums towards it. Doctors have become more defensive, and they may refuse treatment to some patients in fear of such medical legal cases or litigations. And on the other hand, some of the doctors are more aggressive on the investigational and other parts, applying less of clinical knowledge and more dependent on the evidence based or reports, or that is also causing problems. So health services overall are suffering by increasing the cost incurred on the aid. Patients are the billing is increased, and probably the next generation or younger generation looking at these issues currently increasing may probably avoid or may probably not go for the medical courses in future. So the situation may be a disservice to the community in general, but whatever it is, we have to accept it, whatever it is and happening, and we have to fight it, and we have to deal with it, and we have to handle it. So overall, I would say the current status, the number of cases are increasing. I am not saying that medical negligence is increasing. The number of cases are increasing. Okay, but doctors are more and more aware of these complications, and are more and more doctors are taking all the care to avoid these complications, and especially with the advent of NABH, probably more and more are following the paper rules very strictly.
So doctor-patient relationship is deteriorating.
Yeah.
Yes, somebody also. Okay, please go ahead. Hello. Yeah. So doctor-patient relationship is deteriorating more. The model which was like initially where you used to have the common trust among the both of them, like an individual trust and individual respect, which is getting downtrend. So we need to make here some points that doctor-patient relationship needs to go ahead, and the doctor should practice ethically. At the same time, it's a duty of the surrounding people, surrounding the around areas, to make sure that it should go in a healthy way direction rather than getting like a commercializations in this case. So as like a ordinary common patient going to suffer more if you deteriorate in the condition. So buyer-seller relationship should not happen actually here. It should always remain like a treater and healer, and the person who is getting the case is the patient. So it should remain so good for everyone.
Again, in the situation and era of consumerism, so CPA
Yeah,
2019 definitely it is going to buyer-seller kind of relationship, and since as already discussed, there have been many expectations. Patients have now more autonomous standing. They have an ability to discuss and question, as very rightly mentioned, active and passive discussions. So that's also is one of the very common causes.
So we'll go into the ICU
the
part.
moment the
Yeah,
patient, we can say consumer, and the act was applied on us, the relationship started going down, because now nobody sees as a doctor to us. That family relation has already gone down. We are the service provider. We have to maintain that standard, and the patient will see in a other way. So once anything goes negative, they are going to drag us in the court.
Yes, very true. So Dr. Ramgopal, I'm going to you actually. Can we refuse to see the patients?
Yes,
or we have to see.
No, we have, except the life-saving emergency, we have all right to refuse the patients.
Okay.
But in case of a life-saving emergency, we cannot refuse the patient.
So let me first tell me what are the refusing, where you can refuse the patients. Like you have seen some patient previously and is annoying to you and causes lot of ruckus last time. Can you straight away refuse that patient?
Yes.
Okay. Like if you're not
but
giving
again, it has to be a non-emergency issues. If there is an emergency, you cannot refuse it.
Okay. So certain reasons where doctor can refuse, they are like if doctor himself is sick, or he's attending some other patient which is in more emergency, or he has some constrained relationship with the patients, or if he's out of his professional hours, or maybe something like a consent is not given, or the patient is not cooperative, can be refused, but not in all cases, as rightly mentioned by Dr. Ramgopal. So let's see here which are these cases where we have to see in emergency. So doctor in emergency must do certain basic things. So which are those? Dr. Ramgopal, what do you think then?
See, any patient who requires the first aid, we have to give them the first aid. Then the patient who requires a basic life support, we have to provide the assistance, and then we can probably refer if we are not available or we are going out. Even in the if the patient is very sick and he requires a ventilatory support, or someone has come with a cardiac emergency, we need to attend the patient. And even if the patient, we don't have a facility, then we need to help the patient to take him to the higher centers also. So these are the basic conditions where we cannot refuse to see the patient.
Yeah, so certain things which called as like ethics and professionalism. So in that definitely it mentions any sick patient, it ought to be seen by the doctor, irrespective whether his skills are there, whether he has any instruments, whether he has the things with us available. At least some basic aid, some basic part, something can be done, and even the facilitated transfer of such patients to the higher center. So definitely there is one called as permanent Katara case. If people are aware of, or others, I will tell some brief about this case, where the accident happens and the person was denied to give help because the facilities were not available. So despite of going to the higher center, the patient succumb to the injuries happens. So finally, at that time, Rangnath Mishra ji, the sir as a justice, has mentioned very clearly, most important thing is to survive of the patient. Life is most important thing. So doctor must do certain basic things. At least he can try some basic assistance, some basic aid, facilities transfer of such patients to the higher center, so the life can be saved. The most important motive here is to save the patient's life. So that's the duty of a doctor in emergency. So let's now go to the negligence part. I want to know further relations, specifically what is the negligence, how it happens, and what are the things we should be care of. So who wants to take here?
I think Satish sir can be in a better position to explain the terminology.
So I need in details, because like I want.
That is what I suggested.
I think Dr. Ashish can take it.
Okay.
Dr. Ashish, and then we'll let Dr. Satish Tiwari sir. Yeah, Ashish.
Okay. So negligence. First of all, negligence has got 4 Ds of negligence.
Okay.
And it is defined as a breach of duty caused by the omission to do something which a reasonable, prudent man, guided by those considerations which ordinarily regulate the conduct of human affairs, would do, or doing something which a prudent and reasonable man would not do. So herein it comes, you have to have that necessary skill, a reasonable skill, and there has to be a breach in duty. That is the most important component, and it could be either an act of omission or act of commission. So act of omission means you have left you have, this thing you have not done a particular this thing you have not
Particular
provided
job which you
care.
are supposed to do. Yes.
Yes, which you are supposed to do, and commission means you have committed some mistake deliberately or unknowingly, but that has led to some damage to the patient.
Yeah. So anyway, I will take that liberty to give some examples here. There is a one case where has Meenakshi Hospital versus Samuraji case taken from the one of the lectures from the Tiwari sir's lectures, where anesthesia was given to the patient at around 10 a.m. and child become pulseless around say 10:30 a.m. So two anesthetists were there who recorded the statement and papers, and the judge observed that why there are two statements and there are different statements to different papers written and by two different anesthetists. And there was no mention about the particular things about the two cases, two operation, two notes. So there is something definitely was the false play was suspected and the negligence was proved, because we cannot have the two papers from the two different anesthetists at two different timings and which was not matching with each others. One more case against the Apollo Hospital where the MC Act, which mentions about the doctor must mention particular types of records. That records must includes pre-op, post-op, and all the details about the precautions to be taken. So discharge summary shall not be just a mechanical, but it should be the patient friendly. Dr. Tiwari sir, are you there?
Yes.
Yeah, so please go ahead with this couple of two cases. You are very friendly about these cases. So please, I will want you to discuss about these cases.
I think the previous one you can.
Okay, I will go back. Yes, sir.
Dr. Anurag Pangrikar has very well taken how the discharge card should be there, and there were expert comments from also from Dr. Baldava sir in that case. One of the important things which we should follow regarding the discharge summary, that it should not be mechanical but patient friendly. So as Dr. Anurag Pangrikar has said, you have to document almost everything, what was the diagnosis, what was the differential diagnosis, and which treatment was given, which treatment has to be continued. And the patient-friendly discharge card means he should be able to know all the things which he has to do in the future. So that is very important. Like if suppose we are discharging a case of premature baby, then you should always write that he has to go for ROP screening and screening for the hearing, screening for the vision, screening for some of the important developmental milestones. Because if you do not write and patient may not follow those things, he does not go for the ROP screening. And suddenly after 4 or 5 months or 6 months, the relatives come to know that the child has become blind because of the ROP. So then it becomes a clear-cut negligence. Many times maybe a case of res ipsa loquitur. But if you have advised ROP screening every month or as per the recommendation, then of course, if the ROP develops, he has to take the treatment and it will not be the breach of duty. So that is why a proper discharge card, which is patient-friendly, will not be a part of breach of duty. So that is very important.
Okay. So we'll go back to the next case if I have. So that's Tagar Hospital versus Harnam Singh case, which was mentioning the child was admitted with a high-grade fever off and on from last 20 days. And finally, child deteriorating condition is put in the ICU. But then the X-ray and echo reports, which was mentioned, it was not very correlating. And despite of having gross hypoxia, ABGs were not done. And the child subsequently not put on ventilator, died subsequently, was discharged.
Samir, again, I think this is a very important case.
Yeah.
And this says, though it is a old case, now we are having new generation, this new judgment also. This is 2008 National Commission judgment, where the things were not properly documented, that if the why ABG was not done or why the child was not put on ventilator. I think now we are getting the cases where the judgments are going against the hospital for not having a surgical ICU in case of a medical treatment. So if we feel that there can be possibility of some complication which cannot be managed by routine care, then the ICU facilities should be available. The another thing, the new judgments which say that you should practice according to the availability of the services at your place. So if you are practicing for critical care, the ABG should be available. If you are practicing for some surgical ICU should be there. And then of course the ventilators and all, we are now getting many cases that if you are admitting a serious patient, why the ventilator services are not available. So that is very important. The equipment, the instrument, the facilities should be as per your scope of the practice.
Even, sir, I would like to add to it. Now the situation is more grim, and we have this recent judgment of, I think, Karnataka High Court, wherein an obstetrician and even if a delivery is being conducted or a cesarean is being conducted at a normal nursing home, then also the court expects them to have a ventilator facility, and the judgment has gone against the hospital again.
Yeah, that was very recently. I heard about that case where the 3 doctors were held responsible after the death of the patient, and the reason was given that there was no availability of the ventilator.
But there has been, yes, in that case, actually, it has also been proved that there have been gross negligence and gross discrepancies in the doctor's notes. The 2 primary doctors of the same hospital and the other doctor to whom the case was referred, wherein the patient was actually dead before by being really declared by them. But yes, the court also took to cognizance the unavailability of the ventilator and all those other facilities.
Okay.
I have one question for Satish sir, please. Sir, do we require an NICU even if the gynec is conducting a delivery where the pediatrician is called? And what about the facilities if they don't have an adequate? Are we responsible for that?
No, NICU may not be there in each and every obstetric hospital or each and every pediatrician. Only thing is, if you are attending the deliveries, then you should be qualified enough or experienced enough in managing the neonate. And of course, if you are doing a pediatric practice, it is not must that you should have a DM neonatology in each and every case. A MD pediatrics or a DCH or a DNB in pediatrics can see the neonate, and whenever there is some problem or if you feel that it is not possible to manage in your setup, then there should be timely referral of the newborn to a proper NICU. So that is important. It is not important that everybody should have a well-established NICU.
Sir, it is not important, but considering the recent judgments, I think the situation is so bad that it's such a gray area wherein the judgments would come against this also. That why was the delivery conducted in a setting wherein a NICU was not available?
Exactly, that was my point.
So that is a gray area, and definitely we are all to the mercy of the judiciary only. Maybe we could be proven good later on, but yes, because the situation is something like that, the patients are too much expecting, and anybody can go in the court. It depends on the judges, this thing, as far as the judgments are concerned.
So that is what we are saying. If you suspect that the child cannot be managed at your place, like 30 weeks or 32 weeks child or 1.2 or 1.4 kg, then he should be immediately referred to a well-established NICU rather than managing at your own place.
Okay. So Dr. Shripad, will go to the next question here. What is vicarious liability? What do you think that it is an important part or not important part as a considering the doctor in the
it's
ICU?
very important part. Vicarious liability deals with the cases where one person is liable for the act of other. That means even if some in-charge doctor has not done a mistake or some problem is not occurred because of the in-charge doctor, but problem has occurred because of some wrong decision taken or wrong medicine administered because of the nursing staff or resident doctors or paramedical workers. Even doctor is not directly responsible, but treating doctor is indirectly responsible for that act. So seniors and in charges, they are not directly dealing with the patients or complication of that matter, but because the complication has occurred to the some person who is related to the hospital, they are responsible and they can be charged for the vicarious liability.
Yeah. So
When
vicarious
the
liability can be for both doctors as well as on the hospital.
yes,
Yes.
and the whole team also. The message is very clear. Those who are attending, even the medical colleges, the PGs, the whole team, the whole unit could be taken to a vicarious liability task, not only in the hospital setting. So it is applicable to everyone.
Even in Thane, the recent case, the gynecologist had left a mob, but in that scene also anesthetist, nurses, and even the pediatrician has been prosecuted.
So
yeah, because everybody was around, so their judgment, how they speak, it takes into consideration. So take home message here will be: do not employ unqualified staff. That is most important thing. Verify
One more, Samir, one more question. See,
Yeah.
if during a seizure something goes wrong, how is a pediatrician responsible for a gynec outcome or a surgical outcome? That's I want to know that on this
It
case.
should be proved, sir. It should be proved. Definitely, yes. I do
It is
relate.
just the case file. It's not the judgment comes back. So
No, but it has
possibility.
happened in the past also. Even in Thane Vartak Nagar cases, the pediatrician was held responsible and he was arrested for 5 days. He was in jail for a cesarean death. So, Satish sir, you
Dr.
are.
Ram Gopal, what we discuss in such cases or in such decision, that this decision were not properly defended in the court of law.
Okay.
So you have to explain that the pediatrician is not responsible for the mistake of obstetrician or for the mistake of the anesthetist. But what happens many times, we ourselves say that why, if there is any case, we should not have infighting amongst ourselves and we should defend it together. But in this case, probably because if the pediatrician says that I am not responsible and the obstetrician and anesthetist is responsible, so then it becomes that you are giving expert opinion or something like that, that there has been mistake on the part of obstetrician or the anesthetist. I totally agree that this is a wrong decision to the extent that if it is a mop left inside the abdomen or the inside the uterus, is basically the mistake of either the nursing staff or the obstetrician who should count. Even the anesthetist should not be held liable in this. So I think it is our way of defending that how to defend in the court of law, and that's why we repeatedly say that while defending any case, not only an advocate but a medical legal consultant should be taken into for help.
Okay. So we'll go to the next point here. Let me go ahead about the consent. So Dr. Kedar, are you there?
Yeah.
So please tell me about something about consent in ICU related things.
Okay.
What is consent?
In general is an approval or an agreement between patient and the doctor after thoughtful understanding of everything. That is what consent is looked at. But unfortunately, doctors look upon it as a possible defense against liabilities, but that is not so. Probably there are too many aspects of any litigation, the acts of omission, acts of commission, and the extent of the probably the damage or whatever it is. So, and there are several litigations in which several judgments in which there was an adverse comment on consent by hospital authorities or the doctors. So consent is a very important aspect of any paperwork or to avoid any complications, legal complications, medical legal. Now, as the slide projected, there are n number of types of consents. The most commonly we get into is the informed consent. Now, informed consent is very specific. The wordings are probably the voluntary acceptance on patients or relatives after full understanding by the competent patient. Competent means he should be mentally a competent patient in cases of adults, or in cases of children, there is the other surrogate consent. Okay, of a plan of a medical care after the treating doctor adequately discloses or explains the proposed plan, its benefits, its risks, and in addition to this, alternative approaches, alternative treatment approaches. If everything is explained properly and then the patient signs, then that is probably called as an informed consent after the proper understanding of the patient. That will include in their own vernacular language or the language which the patient understands and everything. Okay, so there are basically 3 or 4 components of this consent. First, the mental capacity of the patient or the relatives. Second, the provision of information by the hospital authorities or the doctor. Third, the voluntary acceptance from the patient by the patient, or in cases of pediatrics, the relatives. And the whole consent should be person or the patient specific and the procedure specific. It should not be a vague or a general consent. Okay, so these are the points which must be included in any consent.
So Dr.
Now,
Ramgopal, I want to ask you what's a valid consent will be. Like suppose sir has mentioned about the consent part, but is there anything particularly about the valid consent?
Valid consent means the patient, as sir said, it has to be an informed consent. And when we say it is an informed, so we have to take in writing. In writing means we have to, he should know the language in which we explain to the patient. And probably we tell the patient only to write the consent so that he tomorrow he should not refuse it. See, just a simple printed form, taking signature on that doesn't give you the rights that yes, you are 100% right. So it has to be a procedure specific and case specific consent.
Okay.
Yeah.
So like because there was judgment mentioning that just taking on the blank paper or just taking on the printed format, we should not use such type of consent because it is not a value. Just taking.
That is what exactly I told you.
Yeah,
that was the National Consumer Forum's judgment in 2020, July 2020, which said that pre-printed forms and these are not actually applicable. So it has to be case specific, definitely, yes.
But like suppose in case of emergency, which we have no time, can we take at least a blanket consent and then take additional consent?
No,
like because
if
we
you don't have that. See, any emergency doesn't require a consent. First of all.
May I add?
Sir, sir, just any emergency doesn't require a consent. In emergency, the rule of consent is override. So anyway, and if there is no emergency, then you need to spend some time to the relative and take the consent.
Suppose parents are not giving consent. Dr. Mahesh Baldova, sir. Yes.
Sir, that pre-printed consent form that has been stayed by the Supreme Court. That is not the law. Second thing, informed consent is not the law in India. It's a real consent. What you write on the paper, as Dr. Ramgopal is telling, what is written, it should be specific.
Yes.
That why you are doing diagnostic or this. And for emergency, you don't require a consent. I agree with him.
Okay. So Dr. Ramgopal, suppose somebody is not giving the consent, what is you can do then in such cases? Like suppose
again,
negative
I
consent.
told, in any emergency, you don't require a consent. If there is a life-saving situation, even the court says the life is most important. So that is not dependent on the consent. Yes, but other elective procedure, you can refer to the patient to the higher center or any other appropriate center if the relatives don't agree. You cannot proceed without the consent of the relative.
Okay.
Yeah.
So let's say informed consent, what we need to mention about, it should be comprehensible. It must be in the non-medical terms because we are giving consent, taking consent from the patient, and patient may not be knowing the medical facts. It should be preferably, as mentioned by Dr. Ramgopal, should be in the local language, the language which speak by the parents. It should mention diagnosis, it should mention the nature of treatment, risk involved, prospectus of the success, prognosis if not procedure is performed. Like suppose you don't do certain test or certain procedure, what will happen? So informed consent should mention all this. Also, it should mention alternative method. Like suppose somebody don't want to do lumbar puncture, we are strongly suspecting meningitis. So if he's not giving consent, So we should also mention if he's not giving consent, then it will not be performed. But in that case, we might to go for 21 days of antibiotics. That is alternative, but it may not be the correct because it may not be ideal. If it is not meningitis, I will not give for 21 days antibiotic. So it's actually the you are suffering rather than doing. So best thing you should also mention if you have done previously particular procedure, better to mention that out of 20 procedures I have done, in 18 I succeeded, in 1 or 2 cases I did not succeeded, or some complication occurs. It is better to give rather than giving the data of the international. Better to give your own hospital data or your own procedure data and tell in front of the persons and relatives that yes, this is my data from last 3 years, which in our hospital we done, which mentions that out of 30 lumbar puncture I done, 28 I was successful. So parents will also feel happy. Okay, something is there, his data is there. But in 2 cases it's not possible. So let it be. So informed consent.
I don't agree on this because if the relative doesn't give the consent and we give the antibiotic for 21 days, how do we know whether it is a pyogenic meningitis or it is a viral?
Yeah, that's true. So we have to mention about that part.
The patient, don't take that blame on you. Tomorrow it may turn out something different and the patient succumbs. Then you have to face the court of law and you have to prove that you are not negligent. So rather than going for all these legal hassles, we can always refuse the treatment of the patient.
Exactly.
And Dr. Ramgopal, once you have admitted the patient, you cannot refuse the further treatment.
Transfer the patient if the relatives are
either
not.
You have to refer him, you have to convince him that you are not.
We can refer the patient.
Yeah.
Yeah. So refer the patient if you are not agree or if the patient is not agree. So it should be always be mutual agreement between the 2 people. That's very important when we're talking about the informed consent. It must be mentioned clearly, neatly, has to be signed by both, by the patient party as well as by the doctor. We'll go to the next part here.
Dr. Samir, before we go to the next slide.
Yes, sir.
One thing which I would like to suggest here, especially if we are discussing consent in a critical care, NICU or PICU or whatever surgical ICU is there, I think if the patient is critical and not responding or responding slow to the treatment, a single consent at the time of admission may not be sufficient.
Okay.
So there is no law which says how many times you should take consent. But nowadays we are suggesting that if the patient is critical, then at least once in a day or if there is some new symptom or sign appearing, or if you suggest some new investigation, as we are discussing, if you are doing lumbar puncture or if you want to do MRI or CT scan, then this thing should be explained to the patient and a fresh consent can be taken at least at the time of development of new signs and symptoms or when you advise new investigation.
Exactly.
What about the documents? How we should prove, what we should store, where we should store it, and how for how many days? Who wants to? Dr. Ashish.
Okay, so documents are the keystone for any case or a medical negligence, suspected medical negligence case, and proper documentation forms a bridge of proper case, and there should be no leniency acquired or adopted by any doctor in preserving the documents and documenting all the situations. Then as far as the maintenance of the records is concerned, so first and foremost, the documents are the property of the hospital, but yes, if at all the patient demands it, then it has to be provided to the patient party within 72 hours of being demanded. Then there should be no corrections or manipulations, and it is actually the confident thing of the patient, and it has to be released with this consent only, or until unless there has been a proper notice from the court itself, then only it could be released. And or if at all a patient sends a representative, duly attested representative, then only it can be after confirming his representation. It should be clean, correct, and complete, and definitely maintained in a chronological order, comprehensive. One more thing I would like to add to the documentation as far as IPD and PICU or ICU notes are concerned is it should be in clear, eligible handwriting. If you have visited a patient 10 number of times, then you should document your notes 10 number of times with proper date, time of this thing, your name newly signed and your proper advice and suggestions. Then you should also cross check with the nursing staff about implementation and dispensing of the medicines as such. As far as recording of the documents is concerned, for OPD storage, OPD documents, a good reasonable period is 3 years, whereas for indoors, definitely it has to be 5 years and even longer if at all the time permit, if at all the situation permits. For example, in MLC cases, it preferably for a lifelong or even they say till the MLC case is being dissolved. Then in case of pediatrics, it is said so that it should be 18 years plus the age of the child otherwise, because once he becomes a mature, then again the child can ask, suppose he's a newborn and so it should be preserved at least for 18 plus 3 years if it all it is a suspected case or any, because that newborn once it becomes an adult might take you to the court. Definitely.
So just
Sir,
recently,
we are running out of time, sir. It's already 4, so last 5 minutes maximum.
No, can I, what is the
Sure, sir,
source
please,
of
please.
OPD?
yeah. So this is still has been debatable, and just I remember, though day before yesterday, Dr. J.K. Gupta, he actually asked under the rights of
He
consummation.
has received from the National Medical.
Yeah, so I'm going to that one. Yeah.
Yes.
So when he asked for, he received the details. It mentions for surprisingly for outdoor there is no record needed, and for the hospital admission, keeping the records for 3 years, which is as in mentioned.
No,
in the
all
National Medical
records 3 years, all records 3 years, these 5 years and 15 years, I don't know from where it is coming.
It's come from the National Medical Commission, where he actually asked for documents.
No. On your slide, 3 years, 5 years, 15 years.
Yeah.
3 years is agreed for the indoor case papers. But this 5 years and 15 years, how, from where have you received?
No, sir, I'm just
asking. 5 years is a good period to keep a record. It's a good
period is lifetime. Good period has no meaning.
Yeah, good period is
Good
lifetime. That
period
is
is lifetime.
particularly
Good
for the
period
death
is
and
lifetime.
MLC cases, we should keep
Till
record
the death, till the death of the pediatrician. It should be indefinite.
Yeah,
till the
okay. So I'll
death
just
of the
correct that part. Yeah, so ideal will be
But
to
this
keep
5
it
and
as much
15, I don't know. Even
No, I agree with
even
that
in
part.
the-
We can change that one. So take home message will be you need to at least for 3 years for indoor as well as for OPD patients, but for MLC you keep it for the longer duration. And we still don't know for the PIC patient how much time to keep the records, because next time tomorrow might come with a child who can say I want to take my own decision, and it is like a 18 plus 3 years what was mentioned by Dr. Ashish. But again, this is not proven. This is still the gray area unless we have some decisions coming out. Till the time we are not sure what to be done. We'll go to the next part about the death of the patient in the ICU. What should we do?
We are running out of time.
We started 5 minutes before late. So can we have additional if
Okay.
permission from the
Sure, sir.
audience? Okay, thank you.
All right.
So Dr. Sripath, what do you
Yes.
do in the death of patients? Do and don'ts. What you will do?
Yeah, the
particularly
death of the patient is always shocking for the doctor as well as the relatives. So relative may respond differently. Some may become very aggressive. Some may want immediate action. Some may ask the police action to be involved, political person or media person. So again, there are simple rules for doctors that one has to be very confident. Body language should be very positive. One should not shout or one should not talk in a loud voice and to give the orders. Secondly, important is check everything, all the records and documents has been done properly before you declare the death of the patient. And again, talk to your resident doctor or nurses so that everybody will have got the same version. Whenever the relative want to talk to nurses or other junior doctor, they should have got the same version. You can show your empathy or you can show the sorrow to the relatives, but that should be in a professional way. Don't be too emotional, and always see that there is if there is some aggressive behavior from the parents, one has to have backup, and this thing can be avoided by proper counseling of the relatives.
Okay, so we'll not go to the further how to inform relatives. That is a personal skills, but definitely I need to ask about how to severe. Hello. Yeah. So what are the seviers? Like what will help you? So definitely remember here few things which are required. and that I can call it like a savior. So document all the things, know your limitations, anticipate certain things, introspect yourself. Like certain things happens, like why some adverse events or some death or something related to the not requiring like a unnatural thing what has happened, possibility of, keep in mind everything has to be possible, and that introspect yourself, communicate very clearly, and follow your ethics. So all these 6 parts will help you to defend your case, to survive in the current era, and to help our kids. That is most important thing. Our ethics mentions us very clearly that we are working in the ICU, and our first motive aim is here to survive and make the comfortable care for our ICU patients. And we should not afraid every time about the legal matters and legal things. Yes, you must be aware of ignorance is not the bliss, but at the same time, we should be bind ourselves with these 6 principles, and it will help you in the future. So thanks everyone for participating for today's discussion. We still have a lot of things here like end of life care, withdrawing of the support, organ transplant, but in view of the time constraint, we will take another session maybe in the future part. So stick with our Maharashtra chapter of Medical Legal and Ethics Board, which is started today, and I'm very thankful to the organizer team, and also give best wishes to Dr. Satish Agrawal sir and to the Dr. Hemant Gangolia sir for accepting as a president and founder secretary for this chapter. Thanks to everyone. And back to our Dr. Nidhi Yadav madam. Thank you for you also.
Thank you. Thank you.
Thank you. Thank you, Samir sir. Thank you all the panelists for giving us an insight on various medical legal issues in this session, and enriching our knowledge in law and medicine and its interface. And I think, in my opinion, we had an amazing discussion on various issues, and which included spectrum of perspectives and thoughts and knowledge in the field of medicine and law. To sum up the session, I would just throw in some bullet points which we discussed in past, 1 hour, almost an hour. We discussed how the pediatric population is a vulnerable population, and various reasons have been discussed for the surge in the medical legal cases, from which unsolicited criticism was one of the reasons. So practice of a doctor has to be ethical, as said by Dr. Satish sir, and various decisions. The doctors to know various laws and its implications in their practice, and we all how important it is to inform police, and which cases are the must cases that we should be informing police. And there should be a doctor-patient relationship. And there has been a discussion about doctor cannot an emergency, and there are some circumstances. We have discussed discharge summaries in length during this entire CME, and one quote and unquote what I really like is, don't promise what is not available. And I think this also hits the vicarious liability as well when we talk about individually and as well as from the hospital's perspective. We have to understand vicarious liability, because many of us own hospitals as well, when we are also the founders of those hospitals, and we are practicing as doctors in these hospitals. And the importance of consent cannot be underlined. It is very significant, and we have to understand that blanket consent are to be avoided, and informed in real time consent should be taken as by Dr. Baldeva in details, and it has to be preferably in patient and handwriting or next to kin handwriting. And we have discussed documentation, experience, and preservations, and how important it is legally for us. So all the best wishes to all the doctors here, and thank you for this great session. We had an amazing discussion, and the CME was amazing, and congratulations to all the organizers. Thank you so much, sir.
Thank you everyone for time listening.
Now, since we don't have Mr. Nagarkar sir with us, so before we go for the formal vote of thanks by Secretary of Amravati, Dr. Sushil Raju sir, On my behalf, I thank all the panelists, all the speakers, delegates, and the over to Dr. Sushil Rajput, sir.
Unmute yourself.
Good afternoon, everyone. Thank you for meeting the decorum of the CME, and time management was very fine. I, Dr. Sushil Rajput, Secretary of the IIP Amravati, on behalf of IIP Amravati. First of all, I congratulate dynamic and super active personality Dr. Satish Agrawal sir for being elected as a president of IMLEA Maharashtra, and also congratulate academician Dr. Hemant Gangolia sir for being as a secretary of the IMLEA Maharashtra. We thanks to the installing officer, medical legal expert, our patron, and one of my guru, Dr. Satish Tiwari sir, for installing the new team. We thanks to the National IMLEA President Dr. Mukul Tiwari sir and National Secretary IMLEA Dr. Anurag Verma sir for gracing the occasion. We also congratulate and thanks to rest the team, Treasurer Dr. Nagalkar sir, Vice President Dr. Dinesh Thakre sir, Dr. Jayan Shah sir, Dr. Milin Shah sir, Dr. Sudesh Doshi sir, Sugandhi Ayar ma'am, and all executive members, Dr. Anurag sir, Dr. Gauri ma'am, Dr. Jaipuria sir, Dr. Manish sir, Dr. Radhesham Arora sir. We thanks to all the chairperson, Dr. Sihori sir, Dr. Anurag sir, Dr. Saini sir, Agnihotri sir, Dr. Nidhi Yadav ma'am, Dr. Rajesh sir, Dr. Ravi Shankar sir for chairing the session. We thanks to all the speakers, Dr. Tiwari sir, PN Tiwari sir, Dr. Mahesh Baldeva sir, Dr. Rohini Deshpande ma'am, Dr. Malkama Mirza from Ethiopia, international speaker, Dr. Alka Mukherjee ma'am, Dr. Sudesh Doshi sir, Dr. Mukul Tiwari sir, Anurag sir, Kedar sir, Minat Sheikh sir, Ashish Jain sir, Dr. Shipat Jagirda sir, Dr. Ram Gopal Chijara sir, and Dr. Samir Sadawarte sir, who spoke to the point and perfection in medical legal law. We thanks to Mr. Prakash for handling the backstage. We thanks to all the audiences for attending the session very patiently. If by mistake I have left anyone's name, please don't mind. We thanks to you also. With everyone's permission, we end this session, which was moderated very beautifully and timely. Thank you, everyone, and have enjoy your tea with your family. Have a super Sunday. Thank you.
Thank you, Dr. Sushil sir. And Prakash, now we can mute out the recording so that we can have